Lordship's kindly.
Only 2:30 matters.
Only 2:30 minutes.
Huh?
2:30 minutes.
What is the urgency?
The urgency, my lords, is that the matter stands posted tomorrow for judgment, one part. I received the copy on Friday. This is a matter wherein the plaintiff is not permitted to engage a counsel. His earlier counsel refuses to appear and conduct the proceedings. And the court has proceeded with the thing that no cross-examination, no arguments, and
No,
proceeded to
from
judgment.
when this is happening?
Last 3 months, my lords. We
Then
have
why
made-
why were
we
you
could
waiting
not
till
get the
now?
copy. I could get the last copy only on Friday. That was my biggest challenge. It's a very sad state, but unfortunately, a proceeding in suit is going on without plaintiff being represented by counsel for last 3 to 4 months. It's a very sad statement. And we have made affidavits, we have made applications, representations that permit me. Then the judge says that he would say that I will look into whether it can be referred to DLSC. Very sad statement. Unfortunately, I had to move
The
the
office
court. Otherwise, I
objection
would
has
not
to be
have.
complied, otherwise it will not come.
We'll ensure
All the
that
office objections have to be
2:30
complied.
I'll ensure that it's.
But the common order was passed.
Is it at 2:30?
Yes, ma'am, 2:30. The two matters have been posted today at serial number 44 and 47. The other connected matter, I am
Yes.
requesting.
Yes. No, but the mentionings are for the councils on record, not for the senior council.
There was some difficulties that the list is listed separately. And 4 times the matter was posted.
We'll see, let the council on record mention. I'm sorry to say this.
Only thing is, let it be posted first list.
No. Let the council on record mention because I can't take an exception. It has been the,
Yeah, she in fact.
let us say, what is it?
The matter was listed for 4 times, my lord, in the list too. It was not reached, my lord. There is an urgency in the matter. Kindly-
Why should it be listed in list 1?
There is an urgency.
What is urgency? Which year is the writ petition?
My lord, we have the same.
Which year is the writ petition? Huh?
26, my
Huh.
lord. For the respondent, my lord, they have the interim order of status quo.
That's the whole problem. There are interim orders from 23. Every interim order I can't vacate. Yes.
Lord,
Matters come for attachment.
connected matters are posted today.
Yes, it will be taken
Yes.
up.
Matters come for attachment. My trial court was posted for tomorrow.
Huh?
Matters come for attachment of the property. Ma'am. It is posted for tomorrow. That is urgency, ma'am.
When is the writ petition filed?
15th,
Huh?
15th of this month.
It was never listed.
It is not listed. Ma'am.
Why? Because you have not compared with the office objection, it has not come in the list. Why should we give a special treatment to that? If you compare with the office objections, it will
I
come.
will comply tomorrow.
You compare, it will come tomorrow. I don't have to give a memo for that. Yes.
My lords.
13 rule 1 and 2 application
Huh?
has been, 13 rule 1 and 2 application has been filed, my lord. Emergent notice has been issued, no order has been passed, my lord.
Is it a fresh matter?
It's first.
If it is a fresh matter, why are you mentioning?
My lords, it is urgency is that, my lords, they are.
No urgency at all. It will come. You file it, it will come. Yes. Call the list.
My lords, list to serial number 1, my lords. The matter has been posted for final arguments tomorrow. So kindly have it at 2:30, my lords.
Serial number 39 in the list.
Much obliged, my lords.
May I request it to be taken up end of the list, my lords?
Why?
My lords, there is some urgency in the matter, my lords.
There can't be some urgency. There will be a specific urgency.
Please,
What
my
is it?
lords, what has happened is a 6 rule 17 application has been filed by the counterclaim defendant. That was challenged before this honorable court, my lords. This honorable court has stated the lease period of the tenant has been expired in the last May itself, my lords.
Vacate petitions, I will not take up out of turn. Whenever the matter reaches, it will reach because there are 6,000 vacate stays that are
I
granted.
understand your
Yes.
lords, but
List number 1, serial number 21, my lord. This week, my lord, is inconvenience of senior, my lord. This week, any date, my lord. Serial number.
Don't
20.
worry, adjournment, it will happen when if at all it reaches. It won't reach today. Yes.
My
Call
lord,
the
serial
numbers.
number 54, my lord.
Huh?
Serial number 54, my lord. It's connected with one MFA, my lord.
50
4, my lord. Connected with MFA by order dated.
in serial number, which list?
54, my lord. List 1. Yes.
I'm appearing for a respondent, Your Honor. Nam copy servagilla.
No, if it is connected with an MF, I have to look at the file, whether this has to go or this can be independently decided.
Yes, my lord.
So you have to wait till the matter reaches.
Serial
Yes.
number, list number 1, serial number 7.
Please don't mention the matters. Will you please wait till the matter reaches? Let's call the list.
Number 1, for pronouncement
Your lords-
of order,
Your
serial number
lords,
1, M.
your-
Sidmalappa,
Your
Yes.
lords, I apologize.
I appear for the respondent.
petition is dismissed.
Serial number 2.
Appearing for respondent.
That petition is dismissed.
Serial number 3.
I appear for the respondent.
That petition is allowed. The order dated 15/12/2025 passed by the respondent deputy commissioner is set aside. The respondent deputy commissioner is directed to consider objections of the petitioner in the light of the allegations made by her and shall pass appropriate orders within a period of 3 days from the date of receipt of the copy of the order. Till such time, the interim order granted in this writ petition shall be enforced.
Serial number 4. Devaraju HV.
I appear for the petition.
I appear for respondent number 3.
This court do not find any reasons to interfere with the order passed by the trial court. It is clarified that the impleading respondent shall participate in the proceedings only as an intervener in support of the municipal proceedings impugned in the suit and shall not be entitled to enlarge the scope of the litigation or to claim any independent relief.
So great.
Serial number 5. Prakash Raghi.
For the petition.
The impugned order is set aside. The matter is remanded back to the trial court on the question of court fee, and the court shall consider all the aspects as discussed by this court in the preceding paragraphs. Accordingly, writ petition is allowed.
Serial number 6. Dr. Padmavati.
Order impugned is set aside. The matter is remanded back to the commercial court for consideration. Commercial court shall reconsider the application in the light of section 15 of the Commercial Courts Act. The stage at which the suit came to be transferred, the earlier orders before transfer, and particularly with regard to the recall of the earlier order passed.
Serial number 7. Sudhadi.
Appearing for the respondent number 3.
Writ petition is dismissed.
Serial number 8. A.M. Vijay.
The order impugned is set aside. Writ petition is allowed. It is clarified that the impediment of the transferee does not amount to recognition of any independent or superior right in his favor. He shall remain bound by the every consequences flowing from section 52 of the Transfer of Property Act and shall prosecute or defend the proceeding only to the extent permissible to the original defendant to whom he claims right to the property.
Serial number 9. Preliminary in Bigu Parve Somsekaraya.
Yes, Mr. Somshekhara, being an officer of the court, are you not supposed to be fair to the court?
Yes, my lord.
When did you have the interim order? Please tell the court.
My lord, your lordship can attend to. The interim order was passed.
When is interim order passed?
My lord, further proceedings were stayed way back in the year 2025, my lord. That is on 36/25, my lord.
What is 36 order?
Interim order operation is extended till next date of hearing.
Interim order that is granted is extended till the next date of
Yes,
hearing.
ma'am.
When is it granted? And you seek extension of this order. When with by mistake or by oversight, when the court observes that order earlier granted is extended, when the interim order is never granted, when it is clarified by the court officer to you, you still insist for an interim order.
My lord, interim order was granted, my lord, by, I think it is after hearing the.
I think it is unfair. It's unfair what submissions you are
Please, my
making.
lord, I'm correcting myself, my lord. My lord, here the matter is that, my lord,
I will not hear this matter now. This matter, no interim order. I'll clarify that.
Petition itself is infectious, my lord. Executing court has already closed the execution petition.
Show that.
but I'm filing application for seeking amendment of that, closing the execution.
Whatever you want to do, you do. There is no interim order granted by the court. By mistake, in one of the orders, it is mentioned as the interim order earlier granted is extended. In fact, there is no interim order granted in this case. Yes, list this matter in the month of September.
Till number 10, for orders matter.
Close, my lord. It is
Then counsel for the respondent submits that the EP is
Copy of
closed.
the trial
Till
court.
number 10,
That's what I'm filing along with amendment.
Yes, next.
Krishnamurthy.
I appear for the petitioner, my lord. The matter has been decreed and disposed in the trial court. It may be.
A memo is filed stating that the trial court has already adjudicated the matter and passed the final orders in OS number 2804 of 2020. Hence, nothing survives for consideration in this writ petition. Accordingly, memo is taken on record, dismissed as infractions. Yes, next.
Till number 11,
Yes, memo for withdrawal. It's not there. Let's look at the fact. Get it by afternoon.
till number 12, Till number
Petitioner,
12.
my lords, the petition has become infructuous, my lords. I have filed the memo of withdrawal. My lords.
What did you say? The suit is disposed of?
My lords, the auction date, the auction fixed on that date, it did not happen, my
A
lords.
memo is filed stating that the writ petition has become infructuous. Memo is taken on record and dismissed as infructuous.
Till number 13, for preliminary hearing. Navya, L for petitioner.
Yes.
My lordship, trial court judge has rejected the compromise petition dated 7/4/2025. The parties, petitioner and respondent, have amicably settled the dispute and they have jointly filed a compromise petition in front of trial court judge. But judge has.
You know, it's a 2025 petition, notice to the respondents.
My lordship, kindly remand the matter to the trial
But
court.
without respondents' presence, how can we do it? Yes, 14.
14, Mohan Kumar.
Petitioner, my lord.
Yes.
The application filed by the respondent number 9 for implement into the FDP proceedings has been allowed by the trial court, though she is not proper and necessary parties to the FDP.
Who is the applicant?
Who
filed the implete petition?
The respondent number 9 hearing.
Who is she? I'm asking.
She is claiming that she is the adopted daughter of respondent number 8. She filed the impleading application. The respondent number 8 herself executed the release due during the proceedings of OS, and she released her right in favor of these petitioners.
You know, that has to be decided by the court.
Let-
By the threshold, how can the court?
Nowhere during the proceedings of suit, she stated that respondent number 8, she is having one adopted daughter. She claiming that she is the only legal.
No, that is all the more reason that the implication has to be allowed, because it has to be heard and decided.
Well, now in the FDP proceedings, by colluding with the said impleading applicant, the respondent number 8 is playing this drama by creating one, the respondent number 9 as her adopted daughter,
No,
without producing any documents.
That's what the court will decide. It will say that without granting adjournments, let that be done.
What, Miller, for executing the release deed, we paid an amount to the respondent number 8. Now, at the time of getting the fruits from the final decree, she created this fictitious person as her
Yes,
adopted daughter. That's
Notice
what.
to the respondent.
Kindly stay the impugned proceedings there.
I am inclined to dismiss it. You are saying I'm granting notice, no stay. Yes.
Because in the FDP, they're already.
Notice to the respondents and petition is permitted, take out hand summons on the counsel appearing for the respondent. Once a memo is filed, it's a matter.
Much.
It's there. She seeks liberty with the same cause of action. List this matter tomorrow. Yes.
Till number 15, I'm appearing for petitioner, madam. Challenging the,
Why the court is moved?
it is urgency in the 39, 1 and 2, dismissed by the first appellate court and OS trial court also, madam.
You filed this on 8/1/2026
Yes, 2020.
and 2026,
Yes,
8/1/2026.
Facts of the case is the plaintiff.
Till 6/4/2026, you don't even comply with the office objectives.
Complaint.
What I request advocates is just like that, don't ask for the court memo without a reason. And you wait for months together and suddenly one fine day you realize that it is urgent.
So several times I moved the application.
No, before that, for 5 months you are keeping quiet.
No, my lord. For office subjects complaints.
That's what office objections you complied after 5 months.
Please.
Yes.
Suit for declaration and permanent injunction filed by the petitioners of plaintiff here. No?
Yes.
And they moved an application under 13(1) and 2. The trial court, without ascertaining the.
Both the courts are concurrently held.
Both. Even in this case, the plaintiff's father, Ramaya alias Chinna Ramaya, was the absolute owner of the property. He granted the property through under re-grant rules. Grant records also produced. Now the defendant number 5 to 7, they're using the names of similarities in the names of father. They are the Chinna.
Please come to the reasoning part.
Reasoning part come. Page number. ME adalli. Para number 17. On perusal of the suit claim, the plaintiff has filed a suit for declaration of his title 1 over the scheduled properties. Further, on perusal of the plaintiff governments taking similarities the name of the Ramaya, the defendant number 527 got mutation as per MR so and so by the plaintiff existed in the present list. It is highly improbable for this court to raise prima facie case in favor of the plaintiff in respect of de jure ownership over the plaintiff scheduled property. Further, the defendant number 8, 13, 14 claiming that they are the de jure and de facto owners in possession and enjoyment of the plaintiff property. In view of rival contentions, the plaintiff have made out prima facie trial for the case and miserably fails to establish prima facie case in order to consider IA number 1. Like this, in this case, we produce all the documents with regard to grant order, RTC records, mutation, and the entire documents produced before the trial court to establish my case, to prove my prima facie case. My father was granted the property. The government granted in favor of my father. But the trial court given the finding that it is a suit for declaration or go for trial is the necessary. This is not genuine one. For that reason, I prepared the writ petition, madam. They using the similarities names, they transferred the kata. We challenged the kata.
Oh, you read paragraph number 14, you read?
14. MM. Also. In so far as the point number 1 is concerned, this court has taken note that the senior civil judge J.M. Kanakpura had taken the prima facie case and balance of convenience together in order to avoid repetition of discussion. This court has perused the RTC extract for the year 1979-80 to 83 report, also part number 7, issued by the office of Tahsildar Kanakpura, dated 29/11/1970. Further, this court is also perused RTC extract for the year 1969-70 to 70-74 and proceedings conducted before the land tribunal, form number 10, issued in the name of Ramaya. Ramaya is my father, mother.
Read.
Further, this court is also taken note of the MR number 8 pertaining to the item number 1 of the plain scheduled property, disclosing the name of defendant number 5 and 7. Further, the RTC extract for the year 2003-4 in respect of item number 1 of plain scheduled property, disclosing the name of the Ramaswamy son of Nadupaya and Ramaya. In this regard, the RTC extract is not disclosing the father name of Ramaya. The account of this court is unable to appreciate the contents of the RTC extract for the year 2003-4 pertaining to the plain scheduled property. Further, this court is also taken note of the documents rendered by the respondent number 5A to D, respondent 6A to 7B. Further, the respondents have also produced part number 10 issued in respect of land BSR 61/1. Further, they also relied upon RTC extract pertaining to the item number 1 of the plain scheduled property, discloses the name of Ramaya only. Further, they have also produced mutation register extract MR number so disclose the name of defendant number 5 and 6 and also the name of Puttamma wife of Venkatappa. At this juncture, this miscellaneous appeal filed against order so for the relief of grant of equitable relief of temporary injunction. Further, it is also noted from the material available on record that when Lakshmamma and Govind Swami have filed a suit in so against Rangaraju and others for the relief of declaration in respect of so survey number 61/2, my lord. That is not my property. As filed against the plaintiff and other in respect of item number 1 of plain scheduled property for the relief of declaration and such other consequences, and the same is pending adjudication. In order to get as equitable relief of temporary injunction, restraining the defendant from interfering.
What is the document produced by you to show that as on the date of filing of the suit, you are in possession of the property?
Grant records have produced the entire RTC records.
Records are they are also producing. Those are all of the year 1975. Now, after that, what is the material that will be decided eventually in the trial for declaration of title?
We will file the mutation register and RTC extra
Not the latest ones.
Latest they transferred the kata. We challenge this one. We are in
So
possession.
that has to be decided by the court. To say that you are in possession of the property, what else you are produced to show? That is precisely what the court has held.
For the possession, we produce the RTC records only.
He also produced.
He also produced, but they fraudulently got the transferred the kata
That to be
without
decided.
behind back of the plaintiff.
That is yet to be decided. Your appeal is pending before the revenue authorities. No orders in your favor. So why should we take
Still
that?
adjudication.
Court has rightly said. Please come. Agreed with the orders passed in MA number 5004 of 2020 dated 1st February 2025 by the second edition district and session judge Ramnagara, such at Kanakpura dated 1st February 2025, whereby the court has confirmed the order that is passed by the trial court in I number 1, filed under order 39, rule 1 and 2, read with section 151 CPC. The trial court, the appellate court, while dismissing the appeal and confirming the order of the trial court, has observed that on perusal of the suit claim of the plaintiff has filed the suit for declaration of his title over the plain scheduled properties. Further, on perusal of the plaint government, taking similarities of name of Ramaya, the defendant number 5 to 7 have got mutation as per MR number 8/2003-2004. By the said facts existed in the present list, it is highly improbable for this court to raise prima facie case in favor of plaintiff in respect of de jure ownership for the plain scheduled property. Further, the defendant number 8, 13 and 14 claiming that they are the de jure and de facto owners in possession and enjoyment of the plain scheduled properties. In view of rival contentions, the plaintiff have made out prima facie case for trial and miserably failed to establish prima facie case in order to consider I number 1 filed in OS number 229 of 2026. Further, the plaintiffs have not produced iota of document to establish that the plaintiffs are having actual and physical possession over the plain scheduled property as on the institution of the suit. Further, the documents produced by the defendant, the respondent disclose that the plaintiffs are not in physical and actual possession of the plain scheduled property. In this regard, the plaintiff have miserably failed to establish prima facie case. Further, on account of non-establishing the prima facie case, the balance of convenience is also not less in favor of the plaintiff. Further, on account of non-fulfillment of prima facie case balance of convenience, there is no hardship and irreparable injury would be caused to the plaintiff appellant. And accordingly, the court has dismissed the appeal. Agreed thereby, the petitioner plaintiff is before this court. Land counsel appearing for the plaintiff submits that he has placed several documents before the court to show that he has been in possession of the property. The grant was there. Grant is in the name of Ramaya. Who is your grandfather?
Father.
Who is the father of the plaintiff? And ever since they have been in possession of the property. But all these aspects were not considered by the court. It is submitted that the fraudulently the revenue records are mutated in the name of the defendants, taking advantage of the similarity in names, and in that regard they have already preferred an appeal before the authorities, and the same is pending consultation. In these circumstances, the court ought to have granted injunction in favor of the petitioner. Otherwise, as he could prima facie show his case, and if the balance of convenience is in his favor, and if the injunction is granted, lot of hardship would be caused to the plaintiff. Next part, having got the land counsel, the petitioner peruse the material on record. The suit is filed by the plaintiff seeking declaration in respect of the suit scheduled properties. The respondent defendants have also filed another suit seeking declaration and injunction. Both of them are claiming right and title in the property, and both of them are relying on the mutation extracts. According to the plaintiff, the mutation in the name of the defendants is a fraudulent entry, and in that regard, his appeal is pending. Whether such entry is a fraudulent entry or not, whether the defendant is entitled, is the owner of the property, or whether the plaintiff is the owner and the defendant has fraudulently got the entries in the revenue records, the court will eventually decide the same. during the course of trial. However, when it comes to the interim application seeking grant of injunction, the burden lies on the plaintiff to prove that he is in possession of the property there is interference by the respondents. The trial court, the appellate court has rightly held that except the revenue records, no other documents or no other evidence is placed before the court that he is in possession of the property. Considering the rival contentions of the parties, the court has rightly held that the petitioner is not entitled for injunction. The petitioner plaintiff has not made out a prima facie case, and as such is not entitled for injunction, and this court finds no reasons to interfere. Dismissed.
Number 16, K. Murthy, for petitioner.
For the petitioner, the writ of mandamus directing to trial court dispose this suit within a short period.
Which year is the suit?
2023, my lord.
Which court?
Trial court at Mysore, my lord.
Why should the court give a mandamus to dispose of 2023 suit?
The petitioner is a aged lady and she is suffering, having a health.
What is her age?
My lord.
What is her age?
82, my lord. 82 years.
What is the suit for?
Partition, my lord.
The presented petition is filed seeking the following prayer. Land counsel, the petitioner submits that the petitioner is aged about 82 years and the suit is for partition. Considering the fact that she is a senior citizen, there may be a direction to the trial court to dispose of the matter in a time-bound manner. Generally, this court will not issue mandamus to the trial courts to dispose of a matter, that to a matter of 2023. However, considering the fact that the plaintiff is 82 years and is sued for partition, considering all these facts, this court deems it appropriate to pass a following order. The trial court is directed to dispose of so and so as expeditiously as possible.
Still number 17, Rakesh B. Bhatt, for petitioner.
It's a suit for injunction filed with the plaintiff. I'm the defendant before the trial court, my lord. I have ultimately, my lord, the suit came to be compromised between the parties, and we have filed the compromise petition under 23 Rule 3 before the trial court. The compromise petition is at, my lord.
So what is the IA now?
No, my lord. The trial court has refused to accept the compromise petition, saying that in a suit for injunction simpliciter, in a suit for injunction simpliciter, you cannot ask for declaration.
Let others also come.
My lord, both we have filed compromise petition. They have.
Then in that case, you should have come. Then I'll take up this matter day after tomorrow. Let him be there.
Please.
Still number 18.
Notice to the respondents. I'll list this matter day after tomorrow in list 1.
Petitioner.
Still number
My lord.
18.
Yes.
This is a suit for partition wherein decree of the trial court was there for 115 share each for the petitioners. In FDP, the petitioner respondents in that case have filed a memo to alter the share for 1/5 share each. Just on the basis of memo, the trial court, executing court has ordered for altering the share to 1/5 share.
What was granted? What was the share granted?
1/15th in the original decree.
Now it is made to?
It has been altered to 1/5 share by the executing court. Just on the basis of a memo.
You are?
I am for the respondent number 1 petitioner hearing.
Respondent number 1 in the FDP. And who is, which respondent has filed the memo?
Memo, respondent number, in this petition, respondent number 1, 2 and 3.
Not in this petition. Before the trial court, he is.
Petitioners have filed. Petitioner have filed the memo to alter the share.
Petitioners in the FDP.
Yes. The memo is there in page number 21, my lord.
No, it says that in the light of Vineet Sharma's case.
Yes, my lord. Just first they had filed an application prior to that, 2 years prior, which they withdrew. And now they have filed a memo.
No, why? Is it permissible or not? What is the law laid down in Vineet Sharma's case?
Equal share, they are asking equal share, my lord. That is it. There was a notional share given by the trial court.
So what is wrong with this? That's what I'm asking.
They have not questioned the decree till now. They have just filed the FDP accordingly to get the share.
This is judgment, Vineet Sharma's case. Day after tomorrow.
Then number 19,
19.
SV Bhatt,
It's 19. SV Bhatt is 19. Yes. No representation. This is matter in the month of September. Is 20.
number 20,
No representation. September is 21.
till number 21,
Serial number 21, my lord,
Check
representing
number.
for petitioner, my lord. My lord, we are challenging the order dated 18/3/2026 in the trial court suit filed for declaration directing the defendant to execute the registered redemption deed. My lord, the trial court issued emergent notice on IA number 139/192 application. We
Where is
sought
that?
for injunction, my lord, is
Where is that order?
page number 14. Orders on IA number 1 under 31/192.
Petition is agreed with the order dated 18/3/2026.
Para 3 is
Passed
the
with
reason.
the Principal Civil Judge and JMFC Gauri Bidinod, Chikballapur, in OS number 238 of 2026. It is submitted that when the petitioner has filed an application under Order 39, Rule 1 and 2, seeking interim injunction, but instead of, without hearing the said, without passing any orders on the merits of it, the court has issued suit summons. It is submitted with the land council that if the application is considered and if orders are passed on the merits of it, they will get an opportunity to question these orders, but the court ought not to have granted suit summons. He has relied on a judgment of a coordinate bench of this court in so and so, so and so. Next, in the light of the submissions made by the council and considering the judgment of the coordinate bench of this court is passing the following order. The writ petition is disposed of, directing the so and so court to consider IA number 1 and 2 are only IA number 1.
IA 1 and IA 2 also.
IA 1 and 2. IA 1 and 2 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notice is not served on the defendants.
till number 22, Prasanna BR, for petitioner,
Petitioner is a plaintiff. She filed a suit for partition and separate possession. But in the said suit, my lord, the IA number 9 filed by the defendant, page number 50.
Suit for?
Partition and separate possession, filed by the plaintiff and the defendant. But in the said suit, there is a specific contention of the defendant is that father executed a will on 20/12/2013.
So what is the IA?
But IA for page number 50, amendment of the return statement for correcting the date of the will as 23/2013 instead of 20/12/2013. My lord, before that, my lord,
20, he wants to correct it as 23/2012 instead of 20.
12/2013. My lord, he has,
What is this, which year is the suit? 21 suit?
please.
What is the present stage?
My lord, when the matter was half cross examination was over to the defendant, my lord, he filed this application. Several opportunity was given as evidence was closed and made the application that was allowed. Then, my lord, the
So
application.
according to you, what is the prejudice now?
Pardon?
What is the prejudice caused to the plaintiff?
My lord, that will is now created, that is a word.
No, no.
Because, my lord, he has taken a specific contention in the written statement that will has been executed by father and
Now
20.
the trial has commenced. So the will must have been marked.
Please, no, now they have filed in 2024, now they have produced that will.
Correct.
That shows that he has created that will because
In the cross examination also, he has suggested that will executed
No,
by
what I'm
father and
asking
2012.
is, this will dated 2023 is produced before the court.
No, 2012-2023 is not produced before the court, but there is a written in contention in the written statement. At the time of evidence also not produced. But that is produced in 2024, my lord, after closing it.
So 2024, that will is dated 2012-2013.
Please, 23 2013.
23
2013.
is the will which is produced before the court.
Please, 2012-2013 will never produced before the court.
Hmm.
Now they says that father will executed 23-2013.
Then how come without, no, at that point of time, they have not sought for amendment. Then how was that document marked before the court?
That's why, madam, that is filed along with the application with the condonation, madam, that will has been presented now. But before that, he has taken a contention 2012-2013, father has executed a will. That is taken in the written statement, that is suggested in the cross examination. Even in his examination chief also, he said that his father has executed a will on 2012-2013. All of a sudden, now with the application, they are contending that father has executed a will on 23-2013. That
Come
is.
to the affidavit. What did they say?
Please, madam.
Where is the affidavit?
Written statement, page number 30, the first admission in the para. They may not give trouble. The bottom, these all facts kept on the mind. That is bottom, almost.
Yes, 2012-2013. Before the elders.
Before elders, community, villagers.
This is filed when this written statement is filed?
In 2022,
17/2/2022. Now please come to the affidavit in support of the IA.
Please. Page number 50, application. 51 is affidavit. Only one para, first. Second para.
Let's read that.
It is humbly submitted that the above case is posted for today for cross examination of DW1. On before early date hearing, I have filed the chief examination of my side by way of affidavit. Thereafter, the stage of the case posted for cross examination of DW1. On early date of hearing, when I clearly verified the chief examination filed by me and the documents filed by me are marked. Thereafter, the case was posted for cross examination of DW1. At that time, when I carefully verified the written statement and document filed by me in para 10 and 30th line of the written statement, the date of filing instead of mentioning as 23/2013, but it has been mentioned as 20/12/2013. When I clearly verified the same, it came to my knowledge. Immediately, I told my counsel about the wrong mentioning of the will date. When I was given a clear information about the date of will, but it has given wrongly mentioned as 20/12/2013 instead of 23/2013. But
So this affidavit is filed on?
Not even in the cross examination, it is suggested to the plaintiff.
1 minute. If you answer to my query, I'll able to understand it. 24/9/2025 is this application.
Please.
When was the will marked before the court?
Along with the application on 7/11/2024, the will was
7/11/2024. So while marking that will, you had no objection. And now this, when already the will is on record and the will date is so and so, what is the difficulty? What is the prejudice to you now?
That is marked or not, I am not aware. This is not forthcoming in this.
Please come to the order then.
Please.
That is the reason why I am specifically asking, when was the will marked? When was the application filed?
Please. The reasons.
Please come to the impugned order.
Please. Page number 66, order.
'66.
Please. May I read from para 4? May I read?
Para 5, I think you can read.
Please. It is further pertaining to note that a main objection raised by the plaintiff is that the present application has been filed at belated stage after completion of evidence. The fact to be considered is that though present application has been filed after completion of the trial, that is, no case is posted for cross-examination of DW1. The court is empowered to allow the present application if it is satisfied that dispute the due diligence the matter could not to be raised earlier and the amendment is necessary for determining the real contrary between the parties. The present facts of the case proposed correction is only confined to the date of the will and does not require reopen the entire case. In the present case on hand, the plaintiff has not demonstrated any irreparable prejudice that would be
Now, the
caused
court
to-
also records that it is already produced before the court, long back.
Yes. No, long, not long.
Para number 8. Long back means 24, we are in 26
Please.
now.
To further note that as stated supra, the defendant has produced the will before this court. On perusal of the above said will, correct date of the execution of the will.
Except stating that there is a different, now ultimately, it is for him to prove that will.
If that is so, that will is not there 2012-2013, but that is the shows that the subsequently has that created that will.
No, 2012, 2013, 23, 2013. Only like why can't we take it as a typographical mistake, same date?
If this is a typographical, they suggestion to the plaintiff in the cross examination also. In his affidavit also stated.
So
this was-
unless and until you clarify to this court, when the that particular
Yes, I will
document is
clarify
marked,
that, my lord, short date. my lord.
then, yes, this is matter next week in the first place. Yes,
Cell number 23.
notice to the respondents, petition is permitted to take out handsome. And the counsel appearing for the respondent file a memo to that effect by the next date of hearing. Yes, 23.
I'm approved for the petitioner. Petitioner is the defendant in a partition suit. Plaintiff filed a application by memo to withdraw the suit. Defendant filed a application to transpose her as a plaintiff. That application is rejected, my lord. Memo is allowed.
Let's see that. Where is the order?
89, 88. Page 88.
Yes.
Shall I read, my lord? Plaintiff filed memo to dismiss the suit as not present. Memo registered by the defendant number 7 by contending to overcome the order passed by IA number 8. Memo is filed, hence tried to dismiss the memo, and also filed IA number 9 to transpose him as plaintiff number 2. Plaintiff and defendant in the instant suit were already filed a similar kind of suit with respect to the suit schedule property, and they are pending for consideration. This court is clearly observed regarding the contract of the parties while considering IA
When
number
counsel for
8.
the petitioner submits that its suit of the year 2013, the plaintiff has filed a memo to withdraw the suit, and the petitioner, defendant has has requested the court to transpose him as a plaintiff, but the court giving reasons which are untenable, has has allowed the memo. Hence, the petitioner is before this court considering the same. The operation of the order dated so and so is stayed until the next date of hearing. Notice to the respondent. Petition is permitted to take out handsome.
Now that respondent is about to alienate in the suit schedule property. That
I will not grant any order of that nature. Whatever is the order that I have, yes, the hand summons and memo shall be filed by 31st of July, or else the stay granted by this court stands vacated.
Cell number 24. Lakshmikant K.
Petitioner, my lord. I am challenging the order passed by the trial court at annexure A, my lord. My lord, earlier there is a suit for partition.
What is the present suit?
Present suit is suit for partition, my lord, and subsequently compromise has been entered between the parties. And recently, we are the legal representatives of defendant number 1, who is not who is passed away subsequently after the compromise decree, my lord. Recently, I have got to know that about the compromise decree, my lord. we are challenging the compromise decree before the trial court by filing the application under Order 23 Rule 3 MLR, and the trial court has been rejected the application by stating that the trial court has no authority or jurisdiction to adjudicate the matter.
Come to that order.
My lord. In page number 22, my lord. Impugned order.
20?
22. In page number 24, the
Take out notice to the respondents. Petition is permitted to take out handsomens on the council appellee for the respondent. Say memo by 31st. If the memo is filed, list this matter on 5th of August.
Great,
Yes.
ma'am.
Till number 25, Ravi Shankar S for petitioner.
A suit for permanent injunction was filed by 3 persons. Last may kindly turn to page number 10
Suit
is
for?
the, page number 10 is the plain.
Suit for?
Partition, suit for permanent injunction.
What is the present IA?
Present, along with the suit, he made an application order 1 rule 8. As a representative of other, now we last may kindly see the second defendant is the society. Third defendant is the president of that society. The application is filed by the first defendant. We last may kindly turn to the application at page number 19. Page number is 19.
Plaintiff is so and so.
Second defendant is the society. Third defendant is the
Police
president.
House Building Society.
Third defendant is the president of that society. He did not make an application. Now the first defendant is nowhere
Who
concerned.
is the competent to represent the society, secretary or the president?
He is a president or secretary. He is not the secretary or president. He is a third person. First plaintiff is a third person. Now he files a application. You will ask my candidate to page number 19.
Let's please come to 23, we'll see.
Page number 19 will also make the relief sought.
No, we'll see. Come to 23. We'll read the order.
There I filed wakalat, my lord. But without giving me actually, para 22 you will also make kindly turn to. There, page number 22 you will also make. I filed wakala. I have not been given any opportunity to file objection. Same day it has been ordered. Moreover, order rule 1(8) subclass 3 says that the court has to issue notice to the interested person of the society. There is no compliance of order 1 rule 8 subclass 3. Society has not filed an application. The first plaintiff neither.
Come to 25, what the court says. What is the operative portion of the order?
IA number 1 filed by the plaintiff and order rule 1(8) is hereby allowed. In the result, plaintiff are hereby granted to prosecute the case against the defendant.
What is that? It just says plaintiffs are granted leave to prosecute.
No. Yeah, there is no application. Order 8 rule 1(8) what says they say is that on behalf of the members of the society. Now it lost.
No, correct. It never says that plaintiff number 1 can prosecute this appeal on behalf of the suit on behalf of other plaintiffs.
That is what I am making submission. First plaintiff is not. Second plaintiff is the society. Third plaintiff represented by this president. Second defendant does not. The second plaintiff does not make any application and order 1 rule 8. That is the reason why I am here for the court. If the society now the prayer sought.
I understand your submission.
The prayer sought is.
What I am saying is the order is silent about it. Who filed the application?
First plaintiff has filed the prayer.
That's what the order is silent about it. When you come to the order portion.
The plaintiffs are hereby. That's what the court has not considered the affidavit filed by the.
It will then comes to the petitioner submits that. The first plaintiff has filed an IA, I number 1 and order 1 rule 8 to grant leave to prosecute the case against the defendants and to represent the second respondent. It is submitted that the second respondent is a society and the petitioner number one is unconnected, plaintiff number one is unconnected to the society. And the second, the third defendant, third plaintiff, who is the president of the society, has not made such application. And the court, without giving an opportunity to the defendants and without considering all these aspects, had allowed the application filed under Order 1 Rule 8 and failed to follow the procedure as contemplated under the same. Considering the same, there shall be stay of all further proceeding. Pursuant to the order dated so and so, notice to the respondents. Same 31st. Yes.
Till number 26, Mahendra G for petitioner.
Pertaining for petitioner, my lordship, can take adjournment for two days, my lordship. Take adjournment for 2 days, my lordship.
Mic use ಮಾಡಿದ್ರೆ.
Take adjournment for 2 days, my lordship.
This is matter in the month of September.
Till number 27,
Wait for me.
S. Krishna Swami.
Please, Honors. And the third defendant before the trial court.
Yes.
Lordship, may kindly turn to page 9, the prayer column of the plaint, in the plaint.
So what is the
Declaring-
IA filed by you? What is the IA filed by you?
IA filed 7 rule A, C and D. Well, on the ground that 2002 notification is challenged. Notification issued by the BDA. First point. Second point is there is no boundary mentioned in the schedule. No measurement is mentioned. Order 7 rule 3 and 6. May I take your lordship to order 7 rule?
Look at the prayer. What is the prayer?
Yeah, prayer, your lordship. Declaring that the notification, BDA, etc., CS sites 125 2002 2003 dated 34 2002 and notification BDA, etc., dated 28 2003. They filed this suit challenging the notification issued 26 years later. That's first point. Secondly, kindly turn to the next page, page 10, schedule. CA sites 1 and 4 situated Gedlahalli, PNT, BCS layout, Sanjay Nagara, Bangalore. No boundary, no measurement is given. My lord, may I take your lordship to the BDA Act 3 sub.
What is this schedule? CA sites bearing number 1 and 4 situated in.
Yeah, that's all. That's all they say. Kindly take the, no civil suit lies when a BDA allots a site of CA site. Down below which I have marked, in as no suit or other proceeding shall be instituted, maintained or continued in any court or before any authority for cancellation of such allotment or demolition of building, etc., etc. I take the specific contention, also say no boundaries are mentioned, no measurement is mentioned. Therefore, reject the plaint. The trial court says, no, not inclined to do so at this stage. Lordship, kindly turn to page.
Then how a writ petition is filed under Order 7 rejection? You filed for rejection of plaint. That is
Yes,
rejected.
that is rejected.
Then how a writ petition lies?
Yes, yeah, there's only remedy that is available, madam.
You have to file a CRP.
Madam?
You have to file a CRP.
No, suit is still pending.
Oh, that is pending. If this court allows it, what will happen?
No, what happened? The trial court said valuation is not proper. Therefore, revalue the property and therefore a fresh value and slip and pay another court fee of ₹25 only.
No, in the event this court feels that what your contentions are right, then what result will
The
follow?
suit will be rejected.
So it has to come under 115, but not under 227.
But 125 can invoke only when there is no suit pending. That's
No, that is now much debate is over on that. The petition shall convert this writ petition into a CRP within a week from the date of receipt of the copy of the order for statistical purposes. This writ petition is disposed of. Yes.
Till number 28, Manu Shankar, SS.
Mallards, I may be permitted to appear for the petitioner, Mallards. Mallards, the earlier, Mallards, a suit was filed by the petitioner's father, Mallards. Mallards, kindly refer to that annexure
So
K.
you can tell all the facts. What is the present suit and
Mallards,
what is the
present
present
suit
IA?
is for partition filed by the sisters and the children of respondent number 1. Mallards, for a partition, a separate portion in respect of ancestral properties.
What is the IA?
My lords, IA is filed by me to release the deposits which has been standing in the name of my father. My lords, my father shifted to Bangalore in the year 1964. From 1964, he is in Bangalore. The properties are situated in Chandraipatna. My lords, now the account where, my lords, an application has been filed by the defendants here in, my lords, that is the petitioners here in, seeking for withdrawal of that amount, my lords, which has been standing in the name of my father. My lords, that is arrayed as suit item number 10
Who
in the
sought
suit.
for it? Your sisters have sought for it.
My lords, I have sought. That is daughters of the deceased Shivana, who, my lords, who is the brother of plaintiff, my lords. My lords, that account was opened in the year 2012. My lords, there is no pleading to that effect in the plaint to show that the account, the amount standing in the account is accrued out of the joint family income. My lords, no such pleading. Now, my lords, I have taken the stand in the written statement that the said account is the salary account and the revolvements, retirement revolvements received by him, my lords, because he was a,
And who is entitled for that?
my lords, daughters. My lords, plaintiffs are the sisters of K. Shivana, who has filed the suit.
Sisters.
Yes, my lords. My lords, earlier there was a suit filed by Shivana, my lords, in respect of the very same properties, except the.
Please come to the impugned order.
Yes, my lords. My lords, page annexure, page 65, my lords. The reasons, my lords, paragraph, page 68. The plaintiff has filed a suit for partition. The contention of the appellant is that her father was holding an SB account with the fourth defendant bank, wherein his pension and retirement benefits are being credited. The said amount was his exclusive personal account and not connected with the alleged joint family properties. Her father has nominated her as a nominee in respect of the said account. Hence, the suit, they filed instant application to direct the bank to release the amount in her favor. But the contention
And he
of the
died?
Yes, my lord.
When he died?
My lords, he died, my lords, prior to filing of this 2022, my lords. After the, my lords, 2020, before the filing of the
You have
suit.
not placed before the court the documents to show that what is the account and what are the proceeds that are deposited in that, or.
My lords, I can deposit now. I have no grievance, my lords. I will deposit.
Without that, how will the court know all this?
My lords, now one application has been filed, my lords, connected matter is at serial number 32. My lords, where? My lords, where an application has been filed by the plaintiff number 2. My lords, not by the sisters. Plaintiff number 2 is the
We
son
hear
of
this
defendant number
along
1.
with that. Along with that, all along with 32.
Yes, my lords.
Yes, next.
Cell number 29. Cell number 29.
For the petitioner, my lords, seeking a mandamus, my lords, for speedy disposal. Suit is of the year 2018, my lords. Suit is one for bare injunction.
Which court is this?
Well, it's Bangalore City Civil Court.
How many cases pending in Bangalore?
41st additional city civil and sessions. Sorry, ma'am.
Older than 2018 or pending on the file of that court?
My lords, the peculiar circumstances over here, my lords, is that the matter was initially posted for arguments. All the defendants were placed ex parte. My lords, thereafter, my lords, at the fag end, he comes and files an application. My lords, for a moment, my lords, at the fag end, my lords, he comes and files an application seeking for setting aside an ex parte. My lords, that comes to be allowed. I do not challenge that. My lords, thereafter, my lords, during the pendency of the suit, he sells the property, the defendant. My lords, he creates a sale deed in favor of third parties, and now they come and file an application seeking for impleadment. Now, my lords, once that impleadment gets allowed, my lords, the result is that again the proceeding starts de novo. It starts from the starting for the fresh defendant.
In every
for
suit that happens.
Well, for that reason.
The nature of this court, this particular case, that there should be a mandamus.
Well, it's 2018 is the suit, Malad. Suit is only one for bare injunction, Malad.
I'm telling you, on the file of that court, there are so many matters pending, much older than your matter. The writ petition is filed, seeing the following prayer. In the light of the judgment of the Honorable Apex Court, this court cannot, in every case, cannot issue a writ of mandamus directing the court to dispose of the matter for the sake of asking the same. Unless and until is an exceptional case which warrants an order. Considering the fact that the pendency on the file of the said court or the much older matters are pending, this court is not inclined to pass any order, issue any mandamus dismissal.
My lords, may I seek for only one submission, only one prayer is this, my lords. Let time frame not be fixed, at least an speedy disposal may be ordered, my lords. For the only reason 2018, my lords, the
No, it is.
petitioner's age is about
What
60
is
years.
what is happening is, several matters are pending, what I am seeing it on the administrative side. And
Yes,
old
ma'am.
matters will not even come up for hearing. And from the High Court, continuously orders are passed, take up 23 matter, 25 matter, whoever comes to the High Court, that's a case for speedy disposal. Why should it be? A person who
That's
can come to
because-
the High Court, he should be given special treatment.
No, my lords, indeed not. I'm not only asking on that
What I'm
factor.
saying, that's why the
Age
Supreme
of the
Court also
petitioner, my
said,
lords.
Supreme Court also said that unless and until it is an exceptional case, there shall not be a mandamus from the High Court.
Lords, I understand. my
For
lords.
facts are not exceptional, that happens in every civil suit. Yes,
That's
next.
grateful, my lords.
Cell number 30, Vishwanatha S. NS.
No representation in the month of September.
Cell number
Yes.
31. Narayan BN.
Represent
Petitioner.
petitioner.
Yes.
The plaintiff's writ petition challenging the order passed by the trial court allowing the application filed by one Uma Maheshwari as additional defendants in a suit. This is a suit for specific offense of agreement of sale entered into between the plaintiff and defendants 1 to 3. Now she filed an application.
Who is she?
She is a daughter of first defendant and sisters of two other defendants. Now she is claiming that she filed a suit for partition with other defendants.
Unfortunately, in this specific performance suit and the latest judgments of the Supreme Court, that law laid on Kasturi is now diluted.
No, there
They
are
say that they can be impleted.
no, there are several judgments, my lord, even including Supreme Court. This is a
Latest judgment. I'm referring to latest judgments. Earlier line of the.
even
line-
Supreme Court
earlier
Kasturi
line of-
versus Ayyamma Perumal. This is a case in a suit for performance suit.
Which
Third
year
point-
is that?
in 2005 SEC Kasturi versus
That's what I referred to just now, Kasturi. Now,
Yes.
after that, much water has flown. Now, the latest judgment is very much diluted on that aspect, that they can be implemented in a suit for specific performance. Latest judgment of
I will
this,
look into and I will.
Justice
submit.
Pardiwala. Yes, this is matter next week.
Cell number 32, 32.
Yes,
32.
call that.
My lords, kindly refer to the plaint, my lords, annexure A,
So,
page.
come to the impugned order first.
Yes, my lords, in the first matter, my lord.
No, second matter. 32.
Second matter, my lords, impugned order is annexure J, page 68, where an application is filed by the plaintiff seeking a direction to the respondent number 4, defendant number 4, who is the bank, to produce a statement of accounts. My lords, that order is also been herein. My lords, as per the, my lords, the said account.
It is good for you.
Yes, my lords, I am not doubting it. My lords, only thing is, now that account is opened in the year 2012. My lords, for the moment, my lords, 2012. My lords, the suit is filed in the year 2025, my lords. My lords, the 2024 December, K. Shivana dies. That is, my father dies. My lords, that account is operated and he was a teacher, my lords. That amount has been deposited in that amount, the
That's what,
benefits.
now with this
My
bank
lords.
account is before the court.
Yes, my lords.
Court will understand whether
lords,
it is an amount from his
my
salary.
lords.
Because they are seeking partition and according to them, the entire joint family property is in the control of the late Shivanna.
Yes, my lords.
So what is wrong in
My
it?
lords, I'll produce it. Only one thing here, my lords. Kindly refer to the pleadings, my lords, in the plaint. My lord, they do not say that from which account this amount has been transferred to his account. My lords, he left the village in the year 1964. My lords, he files a suit in the for partition.
This will cut the issue.
My lords,
The producing the bank statement is in your
my lords,
interest.
I'll produce it. My
Shouldn't
lords,
have
in the
questioned
connected
it.
matter, my lords, I'll not press, I'll produce it. My lords,
This matter, no, it has directed to the bank, I think.
my lords, I myself will produce the entire bank statement, my lords.
Defendant number 4 is directed to produce a bank statement.
My lords,
Then
yes,
what I
ma'am.
do is,
Yes, my lords.
as far as this order is concerned, I will dismiss your writ petition.
Yes, my lords.
Second matter, I'll issue notice, I will say, I'll stay the proceedings, let others come.
Yes,
When
my
this
lord.
is before the court, at court decided
Yes, my lord.
afresh.
Yes, my lord.
The writ petition WP number 21212. The present writ petition is filed. Agreed with the order's date, the order passed in I number 8. In I number 7 in OS number 5 of 2025 with the first edition senior civil judge and JMFC at Chandrapatna, Hassan, dated 3rd July 2026. The petitioner herein is the defendant in the suit. The petitioners or petitioner?
Petitioners, my lord.
Petitioners of the defendants in the suit. The respondent herein has filed the suit for partition. In the said suit, the present application came to be filed under Order 11, Rule 14 of CPC, seeking to direct the defendant number 4 to produce complete bank statement. The court, by order impugned, had allowed the application and directed defendant number 4 to produce the bank statement of K.S. Shivanna, son of Siddhagowda, in SB account on the next date of hearing without fail. While allowing the application, the court has observed that on meticulously going through the entire material on record, the averments of the plaintiff is that the suit property is also their joint family and ancestral property. The father of defendant had been looking after the entire affairs of the joint family since 1990 and was getting income raised from the joint family suit properties. Even he had borrowed the loan on the basis of joint family properties. From the joint family income, only item number 9 and from which account the amounts are deposited to this account, and how this is pertaining to the joint family account, joint family. And without stating all these facts, they filed an application, and the court, without considering all that, has allowed the application. Next para. Having heard the counsel for the petition, peruse the material on record. The suit is for partition according to them, the properties or the joint family properties, and they are entitled for share. There is a particular account pertaining to late Shivanna, who is the father of the defendants.
2 and 3, my lord.
2 and 3, and according to the plaintiff, that is that the amount that is deposited in the said account is a joint family is from the amount derived from the joint family properties, whereas it is a case of the defendants that it is as he was working as a teacher, that account is pertaining to his personal his salary and other personal income. In the considered opinion of the court has rightly ordered to produce the bank statement as the court, and the court would be able to appreciate what is the flow of amount to the said account. In the considered opinion of this court, the interference, the court has passed a well-considered order. No interference is called for, accordingly dismissed. Give me the other one. No, I think in that if stay is granted, unnecessarily your
My lords, I'll do
application
one
can't
thing,
be.
my lords. For a limited period, my lords, stay may be granted, my lords. I'll serve it by hand summons to the council
for the
appearing.
petitioner submits that when the account pertaining to the father is with regard to his it is his from his salary and nothing pertaining to the joint family properties, and without there being an averment in that regard in their pleadings, the court ought not to have dismissed the application. Considering the same, there shall be stay of all further proceedings pursuant to the order dated so and so. Hand summons 30.
My lords, I'll.
If the memo is filed by 31st, list the matter on 11th of August.
Much obliged.
Cell number 33,
For the petition,
Prabhakar Sethi.
the matter is connected matter with 21670. In the similar matter, the suit for ejectment.
What happened in the similar
That is interim order is granted in that particular matter. And the same IA, the similar order has been passed. And the premises is different. And the suit
is the same.
Suit is for ejectment.
No, in the same suit, this is also arising.
Same order has been passed, different suit.
Where is that order?
That 21670, 17th of this month it is ordered.
It is not uploaded.
Not uploaded, but it is ordered to interim order has been granted with a direction to serve the copy to the other side on or before 31st. And the IA is.
According to you, only the suit numbers will change.
Your Lordship.
According to you, only the suit number and the IA number will change, remaining all the same.
No, the suit number is different.
That I understand. That's what I'm saying. Order is the same as that was passed on 17th, except
Similar
for the
order,
numbers.
similar order passed in the different suit. Application is similar. My application is for amendment of counterclaim prayer, alternative prayer. That application has been rejected. And on that I preferred an appeal. And the connected matter also similar application is filed.
Yes, same order as that of change the suit number and all. Give the number.
21670. Go ahead.
Number 34,
And the matter was posted to 338, Your Lordship.
List along with that on
38.
38.
cell number 34, Ravindran P.
My Lordship, earlier I moved as a revision petition.
Yes.
This is a money decree. It has been passed by the City Civil Court at Chennai on 30/6/2015. Since the respondent is operating at Bangalore, their base main office. So it has been transferred to Bangalore. And on 26/10/2024, respondent entered into appearance. On 19/4/2025, an IA was filed almost after 6 months.
What is the IA?
Order 21, Rule 26 to stay further proceedings in execution proceedings.
On the ground?
On the ground that they preferred a IA before the Chennai.
But what is how can the court do it?
It cannot be.
Where is that order?
At page number 17, my Lordship, may kindly see.
17.
17 in page. It is a blanket order given. Now what they have.
Now this order has come, is being transferred to Bangalore for execution.
Execution.
It's a transferred one.
Transfer decree. So this could not have been allowed. That too, after 1 year, they moved an application in Chennai court in 2025. Now this after 1 year, this order came to be passed. They never moved, other than moving an application before the Chennai court, they never even moved an application.
And counsel for the petitioner submits that when the execution is ordered and transferred to this court, transferred to the court at Bangalore, the transferring court cannot pass the order staying the proceedings. And if the petitioner is, and he has to, the respondent who is aggrieved has to obtain the orders from the court at Chennai, considering the same, there shall be the order impugned dated so and so. Operation of the order is stayed. Notice to the respondent and summon same 31st.
Number
Yes, sir.
35, K. Chandranath Adiga.
I'll take notice to the advocate of it, please.
Sir.
Yes,
35, Chandranath Adiga.
yes. In the month of September.
Cell number 36, S. Venkatesh Shastri.
Petitioners. Lord, in a suit for declaration and possession, petitioners are the plaintiffs before the trial court, and their entire suit is based on annexure E produced herein, which is a reconveyance deed dated 18/6/1987.
Suit for declaration.
Declaration and possession. Please, madam. Madam, this document was executed by defendant number 1 in favor of my father.
What is IA now?
Madam, there is no IA as such.
Hmm.
On 5/3/2026, when this document was sought to be produced, the trial court at page number 72 makes an endorsement that this document cannot be marked for want of registration.
There has to be a detailed order on that. Or how can there be an endorsement?
My lord, page number 72 may kindly be seen.
72.
Translated copy at 74. In fact, petitioners earlier filed an application under section 65 of the Evidence Act. Trial court holds that admissibility of that document will be examined at the time of producing the document.
I didn't understand this order at all.
On page number 72,
Hmm.
in Kannada, bold letters, if I may read.
So read it. It says, further to examination chief from the counsel for petitioner. I have submitted my chief examination by way of, I have produced the agreement. The CLD dated exhibit P2, the reconveyance deed dated. The said document request, and since the same was not registered, it is refused to get it marked as an exhibit.
Yes,
Or marked as exhibit PN. At what stage it is?
At the stage of examination in chief of plaintiff, witness number 1. And in fact, at the time of the filing the suit itself, I have filed an application under section 33 of the Stamp Act, stating that I am ready to, if the document gets impounded, I am ready to pay the duty and penalty. In
No,
fact,
I'm not able to understand this order at all. This is not the way the orders are passed. When there is any issue with regard to the admissibility of a document, and on that, if the court has to pass an order.
as I have submitted, I filed an application under section 65.
Uh.
The court holds that admissibility of that document will be examined at the time of,
Then let it be examined.
except this document, all other documents are examined. And this is the vital document on which the entire suit claim is
Notice
based.
the respondent's petition permitted to take out hands on. Memo shall be
I may be
filed.
permitted to serve the hand copies also.
The memo is
In the
filed
respective
by
councils appearing
10th
before.
of 10th of August, list the matter on 11th.
Bill number 37.
Yes.
Naga Shankar Pagura.
Lordship, I am for the petitioner. The petitioner father, with the petitioner father, this building taken on rent basis in the year 2000
The
year.
suit for
Lordship, I am challenging ex parte order made by the Honorable City Civil Court and execution petition filed and they have order for attachment and seize. This is ex parte order. Pray for stay that execution petition and permit to the petitioner to submit his objection. True fact not submitted by the respondent. Taken the order, Your Honor.
what is this prayer? Please to call for the records in OS number, miscellaneous number, execution petition. Direct the trial court to consider to set aside OS number. How this writ petition is numbered? Stay the execution of the proceeding. Why? What happened to the section? Why are they numbering this? Are they using their is any application of mind or not? No, they filed it under CPC. They have to see whether it is maintainable or not. Show it to the registrar judicial. This is matter.
Lordship, stay the execution petition, Your Honor.
This is matter after 2 weeks. Ask the registrar judicial to come to the chamber.
Lordship, execution 23rd case is there. They are going to attachment, Your Honor. Ex parte order passed, Your Honor. Stay the.
If ex parte order is passed, what you will do? You will go
Lordship,
before
just
the
stay.
court.
I am ready to. I have appear, Your
Go and
Honor.
do it. I will not do anything here. Yes.
Lordship, this honorable court has to take on record the fact, Your Honor. Otherwise, you are putting to injustice, Your Honor. Pray to stay order, Your Honor. Execution petition only.
Next case.
Bill number 30.
Lordship,
Yes, sir.
humble submission, Your Honor. Grant the stay order, Your Honor.
Yes, next. Yes.
Lord, suit is one for recovery of money, my lords, of rupees 40 lakhs and 8 lakhs interest, my lords, along with my lord declaration of a gift deed dated so and so, my lords, as not binding on the plaintiff, as it is fraudulent. My lords, the application herein on which my lords I have approached this
For
honorable.
the plaintiff.
I am for plaintiff, my lords. The application was filed by the defendant, my lords, under order 26, my lords, seeking for under order, it is in my lords, I number 5 of 25. Seeking my lords for referring the disputed signature for expert opinion along with the admitted signature. My lords, the facts are that I lent a loan of rupees, my lords, 40 lakhs to the defendant. He in turn, my lords, executed promissory notes.
Yes.
It's, this application was filed prior to cross-examining DW1. Lords, since DW1 did not tendered for
What is the document?
document is, my lords, exhibit P1 to P8, that is promissory note.
Oh.
They have denied the execution of P1 to P8. But may I request my lords to kindly see cross-examination portion one sentence, my lords, at page 65.
Yes.
Last, my lords, 7 lines from the bottom. It is true to suggest that as on the date of execution of exhibit P1 to P8, I was residing in a house at number so and so, JP Nagar, Bangalore. Witness warrant. So he has admitted the execution, my lords. Now this is supported by, my lords, one more cross-examination which your lordship will get at page 73.
No, what is it? What, I didn't understand.
My lords,
He says that as
says
on the date
as
of-
on the date of execution of exhibit P1 to P8, that is the disputed promissory notes.
Uh.
He was residing in, my lords, the rented house at JP Nagar. So that is sufficient to show that, my lords, he has executed these documents. This is supported by, my lords, one more cross-examination at page 73.
70?
73 minutes.
Mm.
7 lines from the bottom.
Yes.
I do not know for how much amount I have executed exhibit P1 to P8 in favor of the plaintiff. When he admits, my lords, execution of the documents at exhibit P1 to
Then why
P8,
do you want it to be sent? to
I am not he has sought for, my lords. Defendant has sought for only to protract the proceedings. From 2014,
Please come to the order. Now, what is the interim order you are expecting?
now I have sought for interim order of this particular order, referring the matter, my lords, for comparison. Page 27. I don't want my suit to be stayed, my lords.
That's what I'm asking.
Now they initially, my lords, DW1 did not tender.
Para 14, please. Come.
Please. Applying the aforesaid settled principles to the facts in the present case, it is evident that the entire claim of the plaintiff
What is this observation that nor executed the document?
My lords, this is virtually giving a finding insofar as the final relief as well.
No.
Kindly
This
see, it is the
observation
evident that entire claim of.
of the court is contrary to what you have read before.
Yes, please, my lords. I have pointed out in the objection also I have said, no, this is what is what.
Come. When counsel for the petitioner submits that the defendant has accepted the fact that he has executed the document. Now, an application is filed to send the said document for comparison for the expert opinion, and the court has allowed the same. While allowing the same, the court observes that it is a consistent stand of the defendant that he has neither borrowed any amount nor executed the said documents. Then counsel has drawn the attention of this court to the examination, cross-examination, wherein he has stated that he has executed the documents. Considering the same, there shall be stay of all. There shall be stay of. There shall be stay of operation of the order dated so and so.
Great.
9.
Same
Hand summons memo shall be filed by 31st, or else the stay granted stands vacated. Yes.
Lords,
39 Linkaju KR.
I may be permitted to serve on the council, my lords, and
Counsel.
summons. Yes.
None of the cases I order for party. It is only counsel.
Great.
Linkaju KR.
In this case, my lord, a big to appear for petitioner, my lord. The petitioner had filed a impleading application in FTP proceedings, my lord, claiming that purchaser of the item number 2 property, my lord. My lord,
It is a suit for.
earlier suit for partition, but partition suit has been decreed. My lord, FTP proceedings has been filed to take a share. My lord, I am the purchaser of the item number 2. My lord, now I purchased and I developed the land. Sites have been formed.
When did you purchase the land?
My lord, land had been purchased during the pendency of the suit, my lord. Now only my claim is, my lord, to protect my interest, to protect my share, my lord, my impediment is necessary. My lord, but My lord, FTP court, my lord, without protecting my interest, my lord,
Why should your interest be protected? You're a pendant-led purchaser.
my lord,
What were you doing? Why did you
my
not impede
respectful,
yourself?
my lord, the defendant number 127 had 1/10 share.
No, your rights are not been determined by the court.
My lord, that's why while determinate,
Why you did not impede yourself in the pending, when the suit was pending, when you purchased it? And why
My
do
lord,
you want that FDP court to do all that?
my lord, now, my lord, the circumstances has created, my lord, I came to know,
Notice to the respondents.
my lord,
petitions for
my
written report
commissioner
has-
warrant has been issued. My lord, without my presence, my lord, if the FDP proceedings has been concluded, my lord, again, I have to file suit.
What were you doing during the pendency of the proceedings? You have purchased a property and the suit is pending, and why should the court stay the FDP proceedings
Lord,
now?
that proceedings is not within my knowledge. If I add knowledge, certainly I will knock the door of the civil court. I will get relief, got impleaded. My lord, behind my back, my lord, the defendant number 1 to see how bona fide, without disclosing the pendency of the suit, my lord, they sold the property.
Do that. Let us see what did you say in your affidavit
My lord, insofar as, my lord, my agreement,
that you are not aware of it.
my lord,
Let's see.
insofar as, my lord, for a moment, my lord, before opening that, my lord, I will clarify. My lord, insofar as agreement, joint development agreement holder had approached before civil court, my lord. That application has been
So purchased the property on 23/1/2019.
2019, my lord. My lord, my earlier to that, my lord, joint development agreement is there. The agreement holder had filed application before civil court. That application has came to be dismissed. Subsequently, I purchased the property. After conclude of the suit, my lord. Suit had been concluded in the year 2018. I purchased it in the year 2019. I have no opportunity to file application in the suit, my lord. That is the difficulty. If I had opportunity, my lord, I will.
Come to the order of the court.
My lord,
Come to the order of the court. We'll see what did the court say.
court says, my lord, application has been filed on 2 occasions by the joint development agreement. Application has been dismissed. Now you can't file res judicata applies. That is the finding of the court, my lord. That's all the finding.
Is it correct or not? That is what we are looking at under 227.
My lord, I have no option except approaching the.
Let's see the order. Let us see the order. What is the finding? Whether you have a remedy or not, we have to look at the order whether it is correct or not. That's the only thing. Yes, please read.
Come to, my lord, para 15.
11.
Para 15 in the reasoning, my lord, start from para 11, my lord. Para 15, my lord. Shall I read from para 15, my lord?
You purchase a property from which defendant?
My lord, defendant number 1 to 7, my lord. The petitioners and respondent number 1 to 7 and 10 in their objections specifically contended that during the pendency of the original suit in OS number so and so, one Srimati Mangalama filed application under second allegation development agreement holder in respect of item number 2 of the suit schedule property. And after hearing, the said application was rejected. Therefore, similar application order number 13 under order 1 rule 10(2) CPC also filed, alleging that she is development agreement holder and general power of attorney holder in respect of item number 2 schedule property. And after hearing, the said application was also rejected. If that is so, the similar application is not maintainable and principles of res judicata under section 11 of CPC applies to the present application. The petitioner had proposed.
Who has filed this IA number 30?
Earlier, my lord, who is the joint development agreement holder. She filed application.
What is the relationship between that person and you?
My lord, she given the property to me and under the, my lord, registered GPA, my lord, property has been sold to me in the year 2019. Now I develop the property, site have been formed.
When the person who has given development to you, that person's application itself is dismissed in the suit.
My lord, during that juncture, sale deed has been not executed. Only in the year 2019, sale deed has been executed, my lord. Then I come into entry to the property.
Then you say that you are not aware. You are not aware of these proceedings.
I am not aware of that. Only after execution of sale deed, I came to know. Then I filed the application. Even till, my lord, 25, I am also not aware. Only recently I came, when they started come and try interfere with my land, my lord, then only I came to know. And on inquiry, all this behind back, what happened is came to know my proceedings, my lord. Without my presence, my lord, if the FTP proceedings has been decided, my lord, my share will be go. Again, I have go.
Anyway, it will not be decided by the court.
My lord,
anyway.
that's why, my lord, proceeding has been stayed. Let me enter the proceedings, my lord. Otherwise, my lord,
Take a short notice.
my lord, if, my lord,
Is this matter
my lord,
on,
stay,
on 29th of July, petition is permitted to take out
my lord,
hand summons and
Commissioner
shall
Warren.
file a memo to that effect by 28th. If the memo is filed by 28th, list the matter on 29th.
Commissioner warrant has been issued, my lord. If otherwise multiplicity of proceedings has been arrested, my lord,
Nothing will
again I have
happen.
to file suit. I claim property. My
Nothing
lord,
will happen in a week. We can we can again reverse the order. Yes,
please, my lord.
Number 40, Srikala PK.
yes.
Appearing for the petitioner, my lords, petition is filed by the decree holder. The only relief I'm seeking is for the trial court to consider and pass orders on a pending application. What has happened in this execution?
You filed the application.
Application was filed on 16/8/2025. Sorry, 14/8.
What are those applications?
What had happened was, my lords, the court dismissed the execution petition on the basis of an endorsement by the court, Amina, saying that DHR was not present. On the very same day, my lords, we appeared and we informed the court that we were not informed, and we also filed an application to recall that order. From 14/8/25, my lords, this application has remained.
Let counsel for the petitioner submits the IA number 1 of 25.
1 of 25, my lords, please.
Is filed on 14/8/2025 before the trial court and before the executing court. And the same is pending consideration. From that, it is submitted that there may be a direction to the trial court to dispose of the IA as expeditiously as possible. Next, but considering the fact that the IA number 1 of 2025 is pending from 14/8/2025, this court deems it appropriate to direct the trial court to consider the application in accordance with law within a period of 8 weeks from the date of receipt of the copy of the order. Yes, next.
41,
Obliged.
Sudhakar GV. on name.
Court granted a ex parte order of injunction, my lord. The ex parte order of injunction, after the grant of ex parte of injunction, it was not complete fully, my lord. All the documents, plaint documents were not served, only plaint and IA was served. Therefore, I advanced the matter, filed a memo stating that it is not complete. Even the other side, the plaintiff counsels admitted the fact that it is not, the list of documents is not served. In spite of that admission, my lord, the court proceeds says that instead of filing a memo, I should have filed an application under Order 39 Rule 4 for vacating the interim order, my lord. On that ground, my memo is rejected. My lord, the memo that is filed, my lord.
You could have filed, instead of coming here, you could have, if you filed it, the court would have heard it.
My lord, it is a mandatory requirement to follow Order 39 Rule 4 moment.
I understand. What I'm saying is, if you come here, what will happen? Now I will vacate the interim order.
My lord, because non-compliance, it is a mandatory provision, my lord. Without expressing your opinion on the merits, the court could have vacated and heard the application on merit, my lord. That is what the Supreme Court says, my lord.
Let other side come.
My lord, now ex parte, my lord, 1963's property is sold. A freeless partition suit is filed. Ex parte order of injunction.
This matter on 27th of July, petition is permitted to take out hand summons on the
My lord,
counsel.
for respondent 3 to 16, it may be
A
dispersed.
memo is filed seeking dispensation of notice to respondents.
3 to 16, my lord.
3 to 16, notice to 1 to 2, 1 and 2.
1 and 2. Okay. My lord, it's so far, sir.
We'll hear it. It's finally allowing your petition itself.
Yes.
Yes.
Cell number 42, Sharath Gowda for petitioner.
Great to appear for the petition.
Yes.
That's plaintiff's writ petition.
Yes.
That's application filed by the plaintiff under Order 39 Rule 1 and 2, restraining the defendants from forming the layout, which is as on today vacant, came to be rejected by the trial court and as well as by the first appellate court.
Let's see the appellate court order.
Lords, before taking to my lords to appellate court order, my lords, just in 1 minute, I'll just. One Chikka Muniappa, my lords, was an applicant, forum number 7, seeking tenancy rights before the land tribunal, my lords, as against the landlord, claiming that they are the tenants. That application, my lord, initially came to be allowed. This honorable court set aside, remanded the back matter. Twice it has happened. Now, my lords, as on today, the land tribunal has confirmed tenancy in favor of Chikmuniappa and his legal representatives.
It is confirmed.
Confirmed. That is challenged and writ petition is pending. And in writ petition, there is an order of status quo as regards the possession. That is the status as on today. Now, my lords, this Chikmuniappa had two sons, Narsegowda and Venkategowda, my lords. My lords, simultaneously, my lords, this landlord, though he has lost the proceedings before the tribunal, he has, when the proceedings were pending, he kept on executing sale deeds, alienating this very piece of land which was subject matter of tenancy.
There is an order of status quo.
That is regards to possession. Before this High Court granted an order of status quo, when that matter was pending before the tribunal itself, though his rights are not culminated, only when the application filed for tenancy gets rejected, the landlord will become the absolute owner without any claim over the property. Then only he could have created sale deeds. In spite of these applications being pending, he has executed sale deeds from 2010 to 2015. Now, on the basis of these sale deeds, the defendants are trying to form a layout. What has happened, my lords? One of the sons of Chikmuniappa, he has also become a consenting witness to one of the sale deeds, and he has entered into compromise, leaving the other branch who are the plaintiffs. So plaintiffs are left out. Now, your lordship may kindly is the first appellate court order. First appellate
What is the
court
injunction you sought?
restrain the defendant from forming the layout, because as on today it is vacant. Now, the first appellate court, my lords, what it says, it gives weightage to these sale deeds, which in fact this court says these sale deeds could not have been executed because landlord's rights were not culminated. Landlord could not have sold this property. If your lordship takes page 35, my lords, for a moment, page 35, running page 35 in MA court order.
So these sale deeds are from the year 2007.
From 2007 to 2015. 3 sale deeds came to be executed. For none of the sale deeds, I am the party. And in fact, these sale deeds on the face of it are void because these sale deeds have been executed by the landlord, whereas the tribunal has confirmed occupancy rights in favor of the tenants. So these sale deeds are one without title. Now, solely because these sale deeds are of the year 2010-2015, both the courts are saying that you have approached the court belatedly. I am not party to these sale deeds. These sale deeds are executed by the landlord, which is one without title. Now you may take your lordship to the state.
Name of the plaintiff.
Plaintiff name is Lakshmamma. Plaintiffs are the petitioners, Govind Raju and Lakshmi Kant. They are the legal representatives of Chikkamuniappa, born to his son Narasegowda.
How many children he has?
Chikkamuniappa had 2 sons, Narsegowda and Venkategowda. This Narsegowda wife and children are the plaintiffs. They have not alienated any property.
Mama is his wife.
Wife. Govind Raju and Lakshmi
One
Kanta.
of the son is a signatory to the sale deeds.
My lords, that is the other branch. This Chikmuniappa had 2 sons. One is Narsegowda, other one is Venkategowda. Venkategowda has executed.
What is the extent of land that is granted?
1 acre, 6.8 guntas.
1 acre?
6.8 guntas. 6.5 guntas. This is the extent.
So 2 children are equally entitled to that.
Ultimately, if the Venkategowda had executed the sale deed, he is entitled for his share after 1 out of 1 acre, 6.5 guntas.
What is the extent of the sale deeds?
The entire extent of my lords, 1 acre, 6.8 guntas has been sold off by the landlord, not by my other branch. He is only consenting witness. Sale is by the landlord, whose rights are yet to be decided. If your lordship in this background sees this court order, my lords, while granting stay, annexure K, my lords, page 103.
Yes.
May I read this, my lords? 103.
It's not one.
103 is the
Objections by the respondent.
lords. Annexure J, my lords. I'm sorry. I have put the status, online status, my lords, of the this court's.
Online status is at 1010.
Please, my lord, I'm sorry. There, your lordship may kindly come to the order dated 21/9/2022. 21/9/2022. At the bottom. Learned senior counsel for petitioner is directed to serve copy. Learned senior counsel so and so appearing for the petitioners would submit. That is for the purchasers who are the defendants. Submit that the petitioners herein have purchased the land in question under registered sale deed dated so and so. At the time when the petitioners purchased the land was already converted from agriculture to non-agriculture. Nevertheless, your lordship may kindly see. Nevertheless, when admittedly the application filed by the contesting respondents was pending consideration before the land tribunal, and on 2 occasions the matter had come up before this court and was remanded back to the tribunal, the petitioners could not have purchased the land. This being the position, the order passed by the land tribunal cannot be stayed at this juncture at the instance of subsequent purchasers, that is the petitioners. The respondents are directed to file statement of petition. Nevertheless, the parties are directed to maintain status quo in respect of the possession. When this court directs to maintain status quo, the trial court ought to have allowed by application.
Let's please come to the order again.
First appellate court's order, my lords.
Yes.
Page 35, my lords, may kindly take. Page 30, running page 35. There, my lords, 6 lines from the top. First appellate court holds these questions can be adjudicated only of trial. Hence, plaintiffs have definitely made out a prima facie and triable case in the suit. So far as prima facie case, first appellate court.
No, what I'm not able to
Please,
understand is,
I'll
there
answer.
is an order of status quo, where both the petitioner and
Are
the
directed to-
respondents are before the court in the writ petition.
Yes.
So now, you want them not to do anything, not to frame the layout. In the light of the order passed by the writ
Still,
court,
my lords, because that status quo order was passed at their instance, they are taking advantage and trying to build a formal layout. Though there is an order in the teeth of which they cannot form a layout, the trial court, first appellate court failed to understand this. Just like this, both the courts, because they should have quoted High Court order and granted status quo.
please come. Land counsel for the petitioner submits that the plaintiffs have filed the suit for declaration.
Yes.
And as a declaration that the sale deeds executed, the sale deeds are not binding on them, and also sought for an injunction. Yes. Permanent injunction. It is submitted that the grant, what is that called?
Lords?
What is granted?
Tenancy
rights were granted in favor of the plaintiff's father.
Predecessor in title, Chikkamuniappa.
Plaintiff's is a father.
Plaintiff's grandfather.
Plaintiff's grandfather. It is a case that questioning the orders passed by the tribunal. When a writ petition is filed, that is WP number 17958 of 2022, by an order dated 21/9/2022, a coordinate bench of this court has passed an order observing that the application filed by the contesting respondents is pending consideration for the land tribunal, and on 2 occasions the matter had come up before the court and was remanded back to the tribunal. The petitioners could not have purchased the property. This being the position, the orders passed by the land tribunal cannot be stayed at this juncture at the instance of the subsequent purchases, that is the petitioners therein, and accordingly directed the parties to maintain status quo. Land counsel for the petitioner submits that the purchasers are parties to the said writ petition, who are the defendants in the present suit. It is a submission that in spite of an order of status quo granted by this court, the trial court, without considering all these aspects, and the trial court and the appellate court had dismissed the petition, considering the submission of the land counsel, and in the light of the order of status quo passed in the writ petition, there shall be an order of status quo till the next date of hearing. Same notice, hand summons, memo shall be filed by 31st, or else the stay granted, the interim order granted by this court stands vacated.
Cell number 43, Dhamma Nagabhushan, petitioner.
The petition is constructing the new house on our own site, my lord.
Will issue notice to the KB.
No, my lordship, as on this month, 5th, they have disconnected the temporary power connection, my lord.
Is it coming up for the first time today?
First time, my lord.
That's what I'll take it up in the afternoon
My
also.
lord,
if you
till
want.
then, direct them to.
Then in my court, no interim orders without any instructions. We can't pass orders like that. I'm saying I'll take it up in the afternoon.
Please.
Petition is permitted to take, petition shall serve the copy of, don't write on Mr. Devraj. Yes. And tell him that he has to get instructions. I'll call it up at 2:30. Yes, 44.
Cell number 44. Jai Krishna Bhatt.
44 and 47 are connected.
Take both.
Yes.
Yes. There is one more, my lord, which I moved in the morning.
I'll take all the 3 in the afternoon.
Yes, it's
230.
only recalling PW1.
That's what I'll take up all
Reopening and
along,
production of a
that
document.
other number, code officer.
Yes.
All the three at 230. 230, what matters I say specifically 230, those only you call at 230. Yes.
Cell
Yes,
number
next.
48.
45.
45. Cell number 45. 45.
No representation in the month of September. 46.
46.
No, I appeal for the petition in this case. Not the plaintiff writ petition, suit for declaration and possession. Not in fact, not the defendant 516 specifically denied that the existence of the property, identified existence of property.
What is the suit for?
Suit for declaration and possession.
Yes.
In the
What is the
respect
IA now?
IAM appointment of the court commissioner as ADL in order to not ascertain the existence of the.
At what stage this
And
application?
in fact, what kind of, at the time of argument, the application was filed by the plaintiff, that was opposed by the defendant 516 alone. In fact, they have taken a contention in the written statement at para 9 that there is no property existing which is claimed by the plaintiff.
Let's see. Let's see.
Lord,
See the impugned order. Where is the impugned order?
Page 58, not running page. No, relevant page 58, no, 59, sorry, 57, Mala. Relevant page of 58,
Come
para
to
2.
para 7.
The application is accompanied with an affidavit sworn by
Para
the.
7, page 61. The reasoning part.
Reason. Not the suit. This is suit filed by the plaintiff seeking declaration of title and possession of the suit property. The defendant have totally denied the case of the plaintiff. The plaintiff claims to be in possession of entire suit property totally measuring 4 acres 17 gunta. The defendant have denied the same and have contended the suit property is already converted land and TUDA has also approved the layout in the land. It is argued by the Honorable Counsel for the plaintiff that the document and the evidence on record does not clearly indicate the property as such. A court commission has to be appointed to file a report regarding the salient feature of the property and also regarding the shed constructed by him in the property. It is also argued that if the court commission is first a sketch and it would clearly identify the property. On the other hand, the Honorable Counsel for the defendant has argued that the court commissioner cannot be appointed to decide the possession of the land. The plaintiff has to prove the title as well as possession of the property on its own and not through the court commission. It is also argued with that by filing this application, the plaintiff is trying to collect the evidence and nothing else. I have gone through the entire material on record. In this case, the plaintiff had to prove the title and possession of this entire land as claimed by them. This is not the suit for claiming possession from the defendant. In such case, the demarcation of encroached
Notice the
lands.
respondents. Petition is permitted to take out hand summons. If the memo is filed by 11th of August, list this matter on 12th August.
I have sought for, in fact, the matter, may make one submission. Not in fact, after having heard the matter, the general judge has reserved the matter for pronouncing the judgment on 23rd.
No, in fact, I'm not inclined to entertain this writ petition. I want to dismiss
You'll
it.
kindly appreciate.
I want to dismiss it. Only giving you a chance, I've given a notice. If you insist for it, I can pass an order.
I would rely on the judgment. At any time, this court has taken a view that.
It is not about, because it can be, at any point of time, advocate commissioner can be appointed.
It is not advocate commission.
For whoever it is that commissioner to be appointed, not necessary that court has to appoint. It all depends upon
In
facts and
fact, not in the
circumstances.
background of the dispute, and the contention taken by the defendant.
I'm convinced with the reasoning given by the court. If you say I can pass an order, or else please take
I
a
would
notice.
I would rely on the judgment where there is a title dispute. In fact, the identity of the
Pass orders.
property.
Reserved, take that order copy, heard reserved.
Not I would like to rely on the judgment of.
Please pass on. Take that.
Before that, I would take your lordship to the written statement filed by the defendant 516.
Yes,
My lord,
give the file. Yes,
now kindly come to page, my lord, 36,
yes,
para 9. From the bottom, my lord, second, third line.
yes.
When the property of the plaintiff is not in existence. Two counts, they sought for dismissal of the application. One is the land is converted by the TUDA Another one is, my Lord, it amounts to collection of the evidence. Lord, kindly come to Lord, page 36, Lord, para 9 from the bottom. When the property of the plaintiff is not in existence, the question of encroaching the property at the of the
Yes.
plaintiff does not arise at all. Now, the Lordship kindly, Lord, they in fact dispute the identity and existence of the property. Lord, it is for me to establish before the court that, Lord, there is an existence, Lord, the what has happened is, Lord, the plaintiff predecessor in title was in possession of 4 acres. He filed an application for, Lord, conferring the occupancy rate. Lord, as against the claim of the Lord predecessor in title, 2 acres 17, 1 acre 39 guntas was granted in favor of Hanumanth Rayappa. Now, out of which, Lord, he sold certain extent, retaining 17 guntas. Now, that is in possession of the Lord, plaintiffs in respect of the social property. Now, the defendant, Lord, 516, who claims to have purchased from the first defendant, Lord, he was selected, Lord, he was granted to only to an extent of 2 acres 30 guntas. Lord, as against their claim, in fact, he claims to have purchased not 4 acres, and land tribunal is granted to an extent of 4 acres. Now, on the contrary, the material document produced before the trial court, it's only to an extent of 2 acres 30 guntas. Now, you Lord, kindly appreciate now. Lord, it is for me to establish that, Lord, there is an existence of, in fact, there are structures also, Lord, within the boundaries of the social property. And that is, Lord, now they say that during the course of cross-examination that was also disputed. Now, therefore, Lord, that was warranted for the plaintiff to make an application, Lord, 2609. Now, I would not rely on the judgment of the, Lord, the High Court of Telangana,
Yes.
Lord, 2025, Lord, kindly, the first judgment, civil court appointment of court commissioner, entrustment of the commissioner warrant, identity of the property dispute.
Para, which para you are relying on?
Not, sorry,
Paragraph, which paragraph?
not a head note I'm reading, Lord. First judgment. Not the appointment of the court advocate commissioner, reintrustment of the commissioner warrant, identity of the property dispute. High Court told that the trial court erred in dismissing the petition seeking resurvey of the suit land. The commissioner failed to comply with the specific direction in the warrant and did not obtain the allotment records or demarcate the land as per the CLTS. Held identity of the property being core issue, resurvey is entitled, direction issued to the re-entrustment of warrant and comprehensive survey using the latest technology if necessary. The commissioner report non-compliance of with the court, no, that is not relevant. Now kindly come to next page, my lord. Not the scope of resurvey, identity of land of dispute without identification of the respective parts of plaintiff.
No, we don't have to look at the head note. You can straight away come to the relevant paragraph.
So that is
Because head note is not the judgment. So where is the relevant paragraph dealing with this?
a relevant paragraph. Now findings will also get page 19. Having heard the contention of the rival contention of the parties and the scope of the CRP before the court is very limited, and very application filed by the petition is also being limited to issue which in respect of whether the court can re-allot the warrant to the advocate commission, direct the advocate commission to resurvey the said premises. And answer is whether there is any error committed by the learned judge in interfering with the court under the said revision. Though this revision is filed under Article 220 of the Constitution of India, the contention of the petitioner is that the same was filed under section. No, that is not relevant. Now, as per the trial court, para 43, as per the trial court, the learned advocate commissioner was directed to take the assessment to deputy commissioner, deputy director of the survey land, and was directed to determine the land originally allotted to the respondent number 5, that is the 1393 acres in survey number 493, Circlepet village. No doubt it is admitted fact that the said land could not be surveyed by the learned advocate commissioner for the
You are
reason.
not relevant paragraphs. You're just reading the entire judgment. Your relevant is at page 49, para 49. Please read that.
Not page.
Para 49. It's a relevant that I've already read. Yes. What is the next judgment?
Not next judgment is not the.
Which paragraph in that?
And The next judgment of the this honorable court, my lord, now kindly come to page 307, head note H.
Yes.
Not Order 26 Rule 9, local commissioner case wherein the appointment of the local commissioner is desirable. Broadly speaking, the following cases, the appointment of the court commissioner as provided under 26 Rule CPC is desirable. The dispute related to the easement of right, pathway, road, water course, etc. The dispute related to the boundary encroachment, the dispute related to the forgery, the dispute related to the existence of the otherwise as stream, ponds, drainage, water course, road, pathway, pollution or nuisance. The example given above are not exhaustive but merely illustrative. The guidelines should not be construed as having exhaustively listed the case which the commissioner can be appointed, nor the observation should be construed as having diluted the expanded the discretion vested with the trial court in such matters. Now you will kindly appreciate now. Not my submission is not you also kindly appreciate now. Now, Lord, it is for me to establish before the trial court. In fact, I've also produced a material document to show that, Lord, I'm in possession of the property. There are the building structures standing thereon. And Lord, in fact, the defendant 5 and 6, along with the other defendants, they are trying to encroach upon the property, which resulted in filing suit before the trial court. Now, Lord, except saying that, Lord, Lord, there is no existence of the property. Not that they are not encroached the property. Not in fact, there is also admitted fact. Not the property between the plaintiff as well as the defendant. Not it is adjacent to each other. That is the first defendant. Because what has been granted to the first defendant is only to an extent of 2 acres 37 gunta. Rather, in fact, his claim is to an extent of 4 acres. He has created certain seal deed in favor of the subsequent purchaser over the defendant in the suit. Now, they are not based on those documents. They are trying to encroach upon. In fact, 17 guntas have been sold by the first defendant in favor of the defendant number 5. And in respect of other defendants are concerned, he has sold it by way of sites. Therefore, whether those sites fall in the property which has been claimed by the plaintiff or not the property which has been granted in favor of the first defendant is required to be decided. Now, that is the reason why I have filed an application before the court, not the court. In fact, even other defendants have also disputed the very existence of the property. They have elaborately cross-examined. I will withstand the cross-examination of the defendant. I have also established that there is a property existing in respect of the property granted to the predecessor title. So therefore, the trial court only on 2 counts. That is, I have to establish independently and not the existence of property as well as the title is concerned. As far as title is concerned, I have also produced the document. Possession is concerned, they didn't, in fact, they say that it is part of the property which has been granted in favor of the first defendant. It is for them to establish. Therefore, a commission of warrant is commission is required to be appointed in order to assert.
Yes, heard reserved.
Bill number 47 passed over to 2000.
It is posted for judgment on 23rd.
Tomorrow for judgment. Yes.
Bill number 48, Sangamesh
To appear
Arpi.
for the petition on this matter. It's a small issue has arisen where the trial court notes directs the general power of attorney produced by me to be impounded, my lords. I am the defendant number 9 before the trial court notes.
Yes.
Lords, may I take your lordships to the impugned order? Then, my lords, I'll take your lordships to the plaintiff. My lords, may kindly come to page 16. The impounding order I am challenging, my lords. I am the defendant before trial court. Page 16, my lords, annexure A.
Yes.
Counsel for the, may I read this? Counsel for the defendant number 9 is present. Advocate for defendant filed IA number 16 under order 8 rule 1A and 3 of CPC to produce documents as per the list. To meet the ends of justice, said application is allowed. Documents are received subject to proof and relevancy. DW1 is present and further chief recorded. GPA and affidavit dated 29/1988 are marked. Are not marked because the GPA, the sale is permitted, but the GPA is not registered. Under affidavit, sale consideration is received, hence GPA and affidavit are not marked. These documents are impounded as they are not properly stamped also. Advocate for plaintiff opposed for marking of these documents. Exhibit D9 to 23 are marked. Further, chief deferred on request. But I am challenging this portion of the order where the learned judge direct for impounding of these documents. But so far as the
Which
suit
document?
is, that is the GPA and the affidavit, my lords.
So the court has rejected to take it. Where did the court say?
My lord,
GPA and affidavit dated are not marked because
are
under
not
GPA,
marked and they are impounded.
sale is permitted, but GPA is not registered. Under affidavit, sale consideration.
Other
is the same.
documents are permitted to be marked, but the GPA and affidavit are not marked. And they are impounded. my lords. Agreed by that portion of the order because I am the one who have produced those documents before.
Where do you get that it is impounded?
In the bracket, my lords, your lordships will find. These documents are impounded as they are not.
They are not properly stamped also.
Yes. Lords, now your lordships may kindly come to the plaint, my lords, the next document, page 17. I am defendant number 9 in the said suit. My lords, this is a suit filed for partition by the plaintiffs, and the defendants number 1 to 8 are, my lords, they are related to the family, they are not contesting, my lords. I am the only defendant, my lords, who is contesting. Defendant 9 and 11 are husband and wife, my lords. I appear for defendant 9 and 11 before the trial court. Lords, they file a suit for partition, claiming for partition of the suit schedule properties, where, my lords, the suit schedule property is one property at page number 25, your lordships will find.
Yes.
All that piece and parcel of the land in survey number 6/2 situated at Hennur village so and so, measuring east to west 45 feet, north south 45 feet. But this is the only property they seek for partition and also for injunction. And kindly see the prayer, my lords, page 25, the upper portion, my lords.
Yes.
B1, my lords, they will B is pass an equitable partition, separate allotment of plaintiff's 1/7 share, pass a permanent injunction restraining defendant number 9 and 10 from interfering with the peaceful possession and enjoyment of scheduled property. B1 is declare the sale deed executed by defendant number 9 in favor of defendant number 11, wide registered sale deed dated 29/7/2015 and rectification deed dated 29/12/2015. But this is the sale deed under which I have purchased. The defendant number 9 and 12 have purchased under this sale deed of the year 2015. Now, my lords, this sale deed is executed on the basis of a power of attorney. Lordships may kindly come to annexure C, my lords.
That is dated.
The
That
annexure
is the
C,
one which you are referring to now in the order.
yes, my lords. Annexure C is the sale deed, my lords, I am referring. And annexure C sale deed is executed on the basis of that GPA of 1988, my lords. Annexure C is the sale deed, my lords. May kindly come to page 28, my lords.
Yes.
Absolute sale deed is made on 29th July 2015 by HP Muniappa and HM Pujappa, represented by GPA holder C Munichinnappa. This C Munichinnappa is none other than defendant number 9 before the trial court. But this sale deed is executed on the basis of GPA, which the trial court has now directed to be impounded. Your lordships will find the GPA at page number annexure F, my lords, page 56. Of course, it's Kannada, but then the legal issue is involved is only this. Lords, the learned trial judge says that this GPA is not registered. So therefore, lords, since this GPA gives a power of sale, lords, in this sale deed, the purchasers have given the vendor has represented as a GPA holder under this GPA, and he has executed the sale deed. But the learned trial judge, lords, now says that this GPA and the affidavit, the next document, will have to be impounded. Lords, my submissions on this is, your lordships may kindly come to lords, Karnataka Stamp Act for a moment.
No, you can make your submissions, we'll see.
Yes, my lords. The Karnataka Stamp Act, lords, section 4, lords, says that if a transaction is completed by way of multiple documents, and if the stamp duty is paid on any on the main document, lords, there need not have to be stamp duty called upon to be paid on multiple documents, on all the documents, lords. May I read, lords, section 4 for a moment?
Yes.
Several instruments used in several instruments used in single transaction of sale, mortgage, or settlement. where in case of any sale, mortgage or settlement, several instruments are employed for completing the transaction. The principal instrument only shall be chargeable with duty prescribed in the schedule for conveyance, mortgage or settlement, and each of the other instruments shall be chargeable with a duty of rupees 100 instead of duty prescribed for it in the schedule. The parties may determine for themselves which of these instruments so employed for the purpose of subsection 1 be deemed to be the principal instrument, provided that duty chargeable on the instrument so determined shall be highest duty which would be chargeable in respect of any of the said instruments employed. But in this case, there are the sale deed minutes which I took your lordships at page number annexure C minutes, page 28, has already minutes culminated in a sale deed. There was a GPA, there was an affidavit where certain payments were received by the family members and they executed the GPA, and that has the GPA has already been acted upon and it has culminated in the sale deed in the year 2015, and stamp duty is already paid on the sale deed. The entire stamp duty is paid on the sale deed. So therefore, the learned trial judge again imposing duty and penalty on the GPA would not arise for this reason, because the entire transaction is under a couple of documents, and any one of the documents, if it is duty is imposed and the entire duty is paid, no duty can be imposed on each of the documents. To this effect, I also rely upon one judgment where, of course, this is pertaining to an agreement of sale where possession is delivered. And so ultimately, the sale deed is executed pursuant to the execution of the agreement. May I read para 2, in that page 4? The case arises from a partition suit where the plaintiff contend that suit scheduled properties are joint family ancestral properties with no partition having occurred. They rely on the agreement of sale dated 11/12/2002 to demonstrate that mother-in-law of the first plaintiff and grandfather of the plaintiff number 2 to 5 had offered to sell the land in question to PW2. This agreement, which includes possession, was executed with intent to transfer the property. Plaintiffs intend to use this document to demonstrate that family members are in possession of specific portion of the land and there is no severance, and they wish to place reliance on the document executed by mother-in-law of the plaintiff number 1. During the proceedings, the agreement of sale was tendered in evidence through PW2. The defendants raised objections claiming that agreement was insufficiently stamped. The learned judge, upon reviewing the objections, impounded the document and directed petitioners to pay the deficit stamp duty along with penalty, arguing that the document did not meet the necessary stamping requirements. Plaintiff argued that since the agreement of sale is coupled with possession, the document should not be impounded independently attract stamp duty, given that the sale deed was executed subsequently. The sale deed dated 29/8/2005 was duly stamped and registered, and it confers title upon PW2. The plaintiffs assert that this sale deed supersedes the earlier agreement of sale, and therefore the agreement of sale should not be subject to stamp duty or impoundment. The sale deed, which was marked as Exhibit D1, is an essential document produced by the petitioners. Article 5(1)(e) of the Karnataka Stamp Act specifies that if the possession of property is delivered.
Submits that the court has directed the GPA to be impounded when pursuant to the basing on the GPA, when a sale deed is already executed in favor of the petitioner. It relies on section 4 of the Karnataka Stamp Act. Considering the submission of the then council, there shall be stay of operation of the order dated so and so. The petition is permitted to take court hands a month and file a memo to that effect by 31st. If the memo is not filed, stay stands vacated. Yes.
Milords, insofar as the other respondents are concerned, because Milords, the respondent number 1 is the only plaintiff before the trial court. So far as other respondents, I'll file a memo.
Notice to respond, counsel for respondent number 1. Other respondents, look at it. For how many are there?
Milords, from 2 to 10.
2 to 10, same dispensed with. Give the memo. Yes.
Number 49, Basavanna. K.M. Basavanna for petitioner.
No representation in the month of September. Yes, 50.
Number 50, R. Shashidhara for petitioner.
Same.
Then number 51, Balakrishna Shastriji for petitioner.
Lord, the first defendant's
Yes.
writ petition application, Lord, allowing the amendment in a regular appeal. My lord, page 82, my lord, is the genealogy.
Suit for?
Suit for permanent injunction.
Suit is of which year?
Suit of the year 2014, my lord. Suit was filed on 4/8/2014. Plaintiff claimed there was a partition between himself and his father. In that partition, this property has fallen to him. Therefore, he is the owner in possession. We filed return statement stating that no, yourself and ourselves are co-sharers. My lord, inheriting from the same common owner, it's an ancestral property. We are co-sharers. We are in possession of the property as co-sharers. It is not in possession of your exclusive possession. His title was denied, my lord, in express terms. Trial came to be held. During the trial, PWN admits, my lord, this property belonged to our great-grandfather. Then there was no partition in between ourselves. So the partition deed which was entered into between himself and his father is not binding on us. We are, my lord, other two branches. Then PW2 and PW3 are the two other witnesses which the plaintiff has examined. They also admitted this is an ancestral property. The defendants have shared in it. Defendants are in possession of the property, the suit site. So trial court, my lord, quoting these admissions, dismissed the suit, holding that plaintiff has failed to prove exclusive ownership or exclusive possession as such in the light of the admissions. Appeal was filed in the year 2016, my lord. 9 years, 9 months have lapsed after filing the appeal. When it is posted for arguments, the present application is filed. A vague application, very simple. My lord, no explanation relating to diligence.
Shall we look at that IA, the affidavit that is?
My lord,
filed?
annexure F, my lord. Annexure F, my lord, your lordship sees at page 76. At page 77, my lord. At page 77. The affidavit, my lord, in RA, page 77.
Yes.
I humbly submit that I have filed the above suit only for permanent injunction earlier. But recently, about 2 months ago, the defendants denying my title to the suit property, whereas we have denied it on 12/12/2014. Hence, in order to adjudicate the dispute in the above suit fully and effectively, it is necessary for me.
Please come to the order.
Please, my lord.
Come to the order.
The order is annexure A, my lord. What the learned judge is even time barred amendment, my lord, can be allowed. There is court has got a discretion and power. Annexure A, my lord, your lordship sees at page, my lord.
The suit is filed for injunction in the year 2014, came to be decreed in 2016, and RA was filed in the year 2016. During the pendency of the RA, the present application is filed seeking amendment of the plaint, saying that the defendant has denied the title and they want to seek declaration of title. And counsel for the petitioner submits that when they have denied the title of the plaintiff in the year 2014, question of amending the pleadings in the year 2026 will not arise, and this aspect was not considered by the court. Considering the same, there shall be stay of all further proceedings pursuant to the order dated so and so. Notice to the respondent, same hand summons, memo by 31st.
52, Kumara KG. Petitioner.
Plus,
Yes.
petition is defendant number 6, my lords. See, 151 application came to be dismissed, saying that, my lords, as per the new act, the written statement shall be filed within 120 days.
Commercial court or the regular court?
It's a regular court, my lords. As per Karnataka.
What is the delay?
My lords, delay is, my lords, on 2/6/2026, my lords, notice was served on IA. And, my lords, on 20.
You can tell what is the delay number.
My lords, as per my case, my lords, there is a delay. Our new act is not applicable because, my lords, suit filed on, my lords, 9/4/2025.
9/4?
9/4/2025.
Amendment is in June.
Amendment is, my lords, 6/5/2025, my lords.
Please come, then counsel for the petitioner submits that the court has failed to take the written statement on record on the ground that in the light of the amended provision, the court cannot take the written statement on record beyond 120 days. It is submitted that the amended provision has no application to the facts of the case, as the suit is filed on 9/4/2025 and the amendment was on 5/6/2025. Considering the submission, there shall be stay of all further proceedings pursuant to so and so. Notice, hand summons, in addition, and summons same 31st.
Chair
Yes,
number
yes,
53,
53.
step of petitioner Harish N.R. for Kevita.
petitioner.
Yes.
But the petitioner, my lord, is in position and enjoying the property and filed a suit for declaration in the year of 2023. When the suit is pending for declaration, now the respondent herein filed a suit for bare injunction before the court on the basis of the fabrication documents.
Against the very same plaintiff.
Same against before the same court. But by suppressing the previous suit.
When is the declaration filed? Declaration suit by you?
Well, that is in December 23 by 2023.
2023.
Huh?
1/12/2023.
When is the bare injunction suit filed?
Well, February 2024, by 13 February 2024, bare injunction suit is filed. An injunction was taken. Injunction, you'll ask me kindly see the injunction, the nature, the injunction was passed at page number 38, you'll ask me kindly see. Page number, page number 38. The defendants,
Yes.
the defendants, their men, agents, servants, supports, etc., for obstructing the plaintiff carry out the agriculture work in the suit department. Now, this is an injunction was asked by the trial court by the defendant in the bare injunction suit. An injunction was granted, an appeal was pending before the sessions court by the petitioners. And page number 55, let's make it. In page number 55. As soon as they got the order of this kind of injunction, I'm sorry, again I'll come to the page number 39 and the same 39 you will see. It is made it clear in the injunction order, in the temporary injunction order, it was made it clear at page number 39. Any observation made in the above only with respect to the disposal of this application. Now you let's make into page number 55.
No, please, you have to give the numbers of the suit. Which suit is of?
Suit is the suit for filed by the petitioner hearing in OS number 313/2023.
313. That is in declaration suit.
Declaration suit.
And 81 is the injunction suit.
81 is the injunction suit.
Yes.
Injunction suit. An injunction suit, this order, that interim order was passed. That was under challenge before the sessions court. And during the pendency of the third, they have filed an application for police protection. Page number 55, let's make it. IA filed by the plaintiff under section 151 CBC by allowed. The PSI Abhinavale police station is thereby directed to provide necessary police protection to the plaintiff for the effective implementation of the order passed by the court in IA number so and so. It is made it clear that police protection shall be limited only to the implementation of the injunction order and shall not be construed as a declaration of the suit and position of the property. Now, my lord, let me kindly say, I have produced several documents before the court. I am in position enjoying the property from the last.
You will not consider because your application for against this order, against injunction order, your appeal is pending.
Appeal is pending.
That will be considered by.
That will be considered.
Yes.
My apprehension is that when this order was passed, for 39 rule 1 and 2 also they did not come to the position. Not when this police protection was order passed, not they came when my workers or laborers are working there. Not use we are managed to use amount for plantations, not the fish pond, boundaries and everything. We have all documents we have produced. When my workers are working there, they came with the rowdy elements, not trespassed into the property and threatened like anything.
But unfortunately, how can this court look into all those things?
That is the revenue authorities say. That is you will kindly see the document.
No, you are aggrieved as far as this order is concerned. There is an injunction for implementation of it under 151. He filed an application. Court has rightly granted police protection.
Police protection is granted. Now the police has reported to the court, and that they are not in position. And case was the FIR was registered.
Then the court will decide that when the report is given.
Yes.
Court will take care of.
And
it.
revenue authority also conducted.
Understand, as far as this order is concerned, there is no difficulty. There is nothing illegality with this order. Whatever the subsequent things that have taken place, No, you say that the police have placed a report, the court will
I mean,
consider.
revenue
it will-
authorities have conducted this spot measure. They also reported to the court that my lord, this respondent was not in the position.
That will be decided, no, that will be.
That observation will
that-
happen. I'll take, that observation will happen.
May,
Agreed with the.
in the
That's
year
all.
2023, there were filed suit on the
No,
basis
I
of
am not expressing anything on the merits of the matter. According to him, after the poll, after the so-and-so is appointed, the police protection is given, they filed a report before the court that you are not in possession of the property.
one submission. Right, this order impugned, my lord, passed on 11/7/2024.
7th February 2026 is the 151 order.
Order, my lord,
Order
order
51.
impugned is 11/7/2024.
So, Mr. Counsel, please understand, I am not passing any orders adverse to your interest.
Because-
So no arguments are required now.
Please, already are implemented, therefore that is my submission, my lord. Police
According
have
to-
given protection to me.
I'll record that. The agreed with the order passed in I number 5 in OS number 81 of 2024 by the JMFC at Hiryu dated 7th February 2026. The defendant is before this court. The respondent herein has filed a suit OS number 81 of 2024 seeking bare injunction. In the said suit, he has filed an IA seeking ad interim injunction restraining the defendants from interfering with his agriculture operations. That came to be passed by the court on
Injunction on 11/7/2024.
11/7/2024. Thereafter, yes, the petition defendant has carried this in appeal and the same is pending consideration. In the meantime, the petitioner has filed this IA number 5 seeking police protection that came to be ordered by order impugned, whereby the court has directed the PSI Abnahole Police Station to provide necessary police protection to the plaintiff for effectively implementation of the order passed by the court on IA number 1 and to ensure that the defendants do not obstruct the plaintiff from carrying out agriculture activities in the suit scheduled property strictly in accordance with law. And also, the police protection shall be limited only to the implementation of the injunction order and shall not be construed as a declaration of title or possession. Land counsel appearing for the petitioner submits that, in fact, the defendant is in possession of the property. And when the police went to the property for executing the order, the police have found that the plaintiff is not in possession of the property, and in that regard, they have placed a report before the court. It is submitted that the petitioner, the plaintiff who is not in possession of the property, have filed the suit for injunction and also obtained an interim injunction. It is submitted that before filing this suit, he has filed a suit for declaration and injunction on the file of the very same suit.
Adverse position. They are claiming adverse position, my lord, on that suit.
Plaintiff suit, you have filed the suit for declaration.
Yes.
And
They
injunction.
have filed declaration suit in that, my lord.
No
in the-
file.
Yes, sir.
It is submitted that on the file of the same court, the plaintiff here, the petitioner herein, who is the defendant in this suit, has filed OS number 313 of 2023,
Adverse position.
seeking a declaration of his title by way of adverse position.
In that, my lord, so application, interim application was rejected. Injunction application was rejected.
An injunction. It is submitted that in these circumstances, the petitioner, the plaintiff, the court, the order impugned needs to be set aside. Next parallel, counsel appearing for the respondent submits that in the suit for declaration filed with the petitioner herein, when he sought for interim injunction, the same is rejected. According to the land counsel for the respondent, the order is already worked out and the police protection is granted.
But order
No,
7/2/2026.
His submission.
7/2/2026.
Is worked out and the police protection is granted. Next part, having heard the counsels on either side, pursuant material non-record. Admittedly, an interim injunction is granted against that an appeal is filed with the petitioner herein, and the application that is filed by the plaintiff seeking police protection under 151 CPC is allowed by the court. The petitioner is before this court, agreed by the said order. As long as the order of interim injunction is in substance, The court cannot find fault with granting of an order to, granting of an order of police protection under 151. Now, before this court, several submissions are made with regard to the police report, and the contra submissions are made by the land council
Revenue
for
report also, revenue officer.
revenue court, and the contra submissions are made by the respondent stating that already the interim order, that the order that is granted by the court is already worked out, and the police protection is granted to the petitioner. In these, in the light of these submissions made before this court, as far as the order impugned is concerned, this court do not find any reasons to interfere. Accordingly, this court is passing the following order. This court do not find any reasons with the order impugned. Accordingly, the writ petition is dismissed. Next paragraph. 2. If the petitioner, the petitioner is at liberty to avail the appropriate remedy before the trial court with regard to the report of the revenue court.
Revenue and police.
And before the police, with regard to the, with regard to any subsequent development pursuant to the order dated, the order impugned, the petition is at liberty. Yes, this court has not expressed anything on the merits of the matter.
Much.
This is made clear that the court has not expressed anything on the merits of the matter. Yes, next.
Akshay Ramchandra, petitioner, my lord.
For the petitioner, my lord. It is a case of the petitioner before the trial court, my lord. They had filed 2 IA. One IA was filed by me under order 39 rule 1 and 2. Another was by the respondent under section 151 for restoration of status quo, my lord. So by common order, my IA was dismissed under order 39 rule in 1 and 2, which
Land counsel for the so-and-so submits that the connected MFA number so-and-so, take that, is pending before the High Court. The registry is directed to tag these matters. Yes.
Cell number 55. Cell number 55.
I appear for the
It's
petitioner.
directed to tag these matters after obtaining the necessary orders from the Honorable. Yes.
I appear for the petitioner.
Mm.
2 applications filed in the trial court were dismissed. One under Order 1, Rule 10, and another Order 6, Rule 17. The instant case is with regard to Order 1, Rule 10. The other case is yet to be posted, which has been cleared by the registry. It has not been posted. I request your lordship to
List
post
along
it.
with that tomorrow.
Tomorrow may
Along
not-
with this.
Tomorrow may not be, day after tomorrow, there's some part. I feel caveator, day after tomorrow.
You have served on the caveator, the paper?
I served.
Yes, yes,
I have
it has been.
In the other matter also?
Yes, I have.
In the
received.
other matter
I have
also?
received.
So you want day after tomorrow?
Day after.
ಅಲ್ಲ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಆಗಲ್ಲ ಸ್ವಲ್ಪ ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
On next Monday.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
Yes, 56.
Cell number 56. N. Vageshwar, petitioner.
This arises out of an application filed in the execution petition. Subsequent to the dismissal of the execution petition, the Honorable Supreme Court has granted status quo order. So therefore, the entire suit is a subject matter before the Honorable Supreme Court. Therefore, till the Supreme Court considers that matter, I think that the execution.
When is it coming?
Lord, it is
It
on
is
my
on-
11th of August.
I'll list this matter on 1st of September.
Very
Cell number 57.
Obliged.
Preeti AK for petitioner.
For the petitioner, my lord. My lord, this is the plaintiff's petition. Plaintiff had filed a suit for mandatory injunction for hosting her website on her server. And the defendant respondent had filed a counterclaim with respect to source code. There was an interim.
Defendant.
I'm the plaintiff, my lord. There was an interim order passed on multiple applications, both plaintiffs and defendants, with respect to my application under Order 39 Rule 1 and 2, my lord. It was ordered that my defendant was directed to host my website on my server. Certain facts that are necessary. Plaintiff is a journalist. She has a website running on her server, my lord. She has a web magazine running on her server. She had engaged the services of defendant to run that magazine. Defendants are technical experts who run the magazine. The magazine was running on my server. So the entire control of the magazine was with me. Since articles have to be published, I have the authority to decide what has to be done. Based on that, instructions would be given to the defendant and hosting would happen. This was all happening in plaintiff's server. Because of some invoices raised by the defendant, overnight, my website was deleted from my server and transferred to the defendant's server. Website was still being hosted on the internet, my lords. Magazine was up on the internet, but I had no control on it since it was being hosted from his server. And after multiple negotiation with respect to hosting back of the website on my server, it failed. I filed a suit for injunction, mandatory injunction, directing the defendant to host the website on my server. Defendant also filed a counterclaim with respect to source code. Interim applications were filed with respect to the same. After almost a year of filing of the suit, interim applications were allowed and defendant was directed to host the website on my server. Now this order of the trial court was not complied by the defendant, my lord. It finally came to be complied in contempt petition filed before this honorable court on 1st June 2025. An order that was passed by the trial court on 13/12/2022 was finally complied on 1st June 2020.
Or when was the order? 13?
13/12/2022, my lords.
22.
22. It was complied on 6th, I'm sorry, my lord, 6th Jan 2025 in the contempt filed by the petitioner. After the compliance, which is finally the website was, the source code was transferred to me. The website was transferred on my server and I got back the hosting. The contempt was not closed after 6/1/2025, my lords. I was permitted to check the contents of the website because by the end of the day, I should be able to host the website on my server. A mere transfer does not ultimately mean compliance as well. I tried to host the website based on what was transferred to me, and I was not able to host it, still not able to host it. However, my lord, the contempt was closed as sufficient compliance since the defendant said that he has transferred the entire source code. Though that was the entire case in the trial court of theirs, he had transferred the entire source code. A lot of history happened in the contempt which may not be relevant, my lords. But I was not able to finally run my magazine, and hence my business was down right from the time of filing of suit even till now. Now, the contempt was closed in March 2025, my lords. 17th March 2025, the contempt was closed. In the contempt, my lord, before the hosting happened, before Jan, just 1 month back, the defendant filed another application in the trial court during the pendency of contempt for implementation of interim directions in contempt for appointment of a separate court commissioner when already a commissioner warrant was issued. The Honorable High Court took a serious view of this fact and the suit was stayed. In the contempt, the suit before the trial court was stayed on 17/12/2024, my lords, till the date the contempt was disposed, which is in March, for about 4-5 months. During this time, my lord, in the trial court, nothing happened. And finally, the trial court matter was posted in June, my lords. After the contempt was disposed in March, I then filed an application, finally, for claiming damages caused to me because I was not able to host my website and hence not run the business, and compensation with respect to all the litigation costs that have happened through and through. The trial court dismissed this application, my lord, at page number 155. An important fact in this, my lords, issues were framed in this suit during the pendency of contempt. I'll tell the date.
Issues were framed, my lords, on 29/10/2024.
Yes.
I have produced the entire order sheet of the trial court. Kindly note, my lord, though issues were framed, the matter was never posted for evidence since it was still for compliance.
Take the order from para 9.
Please, my lords. May I, my lords? According to the plaintiff, the website was made inoperative by the defendants. Only after intervention of the Honorable High Court of Karnataka and writ petition filed by the plaintiff, the defendants hosted the plaintiff's website. This is actually contempt, my lord, not writ petition. Only after that, she could assess the damages caused to her. To claim the same to avoid multiplicity of proceedings and also to have adjudication on those facts, she has filed instant application to amend the pleadings as well as the prayer column. The contention raised by the learned counsel for the defendants that the plaintiff has not made out any grounds for allowing the proposed amendment application. It is their objection that the plaintiff has filed the instant application to harass these defendants and she is trying to introduce a new case. It is also argued that the application deserves to be rejected in view of the proviso to Order 6 Rule 17 of CPC that no application for amendment shall be allowed after the trial has been commenced unless the court comes
I've
to...
seen the order. Let's ask her. Yes.
Lords, may kindly have, my lord, the impugned application, my lord, which is at page number 118. My lord, the proposed amendment, my lord, which is at page number 118. Insert para number 28A and 28B is what they say. That is, my lord, much prior to the filing of the suit, which that is number 1, my lord, which they've asked. The next, my lord, which is, my lord, the subsequent event that has happened, whatever that has happened in the contempt, my lord, which they wanted to bring into the, my lord, the facts of the suit. My lord, to show, my lord, all these contents and the damages, the prayer that they are claiming, they have already pleaded, my lord, substantially in the plaint. All these pleadings are already there.
If this amendment is allowed, what is the prejudice to you?
My lord, now
it
the
would
suit
avoid
is-
multiplicity of proceedings.
Please, my lords.
The suit is pending from
21.
21 and from
My lords,
25.
they want the cause of action, my lord, to
When
be
was the
amended,
contempt
my lord.
filed?
My lords?
Contempt was filed in which year?
2024.
Contempt was filed in 2024, my lords.
So from
5/4/2024.
2024,
This damages was very much pleaded, my lord, in the suit. They say there was already a damage to the tune of 1 crore, but still, my lord, they have not sought for that prayer. They choose to file, my lord, only the suit for
Correct.
injunction.
That is what there is a delay. That's what is the application. So what is the prejudice if it is allowed to the
My lord, the
defendant?
cause of action, my lord, at the say, number 1, my lord, the cause of action, which is of the year 2025, is what they say they wanted to be amended. They say, my lord, in the suit that is filed in the year 2021, they want to amend the cause of action, my lord, to 2025. That is number 1, my lord. And number 2, my lord, coming to the prejudice, my lord. Now, my lord, my counterclaim is also there, my lord. I'll not be able to file, my lord, suit for application for 7 Rule 11 since, my lord, my counterclaim is there. However, my lord, this would go to, my lord, the commercial court for 2 reasons, my lord. Number 1, they're asking for the source code, which would form jurisdiction for the commercial court, number 1. And number 2, my lord, even the damages which they are asking for 5 crores, my lord. To substantiate, my lord, the damages, none of the pleadings they want to amend, except the prayer and 2 paragraphs, my lord.
Case, in that case, what will happen?
That will
They'll-
be my
they
benefit,
will
my
not
lord.
be able to prove
bow
their
down, my
case
lord.
and
I
it
bow
will
down.
be, it will inure to your
I bow down,
benefit.
my lord. If I may seek, my lord, for one indulgence, let the suit be expedited, my lord. 2021 suit. That will be
Why
my.
should it be expedited? What is the great reason? I'll allow this.
21 suit.
After lunch, I'll pass the order. We'll allow the writ petition. Yes.
Grateful, great.
Yes.
My lord, small submission, my lord. Serial number 94, lord.
ಬರ್ಬೇಕು ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ 71 ಇದೆ. ಸರ್ ಇವಾಗ ರೀಚ್ ಆಗ್ಬೋದು ನೋಡಿ. 230 ಇದು ಇದೆ.
ತಗೋತಾರ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮೇಡಮ್ನ ಕೇಳ್ಬೇಕಾ?
Court officer, madam.
ನಾವದೆಲ್ಲ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಇಲ್ಲಪ್ಪ. ಹಲೋ ಸರ್ ಹೇಳಿ.
Madam, list continue आ गए थे पास और मैडम फर्स्ट कहते हैं मैडम.
ಸರ್ ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್. ಮೇಡಮ್ ಯಾವ್ದು ಹೇಳ್ತಾರೆ ಅದ್ ಕರಿತೀನಿ.
Fix madam 230 ಇದೆ madam end of the list
ಅದೇ
ಏನು?
ಬಂದ್ಮೇಲೆ ಯಾವ್ದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬರುತ್ತೆ ಆ ತರ ಕಾಲ್ ಔಟ್ ಆಗುತ್ತೆ ಸರ್.
All right, thank you madam.
ಓಕೆ.
Thank you madam.
Court officer? Court officer?
continuation order.
Continuation of the list. Till number
Not list, order. I said I heard that matter.
57.
Please come. Where is the order?
Lord, page number 155.
155.
Annexure N.
Agreed with the order. Passed in. I number 19. Invoice number 7123 of 2021 by the 18th edition City Civil and Sessions Judge Bangalore, dated 16 June 2026. The plaintiff is before this court. The respondent here, the petitioner herein has filed a suit Where is your plaint?
Lord, page number 36.
36.
For mandatory injunction.
Has filed a suit seeking mandatory injunction, directing the defendants by themselves their direct injunction, claiming through the defendants to host back the website through the plaintiff's server from the defendant's server, and also to return all the materials and intellectual properties owned by the plaintiff, which is published through the website from its inception till date, and the defendants be restrained by a permanent order and injunction from using the plaintiff's website and its content for any of their personal gain. The defendants have filed their written statement and also filed a counterclaim. Where is the counterclaim?
Counterclaim prayer at page number 58.
50?
58.
Have filed a counterclaim seeking permanent injunction, restraining the plaintiff and anyone else claiming a right of authority under the plaintiff from using, making modifications, monetizing and selling the code to anyone else, and also seeking a direction to the plaintiff to pay the defendants an amount of rupees 3,658 US dollars owned until December 2021 and 250 USD for every subsequent month in lieu of repayment of invoices raised and due to the defendants for maintaining the server hosting the publishing software used by the plaintiff to publish on her website. In the said suit, an IA is filed seeking ad interim injunction, and the trial court had granted the same. When the defendant has failed to comply with the same, the plaintiff has filed a contempt, and as per the order dated 17th March 20, during the pendency of the contempt proceedings, in fact, the court has stayed the trial court proceedings. Further, it is submitted that the order partially was complied on 17th March 2025, and according to the petitioner, it is yet to comply. While this being so, when was contempt closed?
Contempt was closed on 17th March.
Contempt was closed on 17th March. Order was 6th Jan 2025, and contempt was closed on 17th March 2025. It is the case that during the pendency of the matter before contempt proceedings before the court, as the suit was stayed, nothing much has happened before the trial court. Thereafter, the petitioner has filed IA number. What is this IA?
IA number 19.
IA number 19, seeking an application under Order 6 Rule 17, whereby they want to now seek the relief of damages basing on the subsequent events that had taken place after filing of the suit that came to be dismissed by order impugned. You said the order is at?
Page number 155.
155. That came to be dismissed by order impugned, whereby the court has observed that upon perusal of the pleadings, the contentious issue boils down to ownership of source code. That is, whether the plaintiff is the owner of the said source code or the defendants or the owner of the said source code. If the application is allowed, definitely nature of the suit will be changed and cause of action also becomes different. To decide the issue dispute between the parties, subsequent events or the facts narrated in the application will not come in the way of determining the real controversies between the parties. And the court also observed that the facts averred in the proposed amendment are not necessary to decide the dispute between the plaintiff and the defendants. As such, the court is of the opinion that the instant application is not maintainable and accordingly dismissed. Next part. Learned counsel appearing for the petitioner submits that the if the amendment is not allowed, the petitioner had to file a separate suit seeking for damages, and that would unnecessarily lead to multiplicity of proceedings. Further, if this amendment is allowed, the petitioner, the defendant will not be put to any hardship. Further, he can also file his additional written statement after if this application is allowed. But if this application is not allowed, that would cause a lot of prejudice to the plaintiff. All these aspects were not considered by the court. It is submitted, all these facts were not considered by the court. Even question of due diligence will also not arise in this case in view of the subsequent developments that have taken place. Next pillar. Then counsel appearing for the respondent defendant submits that the court has rightly observed that if this amendment is allowed, it would ultimately alter the nature of the suit, and the subsequent cause of actions cannot be considered by the court while allowing an application. It is submitted that the court has rightly held that it would cause prejudice to the defendant and rightly dismiss the petition. Anything else? It is submitted that the order impugned as a well-considered order, and it is submitted that they have complied with the order passed by the court. After the complaints, the contempt case is closed. It is submitted that after the trial has commenced, this application is filed, and there is no due diligence on the part of the plaintiff, and this aspects are rightly considered and appreciated by the court, and no interference is called for with the well-considered order passed by the court. Next, having heard the counsels on either side, there is the material on record. After the amendment to Order 6, Rule 17, after the commencement of the trial, if an application is filed, the seeking amendment of the pleadings, the party has to plead and prove that in spite of due diligence, the said application cannot be filed before the court, before commencement of the trial. And that apart, when an application is filed under Order 6, Rule 17, the court will not look at the same in a hyper-technical manner. The court would be looking at what the nature of the amendment, and if the amendment is allowed, what is the prejudice that would be caused to the defendant, if that can be compensated in terms of money. Coming to the facts of this case, the suit is filed and a counterclaim is also filed. According to the plaintiff, she has sustained certain damage. She is seeking damages. Now, if this amendment is permitted, the defendant will also have an opportunity to file the additional written statement, and the dispute between the parties can be finally settled in this suit, and no prejudice would be caused to the defendant. In the considered opinion of the court, balancing the interest of both the parties, the court has rightly it is dismissed. The court has failed to consider all these aspects and dismiss the application. The court mainly went on putting that the application is filed at a belated stage and there is no due diligence. In the considered opinion of this court, in the facts and circumstances of the case and the nature of relief that both the parties are seeking, it is a case where the court ought to have allowed the application that's filed under Order 6, Rule 17. In that view of the matter, this court is passing the following order. The order impugned dated so and so is set aside. Consequently, IA number 19. 19. IA number 19 is allowed.
Make one small submission. There is an error in my prayer with respect to the annexure. Written as annexure L, it is actually annexure M.
No, annexure doesn't matter. I didn't say anything about annexures. Huh? That you will, that I have already observed. 230 matters, yes, 230. Oh,
Pass over 230, cell number 43. 43.
For the petitioner.
HP Devraj.
Copy served me.
where is Mr. Devraj? You have instructions? Huh? Please use the mic. I'm not able to hear you.
Disconnection of power supply without issuing notice. I will get the instructions, like call it tomorrow.
Just one phone call away. The moment he
That
gives
with
you
this
the,
is not that is the Kanakpuram lad that I have not.
when was
don't
it
have no-
disconnected?
5th of this month, my lord.
5th of this month. Tomorrow I'll take up. First matter, tomorrow in the first list. Please get, print the
I'll
name of
get-
Mr. Devraju. Please get instructions. No more
I'll
time.
get it.
Yes.
Cell number 44, M. Vijay Krishna Bhatt.
Yes, what are these three writ petitions?
Yes.
Or the,
In the list, there are two writ petitions.
Yes, ma'am.
21873,
or the
One more listed.
1897, and the other is, what is the number? Is what are these IS?
Lord, plaintiff's writ petition.
Hmm.
Lord, the application was filed to recall PW1 by reopening the evidence.
No, what are these numbers?
Numbers, my lord. Lord, IA number 15 is filed under 151.
No, 21873, which
Yes,
IA you
ma'am.
have questioned?
Lord, 21897 pertains to IA number 15.
Hmm.
Lord, 21763
Hmm.
is for IA number 16.
Hmm.
And other one, 21873 is on IA number 17
Hmm.
for production of document.
IA number 17 is production of documents.
Yes.
15 is for?
15 is for under 151 to reopen the evidence of PW.
16?
It's a recall PW1.
Hmm. What is the suit for?
But suit for declaration and injunction.
Hmm.
Lord, we wanted to produce certified copy of the earlier judgment in another suit
Hmm.
where I have been declared as the absolute owner of the suit property.
What is the present suit?
Lord, present suit is also for declaration and injunction. So I wanted to produce only the certified copy of.
No, in this case, you are the defendant.
I'm plaintiff. This is against another person.
Hmm.
The defendant was the
Which year is the suit?
suit year is of the 2014 Lord.
When was the evidence closed?
Evidence exact date, but
If not date,
posted for arguments.
Year, when was it closed?
Closed.
2014.
Yes, Lord. It's
Court must have given reason. Let's go to the order.
Yes.
Let's see the order.
Yes.
Come to the reasoning part.
para 7 onwards. Suit is filed for relief of declaration and permanent injunction in respect of suitable property when the case was posted for argument. The plaintiff has come up with these applications seeking to reopen the case for further chief examination of PW1 and permit him to produce the documents and thereby by condoning the delay, the affidavit, etc. The objections of the defendant that when the case is posted for plaintiff's argument, the plaintiff has filed this application to
Have you referred to the suit in your pleadings?
Not the earlier suit I have not referred.
So for what purpose you want
Not
to?
that in an earlier suit I have been declared as the absolute owner.
No.
Being a judgment in RAM, my lord, I wanted to place it on record.
Got it.
Not, it's a certified copy of an earlier judgment.
Your evidence should be in consonance with your pleadings.
Yes, no, my pleading is I am the owner. Not, it is one of the supporting document to support my contention. It's a matter of evidence.
Any amount of evidence that is adduced contrary to your pleadings.
Well, pleading in a sense,
Question
not
by
I
your
have
flaw.
said I am the absolute owner of this property on so and so
That is what
reasons.
you have filed the suit for.
So,
You have not referred to anything in your pleading.
Yes.
Suddenly now after entire evidence is completed, now you come and say that I want to file this document.
it's a certified copy of a judgment.
Might be. What is the relevancy of that? You are seeking declaration against some other person.
Some other person, wherein the entire, my title has been examined and declaration has been granted, being a judgment in rem generally of,
And you will produce it whenever you feel like.
no, there is a delay.
Notice to the respondents
I will take, no,
and summons. And if the memo is filed by 4th of August, list the matter on 12th of August. Yes,
three matters may be connected.
connect all the tag with these 3 matters. Yes, 230 matters.
Yes, 230 matters.
First you call the list matters.
230 matters. List number 1, serial number 94, serial number 92, serial number 92. Anand.
94 she called.
It will be called.
She already called, so.
You said 94, so he is ready with his matter.
92.
Yes, where is the convenience compilation
One
of all the
government
parties?
government has filed.
Hmm.
R3 also almost identical, my lords. We have done it in a chronological order.
What about yours?
I have also-
Take that, Court Officer, both.
Madam, we have served the copy.
I had filed it on Friday. I'm not sure whether my thing has come before the compilation notes.
You filed already?
Yes, Lords, on Friday itself I had
It's
filed
there?
it.
Look at it, where is it?
ಅವ್ರದ್ದೆಲ್ಲ ಕೊಡು ಇವ್ರದ್ದು
ಇದೆ.
ಅವ್ರದ್ದೆಲ್ಲಿ ಹಿಂಗ್ ಕೊಟ್ರ ಅವ್ರದ್ದು
Abhinav, I can get a copy of you.
ಅವರು
Yes, Mr. Raman. I want all of you to make precisely on the point.
Please.
How what I would like to know from you is, like, what are the hereditary rights in favor of whom it is?
Yes.
From how long, according to you, the petitioner she is enjoying? And what was the earlier statement before the representation that is given?
Time for this reason. What is also a hereditary right, my lords will have to, my lord, examine. When we use the word hereditary right, what partakes under that right also, my lord?
No, the forum is not this court to decide that. You will go before the authorities. The authorities, if they don't, if they reject your case,
My grievance is, my
then you
lord,
will come here.
yes, ma'am. My grievance is without examining that the impugned order is passed, which is why, my lord, I have also filed an application for amendment. My precise grievance is without, my lord, considering all these things, if an order is passed, lord, that will have to be set aside.
You are on the point of hereditary rights.
Yes, my lord.
Who is the ancestor who is having this right?
My lord, one Adi Narayanappa,
Adi Narayanappa.
Yes,
What is the relationship of Adi Narayanappa to the petitioner?
my lord, Adi Narayanappa's daughter is the first.
So he is a maternal grandfather of
Yes,
this. And she is the only lady or any other
no,
petitioner?
second person is there. She is, my lord, the first petitioner is related to Hema, husband's brother.
So he cannot claim hereditary, first of all. So his rights can't be considered in this case. Husband's brother.
What has happened, my lord, is these orders are being passed together in the joint names. In the joint names, which is why, my lord, since the impugned order, my lord, has both their names, my lord, both of them will have to be made as petitioners.
So as far as this second person, the husband's, what is his name?
My lord, Rangaraju.
As far as Rangaraju rights
First petitioner, my lord, he is the first.
Rangaraju's rights are concerned,
Yes, my lord.
we don't have to go into that aspect. Only as far as Hema is concerned. Hema's grandfather is Adi Narayana.
Yes, ma'am.
No, the other day, when a senior counsel was submitting that, Adinarayana's right for hereditary, whatever rights
Yes, my lord.
were rejected.
My lord, his two sons came before this court,
Hmm.
and my lord, there was a dispute. The matter was referred to the civil court, where they said, you please go and examine that. My lord, that would be slightly different from what, my lord, we are claiming here. There, my lord, two sons were there. One son was not working as a paricharak. He came before this court and said, I have got hereditary rights. Since the records did not indicate the name of the second son, as I understand the dispute, we are not
But
parties.
the first son, they said that he is entitled.
First son was, my lord, appointed pursuant to an order. Insofar as the second son, he said, I am son, and therefore I should also be given those rights. But therefore, the court relegated them to, my lord, the
So
civil
when you
court.
say that you have a hereditary right, first of all, Adinarayanappa's rights should be established. What is the document in that regard?
Lord, please, my lord, in my compilation,
Yes.
my lord, their own document. In fact, my lord said, ask them to produce. My lord, the register of the temple.
Hmm.
My lord, this is a register of the temple. Please take, my lord, page number 45. This is
Yes.
in my compilation.
Hmm. Your compilation or their compilation?
My compilation.
Yes. 45.
45.
Hmm.
My lord, this is, if my lord kindly sees, it starts from page 41.
How old is this temple?
My lord, this is very old, my lord. This is supposed to be, my lord, not even, my lord, this yuga, the previous yuga, as they would say.
Hmm.
My lord, where Lord Subramanya manifested in the form of, my lord, a serpent. So, my lord, as per tradition, my lord, they say it is thousands of years old.
So these persons who claim hereditary are because after the Endowment Act has come into force.
Yes,
After that, there is no question of hereditary
There is, my
archakatvam
lord, it
and
is
all.
protected.
So
It is
before that,
protected.
your rights must have been, you must be
Protected.
exercising those rights, which will be protected after the act. So you have to establish your right of hereditary parcharika or whatever your rights
Yes,
prior to that. Which year is that?
I'll show, my lords. I'll show,
Yes,
my.
yes.
May I
No.
just show, my lord, 45 first?
Yes, 45.
Yes, my lord. Please take 45.
Mm,
My lord, this is proceedings of the temple committee
mm.
on 25/5/2018.
That is very recently.
Quite recently, my lord, that will be in my favor because till recently, my lord, they say this is an hereditary activity.
Let's see, please read
Yes, my
that.
lord.
You have
45.
you have a translated copy to that?
Yes, my lord. 45 is the translated copy, my lord. I have put the translation.
Down,
45.
yes.
My lord, item number 3, that is resolution number 3, my lords will kindly see. Srimati D. Emma has been providing so and so prasadam in the temple and has requested to continue for the next 10 years as the period is about to end. After examining the matter thoroughly, Srimati D. Hema belongs to the priest family of this holy area and has been selling prasada for the last 25-30 years. That is, she has been doing it since 1990, my lord. That is what they are recording. Hereditarily, that is Vamsha Paramparya Vagi, as per the customs and traditions of the temple, without complaint from villagers, devotees, and the public, and by paying the money due to the temple from time to time. It was decided that this can be proposed to the Honorable Commissioner to continue the sale of prasada for the next 10 years. And in the interest of sanctity, Panchamrita Abhishekam shall be prepared
Yes.
in the room being currently prepared.
Yes, I have seen that.
Yes, my lord. My lord, this is under, my lord, the new act, as my lord says. Under the old act, my lord, how this started, my lord, is, my lord, when the temple doors were closed, persons who were coming, they were not getting the prasada items. They made a petition, my lord, to the committee, saying that when we come and the temple doors are closed, we are not able to get the prasada items. Please make some arrangement for that. Because, my lord, during the temple hours or puja hours, my lord, it is a matter of course, my lord, nobody can restrict it. The entire system of, my lord, selling this came, my lord, because persons could not come during the puja hours. The first one of that, my lord, as we have, my lord, there are even earlier to that, my lord, we have applied, they have not given it to us. Please take, my lord, document number 16.
Page number?
Yes, my lord. Document number 1, page 16, my lord, page 16. I'm reading the translation. This is also, my lord, under the old act, and this is a meeting of, my lord, the committee. This is, my lord, extract from the resolution book of the temple committee. My lord, this is the earliest we could lay our hands on. My lord, others we have applied under the RTA Act. It is, my lord, still pending. In this regard, my lord, application is given Shri Adinarayanappa, duly discussed. Currently, in the temple, prasada is available during puja time. Prasada is not available during non-puja times. During non-puja times, kalsakre, kobri, kharjura can be packed in plastic covers traditionally weighing 100 grams and should be sold in a traditional manner. It was unanimously decided that this shall be recommended to the deputy commissioner to allow the sale. It was also agreed that Adi Narayanappa shall contribute rupees 25 to the temple treasury every month.
What does it mean?
My lord,
What does it mean? Why he should contribute 25 to the?
yes, my lord. What is happening, my lord, is when I sell the prasadam, my lord, I get some income. So what they said is, out of this you contribute, and my lord, the system came about only for non-puja hours. Please have a look at it, my lord. Non-puja hours, my lord, this came into effect because the complaint was made during non-puja hours. We are not getting prasada. After all, when we go to the temple, that is how, my lord, this system of permitting Adi Narayanappa to give prasada, my lord, came for non-puja hours. During puja hours, I don't think, my lord, anybody can dispute my right to, my lord, to offer and, my lord, sell the prasada, give panchamrita, my lord. This is every temple, my lord, it happens.
So how maternal granddaughter will succeed to
My lord,
any of the rights that
That
are.
is Sheshammal's judgment is there, my lord. I'll show that 72. My lord, the priest passed away. The daughter.
He has sons. He has two sons.
Yes, my lord. Now, my lord, that
Sons are also fighting.
now
for
that distinction is removed, my lord. Article 14, the distinction between
You're
son and.
talking about 25, 30 years. That's what you're talking about.
Yes, my lord. I'm only trying to show that, my lord, this was an activity that was being carried on in the temple, and in what circumstances, my lord, this provision was made. This provision was not made, my lord, for me to give, my lord, prasada during puja hours. This arrangement was made, my lord, for me to give prasada items during non-puja hours. That is how, my lord, this came into effect.
Yes.
And this was given to me because I was the person who was doing it even during puja hours.
Yes.
My lord, in the subsequent further discussion, Mail Vicharane with the Muzarai authorities, the temple Dharmadarshi, it was agreed that this can be allowed and granted. But there is one more, my lord, subsequent my lord, resolution, which, my lord, only extends this arrangement. Please have a look at page number 28. My lord, this is again temple committee proceedings of 26/8/1986.
Yes.
My lord, page 28. With respect to the sale, my lord, this is what I read earlier.
Yes.
Granted by the special deputy commissioner in the previous year, sanction has been obtained. It is decided that similar approval may be obtained
Yes.
in the present year. So therefore, my lord, what has been followed, my lord, is only during non-puja hours, my lord, permission is being, my lord, given for me to, my lord, to offer the prasada to the deity and, my lord, to give it to the devotees. It becomes prasada only, my lord, after it is given to the devotees. It is not, my lord, sale of anything else.
Yes.
My lord, 1999, I give a representation.
Page number?
Page number 31, 31.
5/3/1919.
Yes, my lord. Where, my lord, I say that traditionally I have been doing it. My lord, what happens is, my lord, these people give representations in Kannada. Many a times, my lord, they are not worldly wise. Please see, my lord, the second paragraph. First paragraph, she has been, my lord, giving it to prasada to various. Page 31, 31. Kannada is 29. First para is, my lord, what they would say. Second, my lord, is from the time of our forefathers, the members of our family have been engaged in preparing prasada, offering to the same to the devotee as Nevedya and distributing it to the devotees in accordance with the customs and traditions of the temple. Presently, my grandfather has been granted the right to sell prasada items such as so and so in the temple by making a monthly contribution to the temple, and accordingly prasada has been distributed to the devotees. My mother Subhadramma has also been engaged in the preparation of prasada in the temple. Being a member of the same family and lineage, I also desire to obtain and continue the right to prepare and sell prasada in the temple. So, my lord, this is not for the first time, my lord, that I am trying to assert before this court. My lord, earlier also, my lord, we have said that we belong to the lineage. My grandfather was doing, my mother is doing. Please also permit me to do.
Yes.
Then, my lord,
yes.
Please then, my lord, take the temple committee, my lord, page 45 I have shown to my lords.
Yes.
Then, my lord, please come to, my lord, page 48.
Yes.
Where, my lord, a report is submitted.
48.
Yes, my lord, 48.
Yes. Yes.
My lord, this is a letter written, my lord, by the Endowment Commissioner to the Deputy Commissioner.
Hmm.
My lord, please turn to page 50.
Yes. Yes.
The temple was, note 13, my lords will get, my lord, at page 50,
Hmm.
at the bottom portion, note 15, note 13, sorry,
Yes.
page 50. The said temple was visited and inspected on 29/4/2022. During the inspection, the executive officer of the temple, the priests of the temple, and devotees were present. It is observed that the so and so, that is Panchavrata items, are being sold for a period of 5 years. But what happens is, in each of these things, whatever is the immediate previous permission that is granted, my lord, is taken. But my lords have seen right from 84, my lord, we have records to show. Then, my lord, please come to 52. My lord, the earlier, my lord, permissions that were given is noted in page 51. I will skip that, my lord. Please take 52. It is observed that Srimati D. Hema and Sri Rangaraju have paid all the amounts due to be paid to the temple as per the orders issued by the commissioner. Even though the doors of the temples were closed for about 2 years from March 2020 due to COVID-19, it was found that they have paid all the amounts due to the temple during the COVID period 19. It is found by this that they have been managing the sales in accordance with the aforementioned order without causing any trouble to the temple fund and devotee. It is observed that the Brahmin community, which has been preparing and consecrating and offering certain prasada to God and running it as per the customs and traditions followed since the past in the temple, is continuing the same even till now. Upon considering all the above facts, it is found that Srimati D. Hema and Rangaraju are conducting themselves in accordance with the 3 orders issued by the Honorable Commissioner, and points raised in the complaint given by only 2 complainants regarding the said orders are not justifiable. Further, managing the items offered to God, such as so and so, etc., is in accordance with the tradition of the temple, is compliant with the scriptures and traditions of the temple. It is not religiously appropriate to auction the aforementioned prasadas, since the customs, tradition, and practice followed in this temple, since the past have been coming prior to the have been forthcoming from prior to the Hindu Religious Institutions and Charitable Endowment Act 1997, Regulation 2002, it is appropriate to continue the said custom and tradition under Section 58.
Yes.
Since the order issued by Srimati Hema and Rangaraju is in force, sale of the aforementioned holy water, etc., by them will be continued. So, therefore, my lords will kindly see, my lord, this is a report given by the senior Agama Pandit, which is attached to the letter, my lord, sent by the commissioner to the deputy commissioner, my lord, to take further action. What it would say is, my lord, one, my lord, it is a custom, tradition, and practice being followed in the temple. Then, my lord, this was in vogue even prior to the coming into force of the act. And, my lord, most appropriately, my lord, it is, they say it should be continued as it is a custom and tradition under Section 58. Under 58 of the act, my lords will kindly see, all customs, traditions, my lord, are to be continued and not interfered, unless, my lord, there is a difficulty or problem along with it. I'll just read, my lord, 58 for a moment here, so that, my
We'll
lord.
go to the provisions, complete with this.
Yes, my lord. I'll
Take your submissions with all the material you have placed. Please complete the argument. What are the other relevant document that has to be looked into?
Then, my lord, there is, please turn to page, my lord, 71.
Yes.
Which is the order, my lord, which is now challenged before my lords. This is the order, my lord, which is now challenged.
Yes.
Lord, I will take my lords to, my lord, page 74. This is the order, my lord, which they have passed. Please see the last paragraph, my lord, in page 74.
Yes.
To verify whether the customs and traditions of the temple are being followed and to submit a report, Agama Pandits of this office were deployed to the temple on 7/8/2023 They conducted a spot inspection and submitted a report. In the report, after verifying other religious matters of the temple, they have also verified the manner in which prasada is being sold in the temple under serial number and reported as follows. In all temples across the state, it can be seen from the past that holy water and prasada are distributed inside the temple. A temple comprises of, my lord, various portions of the temple is described. Therefore, distributing holy water prasada anointed to the deity and the prasada prepared for Nevedya to the devotees inside the temple is in consonance with Agama Shastra and traditions. By providing such holy water and prasada to devotees inside the temple, divine feelings among devotees will enhance, and the importance and sanctity of the prasada will also increase, thereby creating a sense of devotion. Moreover, the place where sugar candy, panchkajaya, dates, and other prasada are currently being sold is causing public congestion. My lord, please see, after this is their order. Their order records all these things. It is being done as per customs, traditions. What they would say is, my lord, this is causing public congestion. By relocating the 3 temporary rooms counters and by placing the said prasada sale tables, boxes, counters at any suitable place within the first courtyard or second courtyard inside the temple, in alignment with the moving queue line of devotees, ensuring no hindrance to the availability of prasada to devotees, it will aid in alleviating the crowd's congestion so caused. Furthermore, it also contributes to the development of the temple. Appropriate action will be taken in above points, and it will not violate Section 58 of the Karnataka Hindu Religious and Charitable Endowments Act and rules. Presently, in the courtyard of this temple, the aforementioned prasada and articles are being sold on tables. Panchamrita is also being sold. Due to this, the smooth movement of devotees coming to the temple and temple festivals are being obstructed, and selling prasada outside the temple is not appropriate from the viewpoint of sanctity. So therefore, my lord, the entire proposal was sent saying, my lord, that prasada should not be sold in the first inside, it should be sold in the first circle or second circle, because it will aid in, my lord, regulating the queue.
What is the order?
My lord, I'll just read, my lord, what is at page 77, and then, my lord, below that is the order. As per official memorandum dated 2/6/2010, it has been instructed that prasada distributed in the form of sale in the temple shall not be entrusted to anyone through auction, and must compulsorily be prepared by the temple staff, offered to the deity, and thereafter sold to the devotees through the temple administration staff itself. Therefore, taking all the above points into consideration, following order is passed. Since the current location of the sale of ladu so-and-so, 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 being sold in the form of prasada to devotees at Ghati Sri Subramanya Swami Temple, Dodbarapura Taluk, is causing crowd congestion, this order will come into force immediately. So therefore, my lord, this is taken as an action because, my lord, it is causing some inconvenience. That is the prelude. Now, my lord, what they would say is this: as the lease period granted on lend to Sri so-and-so and so-and-so, who are currently selling the above prasad and articles has expired, they shall be evicted from the spot immediately. It is ordered to identify a suitable place within the first courtyard of the temple without causing hindrance to devotees. All these items shall be prepared through the temple administration, maintain appropriate accounts, and make necessary arrangements to sell them to visiting devotees through the temple administration staff. So this is what is challenged, my lord, before my lords. Now, therefore, my lord, the way, my lord, the prelude is there. I'll just show the, my lord, other aspects, my lord, which will aid our argument. I'll just show the arguments and then come to the impugned annexure. Now, my lords, please take the report, my lord, I have produced separately, page number 91.
Yes.
Please come to, my lord. This is the report 7/8/2023, on the basis of which, my lord, the impugned order is passed. The senior Agama Pandit, my lord, professor, visited. And then, my lord, please come to page 99. This is the entire report, my lord. I'll read page 99, my lord, in Agama Shastra.
Yes.
In Agama Shastra, preparing the prasada in the temple or inside the temple, inside the courtyard, in some mantapa room, offering it as nevedya to deity and thereafter distributing it to devotees visiting temple is in accordance with the Shastras. Accordingly, it was observed that the aforementioned prasada being sold are being prepared in a small room in the inner courtyard of the temple. My lord, this refers to all my activities. In the temple across the state, it can be seen from the past that holy water and prasada.
I think.
Sorry,
Same
my lord.
thing. It's the same thing which we have read
Yes,
in
my lord, that only the relevant paragraph was extracted. My lord, this is the entire thing. And my lord, this is what is only the last portion was extracted. And then, my lord, this is the entire report which we have now produced. Now, my lord, the latest order, which is under challenge in the second, my lord, in this background, please have a look at page number 127.
Yes.
Second case you are appearing. Second case though. I am not appearing in the second case, but for perspective, I am not arguing on the correctness of this, but I will just place it in the proper perspective. My lord, it is my submission that both will have to go together. My lord, I make that submission with. Now, please see, my lord, 137 is what is, my lord, challenged.
Yes.
My lord, please take 136, 9, serial number 9. Regarding prohibiting private individuals from selling prasada at Sri Gati Subramanya Swami Temple and enforcing regulation as per section 38 of the Authority Act. Meeting took note of the prohibition of private individuals from selling prasada at Sri Gati Subramanya Temple and the following factors. In the circular dated 2010, it is stated that since there are opinions among devotees that the system of distributing prasada in temples through tender auction is commercialized without hurting the sentiments of devotees and without affecting the temple traditions as per Agama Shastra, prasada should be prepared in the kitchen. And it is appropriate to offer the daily prepared prasada to the deity and only then distribute it to the devotees. Henceforth, in temples coming under the purview of the Department of Religious Endowments, Laddu so-and-so shall not be assigned to anyone through auction and must mandatorily be prepared on behalf of the temple. Any offering of the deity is directed to be sold to the devotees on behalf of the temple. The Supreme Court in Commissioner versus Sri Lakshmindra Tirtha Swamiyar of Shirur Mutt has clarified that prasada is an essential practice of Hindu religion and is protected under Article 26B of the Constitution. So therefore, my lord, the entire background to this is, my lord, certain private individuals are selling it, and that is how the note is prepared. The certain individuals, my lord, refer to the petitioners. My lord, I will just come to it. Therefore, my lord, in their own order, what they would say is, in 1954, my lord, the Shirur Mutt case, my lord, offering prasada and, my lord, giving it to the devotees, my lord, has been recognized as an essential practice of Hindu religion. That is very important because, my lord, Article 26B will kick in based on, my lord, the preparation and offer and the rights and persons who are doing this. The preparation and sale of prasada by private individuals is an external interference in religious practice and constitutes a violation of Shirur Mutt judgment. It is quite the opposite. So therefore, my lord, why I am reading this is, my lord, the first order did not prohibit me from making this prasada or selling it. Now the subsequent order now says, my lord, there must be a total ban, which is why I am saying, my lord, both the matters should go hand in hand. As per direction, my lord, please now see para 3 at page number 138. As per the direction in para 18 of the order dated 12/8/2024 of the Honorable High Court of Madras, it has been ordered that no contract, license or permission shall be granted to any private person or commercial establishment for preparation and sale of prasada, and excerpt of that para 18 is as follows. This is, my lord, they are referring to a judgment of the Honorable High Court in relation to preparation and sale of prasada. It has been ordered that private individuals should not be allowed to sell prasada in the temple. Currently, private individuals have been selling about 20 items in the temple for 20 years and their term expired on 2023. It is ordered with a order bearing number so and so to evict them immediately from the place, prepare all prasada items on behalf of the temple itself, maintain proper accounts and make necessary arrangements to sell to the visiting devotees on behalf of the temple. Challenging the order, petitioners have obtained an interim order in WP number 25004. That is the first petition where I am arguing. So, my lord, he cannot say you don't.
No, don't go into
Yes,
order.
my lord.
Please continue.
You don't argue the other matter.
Yes.
In the honorable court and are continuing their business. Next date of hearing is so and so. 5 regular chief priests of the temple submitted their opinion on 20th of April 2026, saying prasada made by the said private sellers has affected the sanctity of the prasada, and they do not offer naivedya to the deity before selling the prasada, and installation of machines and preparation by private individual is against the tradition of the kshetra. In light of the above factors, it was instructed to take the following action. It is resolved to prohibit private individuals from selling prasada within the limits of the Subramanya Swami temple. So this is, my lord, the restriction which they have now brought in. This restriction cannot be read into the previous order because previous order only said please relocate them. You prepare the prasadas yourself and sell it. They did not prohibit me from, my lord, preparing the prasada and selling. They said temple management will do it. Temple.
No. Please come back to that order.
Yes, my lord.
Page 71. Operative portion, what it
Yes,
says?
my lord. 77. Please see, my lord, operative portion is 77.
As
This is the
lease
current
period-
location.
As the lease period, end of it.
Yes, my lord. My lord, this is taken in the context of, my lord, relocating me outside.
So let's see that. As
Yes,
the
my lord.
lease period,
My lord, I'll read from the order portion. This is the current location of the sale of so and so, so and so, so and so is causing crowd congestion. This order will come into force effectively. My lord, if they were to only say, my lord, that my contract period has come to an end, they would not be taking into effect, my lord, crowd management and inconvenience cost.
two aspects, even for the further allotment also should be taken into consideration by.
So, my lord, it
keeping
was
them
in that
outside.
context that this was made. Otherwise, my lord, there was no necessity, my lord, to get into crowd regulations and all those things. All that.
Let's read
Yes,
it.
my lord.
No,
As the
implication
lease
of this
period granted on lent to Sri K.S. Rangaraju and D. Hema, who are currently selling the above prasada articles are expired, they shall be evicted from the spot immediately. My lord, the spot was inside the temple. It is ordered to identify a suitable place within the first courtyard of the temple without causing hindrance to devotees. All these items shall be prepared through the temple administration, maintain appropriate accounts and make necessary arrangements to sell them to the visiting devotees.
So, this order contains two parts. One
Yes.
is your license, your lease period is over.
Yes.
And second, whoever is, even the temple administration, selling it, that should be at an appropriate place to be
Appropriate.
identified.
Yes, my lord.
So.
This does not say private individuals, so-called private individuals or any other person associated with the temple cannot henceforth sell prasada, my lord. That restriction is not there. That restriction.
So it clearly says that it should be done by the temple.
My lord, it should be done by the temple administration, my lord, is what they can also do. My lord, they are saying, okay, there are other persons doing it. Temple administration should also do it under accounts. They are not saying you stop. What they have told me is you please vacate this place. You identify appropriate place in the first prakara.
Whatever they might have told you, but if you look at this order, a reading of the order says that you should be immediately evicted because your lease is completed.
Yes, my lord.
And
They are attaching the lease, my lord, to a specific place. My lord, that is the mistake which they are doing. They are not attaching, their concept is, my lord, lease means a place. So since the lease period is over, you don't carry out your sales here, you go to the first prakara.
According to you, what this order says?
My lord, according to me, what this order says is, my lord, the lease period is over. Whether it is over or not, my lord, is a different aspect. We'll take it for granted that, my lord, for the sake of arguments, it is over. What they would say is, your lease period is over, so you are evicted from here, go to the first prakara, and then, my lord, the sale of items prasada will be through the temple administration, and you please maintain accounts and sell, let the temple administration sell it. So therefore, my lord, it does not say that.
Why I am not able to understand the same manner in which you are.
Yes.
Maybe your English is the same, but I'm understanding it differently.
I follow, my lord, which is why, my lord, if this was all.
It is in two parts. It is
Two
in
parts.
And
my
it
lord.
never said that to continue.
Yes, my lord.
You, the petitioner.
It doesn't say continue the petitioner because I don't have to be continued by them, my lord. This is a customer right which I have,
Yes,
my lord,
yes.
which is why I'm pointing my lords to the subsequent order where they're for the first time saying private persons, my lord, are prohibited. That, my lords, will not get it in this order.
Yes, yes.
Which is why, my lord, I read the subsequent order.
141.
139. It has been ordered that private individuals should not be allowed to sell prasad in the temple. That is not there, my lord, in this order.
Yes.
Of course, my lord, it can be inferred or treated that, my lord, the same meaning would also apply to this order. But, my lord, if the context is seen in which the order was passed, which is why I read the previous paragraphs, my lord, that is not the context.
Yes.
Now, my lord, please see para 4.
Yes.
I was reading para 5.
Yes. 6 also.
Yes, my
summon
lord.
up the-
My lord, this is, my lord, if there is already a restriction, my lord, in the earlier annexure, which is under challenge, my lord, there was no necessity to issue this. My lord, if that all, by implication, my lord, if it said that private individuals are not supposed to prepare prasada and offer it, there was no necessity to issue this afresh. Therefore, they refer to Shirur Mutt, my lord, case. They say there is a Madras High Court judgment. Private individuals should not be permitted to prepare prasada and sell it in the temple. That is the background, which is why, my lord, the enforcement of the stoppage of prasada comes in for the first time. That is not the prelude in the previous order, which was my respectful submission, which is why, my lord, I am reading both the orders. My lord, 6.1, it is resolved to prohibit private individuals from selling prasada within the limits of Ghati Subramanya temple. My lord, if this was already there in the previous order, they wouldn't have passed this, my lord, by referring to all the judgments. Therefore, my lord, by implication, my request to my lords is, my lord, please treat that this is not there as a part of the previous order, or else there would be no occasion for them to, my lord, introduce it here. Then, my lords, will kindly see 2. It is instructed to prepare and submit draft rules to enforce regulations in regard by notification by the government as per section 38 of the new act. Private individuals have been selling prasada for about 20 years currently, and even though the term has expired in 2020, they are continuing by obtaining an interim order in the writ petition. Therefore, action shall be taken to bring the fact of prohibition of private individuals from selling prasada within the temple limits by the current authority to the notice of the Honorable Court and get the writ petition disposed of. This, my lord, clearly answers my interpretation to this. What they are trying to say is, please bring this restriction to the notice of this Honorable Court, thereby meaning that even outside the sanctum sanctorium, that is in the first prakara, they are now restricted from selling prasada. Please bring this to the notice of the court and get the writ petition disposed of.
Yes.
So if the orders are read, my lord, conjunctively together, what it will emanate is, my lord, restriction in terms of preparation and sale is by this order. Otherwise, there was no necessity, my lord, to bring about this. Why all this is being done, my lord, is
Yes.
there are, my lord, persons who are interested to, my lord, take over this, which is why, my lord, despite there being an order, interim order, my lord, the executive officer, my lord, does not permit me to, my lord, tender these, and which is why, my lord, a clarification was also sought at the hands of this honorable court, and this honorable court came down quite heavily on the temple administration, my lord. This is nothing but vendetta. My lords will kindly see, my lord, the order sheet where, my lord, this has been made clear. My lords may kindly take that order sheet portion, my lord. I did not put it into the compilation. Since the interim order was not, my lord, obeyed, Lord, please come to page 79.
No, I can look at the proceedings, which order dated.
My lord, please see the interim order dated 15/11/2023. And then, my lord,
Yes.
the order dated, my lord, 6th of December 2023.
Yes.
And then my lords will take the order dated 10th of January 2024.
Pause or impose? I think we have seen this order.
Yes, my lord,
earlier.
10th of, Lord. So therefore, there has been always an effort, my lord, which they are not explaining why, to always obstruct it, and my lord, to see that my activities are disrupted. All this is, my lord, not any regular exercise of powers, my lord. They have always been trying to, my lord, do it. Then, my lord, there is also a pending application, IA, my lord, 2 of 2026, where, my lord, they cut off the power supply, and they, my lord, come in the way of, my lord, my activity, which is why, my lord, on 17/2/2026, my lord, an application is filed saying that, my lord, the power supply should not be cut off, and, my lord, in that way indirectly affect the sale of prasada. My lord, IA 2 of 26, my lord, all these things are, my lord, indicated, and
Order was dated.
sorry, my lord,
Order was passed.
order is not passed, my lord, it is still pending. Application is still pending.
Yes.
Because the cause list also does not show IA 2 of 26. My instructions are it's not been served also.
Then there is a pending amendment application. Then I knew this will come, therefore I put it in the compilation.
That compilation, my lord, without serving.
My lord, if they are objecting on this, my lord, the order sheet may be seen, my lord.
Yes. Next is IA number.
My lord, IA 1 of 25 for amendment. Where, my lord, I want to bring in two aspects. I have, my lord, filed the application, my lord, as a in the convenience compilation, page number 153. I want to point out two aspects. One, my lord, that the prasada should be, my lord, served inside the permitted to be sold. Please take 155. What is, my lord, I want to include, my lord, 2C, is that, my lord, it should be inside the temple itself. I rely on the Agama Pandits, my lord, two reports, which I just read to my lords. And then, my lord, I draw a parallel to other temples, para 2D, my lord, page number 155.
Yes.
2C, my lord, 2 Agama report, Pandits report, my lord, which I showed to my lords, I will not repeat it. 2D, the petitioner further submits in that in all famous and sacred temples in Karnataka, like Kollur Mukambika, Katil, Dharmasthala, Chamundi Betta, etc., prasada and other religious items have been given and sold inside the temple, and has been the tradition for the past several years. Nowhere in any temple a prasadam or religious item has been given outside the temple. Gati Subramanya has been one of the oldest temples with a lot of history and tradition. As far as extension is concerned, so and so. So therefore, I want to introduce this, my lord, saying that the prasada has to be sold inside the temple, my lord, and that is the requirement of the Agama Shastra itself. In all other temples, when this is being permitted, why, my lord, this is being denied is one thing I wanted to, my lord, raise. And then, my lord, a suggestion was made, my lord, at the instance of the special counsel, not, my lord, my friend here, the previous predecessor of my learned friend, as to why, my lord, and additional advocate general, as to why, my lord, my activity should not be shifted outside the temple, and they would permit me to sell the prasada outside. My lord, that order, I'll just give the page number, my lord. I made a note. Lord, please take page 86, my lord. 86. This is the submission that they made. On 2/6/2025, page 86, my lord, it is an order of this honorable court. She so and so learned the senior counsel would submit that the petitioners have no right to continue the shops in the temple, which is earning itself by earning all puja material, sum of rupees so and so. The learned counsel appearing for the petitioner submits that Kukke Subramanya temple has extended the lease of shops of the kind that the petitioners are holding for a period of 4 years, subject to increase of 10%. Shri so and so learned counsel would suggest if the petitioners are willing to shift their shop outside the premises, they would be permitted to continue. So therefore, their problem at that point in time was not about my sale. It was about the place of sale, which is why they said your period is over by sale, by termination of the lease. The learned counsel appearing for the petitioner seeks time to secure instructions. Interim order is extended. So therefore, even during the pendency of this honorable court, the submission is you please sell it outside. We will not come in the way, but you please sell it outside.
Yes.
So my right to, my lord, offer and sell was not disputed even during the pendency. Now, my lord, now they are trying to give it a different color. It is only after this, my lord, that the order came to be passed, which I just now showed by the authority, my lord. Now, my lord, earlier it was the 1997 Act. Now the temple is, my lord, governed by the new Act, my lord, which I have produced at page number 217. Now it is governed by this Act. The English portion, my lord, commences from 237. My lord, one aspect, my lord, which would also require the interpretation is, since this is an order passed under the old Act, that is what is challenged in the present writ petition, and having regard to the fact that a new Act comes into force during the pendency of the writ petition, my lord, will that order still survive, or would any order have to be made under the new Act? That is one interpretation, my lord, which will arise, question that will arise for my lords. Then, my lord, page 244.
Yes.
Please see section 19. Notwithstanding anything contained in any custom, usage, or provisions of any law for the time being in force, under which Sri Ghati Subramanya temple is governed, or the provisions of the Karnataka so and so Act.
You're reading?
My lord, section 19, my lord, 19,
Yes.
page number 244, my lord.
Yes.
Notwithstanding anything contained in any custom, usage, or provisions of any law for the time being in force, under which Sri so and so temple is governed, or the provisions of the earlier Act, the ownership, administration, and complete management of movable and immovable properties, including jewelry liabilities of the temple, will vest with the state government from the date of commencement of this Act, and shall be transferred to the authority later. So therefore, my lord, everything stands vested with the state, and only after the state, my lord, gives a notification or transfers it to the authority, my lord, authority gets control, my lord, to take action in relation to all these things, notwithstanding any custom. So therefore, my lord, of course, in the second writ petition, the question that will also arise is whether this transfer has happened to the authority. Because, my lord, now currently, as per the provisions of this section 19, it is vested with the state. State must transfer it to the authority. Therefore, my lord, the temple authority as well as the state must now show how it was transferred, when it was transferred, what are the powers that were transferred, because that has a bearing on, my lord, the order of 18/5/2026, which is challenged in the second writ petition, which completely prohibits me from, my lord, the sale of prasada. Then, my lord, one other provision which may be, my lord, necessary for my lords to consider is, my lord, page number 249, the very same enactment, my lord, section 39.
Yes.
Notwithstanding any compromise, agreement, scheme, judgment, decree, or order of the court, or of any authority or any custom, usage governing Sri Ghati Subramanya temple, the provisions of the Karnataka Hindu Religious Institutions Charitable Endowment Act and the rules shall prevail. This is important, notwithstanding the fact that new act comes, shall prevail in so far as they relate to religious practices of Sri Ghati Subramanya temple, Ghati Subramanya village, which shall remain as a notified institution under the provisions of the old act. Of course, my lord, this in the second writ petition they'll take up. When this, my lord, is read in, And they said all usages, religious practices as under the old act is allowed to continue. Whether the order of the kind, my lord, that is made in May 2026, challenge the second writ petition, my lord,
Yes.
can be made.
Yes.
Now, please take the statutory provisions, my lord.
Endowments Act. Give the act. Yes.
My
Which
lords will
provision?
kindly see. Please turn to section 58. Lord, my respectful submission is section 58 is still, my lord, saved in view of 39 of the new act, my lord. Please turn to, my lord, section 58.
Yes.
The commissioner, the deputy commissioner and the assistant commissioner and every other person exercising powers or performing functions under the act shall not interfere with and shall observe the customs, usages, ceremonies and practices appropriate to the notified institution or declared institution in respect of which such powers are exercised. So this has two parts, my lord. One is they will not interfere. Number two, there is a provision which says that they shall observe all customs, usages, ceremonies and practices in relation to any notified or declared institution. My lord, this is 58 which the Agama Pandit, my lord, refers and says, Lord, this must be continued. Now, my lord, please see, coming to the order, my lord, before I go to the judgments.
Can I just take leave? I'll come back before he finishes. Some matter is reaching.
Lord, annexure H, which is challenged, my lord, is not passed, my lord, without giving any opportunity to the petitioners and without holding any inquiry. Annexure H, which is now challenging the first writ petition.
No, that is after the expiry of the lease. You have a lease or not?
My lord, my lease is not expired because, my lord, I said there is extension that is given because of COVID. You must consider that appropriately. That is why, my lord, the writ petition came to be filed. Now, in the peculiar facts of that case, my lord, notwithstanding, my lord.
Oh, but the difficulty is all these things cannot go together. Your lease, your hereditary rights. When you have a hereditary right, question of issuing a lease will not arise. If you have a lease, you are bound by the lease.
No, that is what, my lord, I'm trying to, my lord, emphasize. My lord, my hereditary rights, my lord, I can exercise during the puja hours. Nobody can stop that, my lord, because it is between me and the deity. Offering prasada is something between me and the deity. And only after, my lord, it is offered to the deity will, my lord, the devotees partake it as prasada. I cannot, my lord, manufacture something, prepare something and give it. So nobody can come between myself and the devotee, my lord. That is an essential religious practice. That cannot be, my lord, restricted or.
There is, now it is like this. You are doing some service.
Yes,
as a hereditary paricharika or whatever it is. Now, by selling the prasadam to the devotees, are you doing a seva or is there anything monetarily it is you are receiving
Lord,
something?
my respectful submission is both. Lord, unless I offer it to the deity, it doesn't become prasada. It is like any other food item.
For example, once the act comes into force,
yes,
and when there is a equality, the constitution also comes into play. In that case, how can one person, you can enjoy your right to offer prasadam to the god, but you cannot sell it commercially and say that it is my hereditary right. Now the temple has expanded, I will sell it to everyone, and whatever the proceeds I will alone be taking. It is my hereditary right. That the constitution don't permit.
Yes, my lord. Which is why I said, my lord, the first order says the temple management should do it. I am not challenging that portion of the temple order which says, my lord, they must independently, my lord, sell the prasada. I am not saying, my lord, I should be given monopoly rights or exclusive rights. But my lord, can the state, my lord, prevent me from doing so is the question.
So is it your submission that I have to take that you are not concerned with selling of prasadam to the devotees, you are only concerned with offering the prasadam to the deity? They are two different issues.
My lord, it is the same transaction, my lord, same part of it, my lord.
You will prepare, but you will not have the revenue out of it.
I will prepare it and offer it to the deity. Yes, my lord.
Deity,
Once, my
that
lord.
is a hereditary right
Yes,
to
my
do
lord.
it.
Yes, my lord.
But selling it to the selling it to the public on some amount is not a hereditary right.
My lord, that nobody can. My lord, that ownership of that prasada, my lord, to whom, my lord, on that point.
That can't be. That is not called hereditary right. Hereditary right in terms of
My lords
monetary
may
terms.
take any temple, my lord, anywhere. My lord, what?
Once upon a time in TTD temple, this was there. All the archakas were having all kind of rights in everything because they were having it hereditarily. But that was recognized by the Honorable Apex Court.
My lord, that was taken away by a legislation. If it is taken away by a legislation, my lord, then it is a different.
So first of all, in this case, you have to establish your right. So far from the material on record, I am not convinced that you are having a hereditary right.
My lord,
anything else, first of all, you clarify that because that's the whole basis for your case
my lord,
about
what?
your hereditary right.
Yes, my lord.
That I am not convinced so far.
Yes, my lord. I'll try to, my lord. My lord, what is not in dispute is, my lord, these activities are being done. We will come to the hereditary part a little later. The fact that Adi Narayanappa was
No,
doing.
problem is because at somebody's convenience or somebody's, like they're conveniently accommodating you, you're doing something that itself will not create a right in you.
Yes, my lord, I follow what my lord
you have to show from where you're, because some officer is giving you, now he gives from here, next 50 years, if lease is granted in favor of somebody, that will not become hereditary right. Hereditary right is something which has to be established as per the provisions of the act. And act or not the usage or whatever it is. So you continuously giving prasada for 50 years also.
Yes.
That can't be called hereditary right.
My lord, I'm coming to that point. My fact that, my lord, I was preparing prasada, offering it to the deity and giving to people, my lord, is not in dispute. All the records would show that. It was Adi Narayanappa, my lord, later his mother, and then it is me. Whether, my lord, it will flow through the female progeny, my lord, I will demonstrate. That is a separate aspect. That is, again, a legal contention. Fact that I was doing these activities, my lord, is not dispute. Now, how does it become, my lord, hereditary? Now, their own circular says either I should have done it for 3 generations or I should have done it for 100 years. Their own circular, my lord, department circular is there, which I can place it before my lords, which says if I have done anything, my lord, continuously for 3 generations, my lord, I have been able to show from their own records. Adi Narayanappa was there, then my mother is there, now I am doing it. So 3 generations, my lord, we have done it.
So from one family, how many persons will be there in matter of?
My lord, what happens, my lord, if there are more numbers, then there is something called a rotation, my lord, which they will bring it. They call it Sardi.
So already your uncle is already there in.
No, he is not doing this, my lord. He is claiming the right, my lord, of, my lord, inside the sanctum sanctorum, my lord, there are various other responsibilities which are given to Parichara. He nowhere claims, my lord, they have not produced anything till today, which says that he is doing out the activity of preparation and, my lord, offering the prasada. There is nothing on record, even in their statement of objections or anywhere saying that the 2 sons of, my lord, Adi Narayanappa were doing this. That is not their case at all.
Now, is it officially recognized by the state that after Adi Narayanappa, his daughter is doing?
Well, I showed, my lord.
That is the
temple committee,
that is your no. That is your representation.
No, my lord. Temple committee proceedings are
my
read
mother
out.
is doing. After that,
no, temple committee proceedings, my lord. Temple committee.
Say, show it. Which page?
My lord, 45, my lord.
Yes.
45.
Yes.
After examining the matter thoroughly, page 45, my lord, the 4th line. After examining the matter thoroughly, Srimati D. Hema belongs to the priest family of this holy kshetra and has been selling prasada for the past 25-30 years hereditarily. Vamsha
By
Paramparyavagi.
using a word hereditarily, it will not become hereditary at all.
My lord,
You
that is
have-
not their case, my lord.
have to-
Unfortunately, that is not the case, my lord. If they were to say,
No,
my
now
lord,
the issue has come. So we have to examine independently. Whatever they say in their proceedings, it won't become the.
true, my lord, but they don't say, my lord.
Here in this proceedings,
Yes, my
where did they say about your mother?
lord, about my mother.
You only said in your, if I remember
Lord,
reading
what?
it, you only said in your representation that after him, my mother was doing. Now I may be permitted to do is your representation.
Yes, true, my
Yes.
lord.
Page 29.
True, my lord. That is my representation. My lord, therefore, when they say that, my lord, I have been doing it hereditarily, my lord, it assumes that, my lord, I have been doing it generations, my lord,
That's
uninterruptedly.
what, now they are denying it. You have to,
Now,
you have to
that-
place a document.
My lord,
You are asserting your right.
yes, my lord.
And
Now,
according to you, this temple is thousands of years old or hundreds of years old.
yes, my lord.
You show something from the year 1980 and you show something of 1990, the periodical lease, in respect of hereditary Achka, no lease is required. If that is the case, if they recognize you.
Yes, my lord. That's why, my lord, I'm clarifying. No lease is required, which is why, my lord, I read the proceedings of the 84.
So now you are making like two submissions. If that's what I want
Yes.
facts or clarity. According to you, as far as offering prasadam to the deity is concerned, it is an hereditary activity and nobody is obstructing you.
During puja hours.
During puja hours,
Yes, ma'am.
nobody is obstructing.
Yes, my lord.
And as far as the second one is concerned, that is recognized by lease. Not selling the prasadam after the puja
Yes, my lord. The
hours.
sale of the prasada takes place, my lord, even during puja hours. Sale of the prasada takes place even after, my lord, puja hours.
So according to you, after the puja is a lease.
Not puja, my lord. After puja hours. That is, my lord,
After
after
puja
the
hours,
yes,
after
ma'am.
puja hours,
Yes, ma'am.
that is a lease given to you.
Yes, ma'am.
According to you.
Yes, ma'am. Yes, ma'am. Yes, ma'am. That is how.
So as far as that aspect is concerned, we don't have to go into the hereditary aspects from your submissions.
My lord, what I'm trying to submit is this. If they want to regulate the place at which I must sell, they have got all the rights, my lord.
No. That is a different aspect. We shouldn't mix all this unnecessary
My lord,
confusion.
it is.
I said,
It is.
as far as offering prasada to God and selling the prasada during the time of, during the puja hours is your right.
Yes,
For that, no lease is
No,
there.
my lord. No, and
And
they have
as far
not,
as
they have
selling
not
the,
restricted me
as
as
far
well.
as selling the prasada
Yes.
after the puja hours is a lease. There is no hereditary right for that.
There is no hereditary right, my lord. It is hereditary right in the sense, my lord, I can continue to sell it. But where I must sell it, my lord, they can regulate. On what terms I must sell it, my lord, they can regulate.
Even assuming that such a right can't be now, every person, everyone has their a person, you know, how much, what would be the monthly income to this puja activity?
Kindly come to my
This prasada,
page number 12, page number 45 in my compilation, lords.
how much it is?
4 crores 2 lakhs is the annual income. The first petitioner would get an company recorded in his name, Sri Skanda Services, K.S. Rangaraju.
4 crores 50 lakhs
4
per
crores
annum.
2 lakhs 5,135 including GST is what he has declared for the year 2022-23. This year's it is much more is what I am being told. Lords. Here,
And state is just watching
Lords,
it.
that's the I wanted to come to that, Lords.
Yes,
please.
I'll find. Yes. So according to you, selling a prasada for these much of this much of revenue generating should be your hereditary right, and nobody should interfere with that.
That's what I'm saying, my lord.
That's why I want you to make the distinction between the two. If you say that this is one and the only, both are on the same.
My lord, both are on the same footing up till one aspect, my lord. My lord, offering prasada to the deity, my lord, whether it is during the puja hours or after puja hours, my lord, will not matter because I can offer it to the deity only during the puja hours.
No, once the temple is a notified temple.
Yes, my lord.
The government or whoever is in the administration of the temple, they should continue the rituals or whatever the procedure that applies, they should do it.
Yes, my lord.
But on this, the selling the prasada and all, it is an administrative act.
No, my lord,
It is not. No. You prepare it.
Yes,
You
my lord, I prepare it. I prepare.
But You prepare it, but you can't sell it on your own.
No, my lord, that is an essential part of the prasada, my lord. I'll be able to show.
Then you give it, then you distribute it, you won't sell it.
My lord,
When
now,
the
my lord,
selling
when I give
component,
it,
when the selling component is there and the money is generated out of it, you cannot claim it as a hereditary right at all. Hereditary right pertains to your whatever the procedure that has to be followed in respect of doing pujas and what kind of prasadam should be offered to the deity. It's a different aspect. Under the guise of this, if you are earning this much of crores and say that it's
no,
my right,
that is not correct, my lord. I'll point out that that is not correct.
we will not, I'm making it very clear. I'm on the face of it, I'm not convinced with this submission at all. And we will not let these kind of arrangements to go on.
My lord, this is happening.
How can the government be so quiet
My
for
lord,
these
my
many
lord,
years?
I'm only
letting
asking,
somebody to do
I'm
it
only
like
asking
this?
the government one question, my lord. Is this the only temple, my lord, where they are doing it?
They should do it in every temple.
Yes, my lord, exactly. Why, my lord, pick and choose this temple, my lord? My lord, if they are permitting this to happen, my lord, in all temples.
What has come before this court, that only the court can look into.
Yes, my lord, but then,
And
my lord,
file a public interest litigation
no, my lord,
about what's
but my
happening
lord,
around.
but my lord, I can definitely request this court to see their conduct under Article 14, where they would permit this similar activity.
Article 14 not with equality can't be on this kind of
Lord,
illegality.
if a paricharak, my lord, is able to do this in other temples, why is a paricharak in this temple, my lord, being denied
That's
an
what I
opportunity
said.
to do this?
I am sitting in this floor, so I can only deal with what is before me. So you have to take it to file a public interest litigation. They have to respond to that. No, as far as the list before me is concerned, it is absolutely not permissible that somebody should do it. So that's why I want you to argue on two aspects.
Yes, ma'am.
One, about your right to do
Yes, ma'am. I
prepare
follow,
the
ma'am.
prasada
I want to show
and
that.
to sell the prasada.
Yes, ma'am.
Two aspects.
Yes, ma'am.
No, as far as you are doing it something because it's your faith in the God and you're being the devotee and doing it or being a part of the temple, that's a different aspect.
Yes,
which has to be recognized as per the act.
My lords are asking me to give an answer specifically with regard to what happens to the prasada after it is offered and how I will be entitled to sell it.
Hereditary achakatvam also includes selling selling the prasada for crores of rupees.
Not crores, my lord, what happens is, my lord, when I give prasada,
it is more or less like a business.
My lord, I will tell why it is like a business. My lord, what happens, my lord, is, my lord, kindly take a situation where, my lord, the priest or the paricharak, my lord, gives either tirtham or, my lord, flowers adorned to the deity. My lord, he does not say, my lord, of course, in some temples abroad, North India, my lord, they demand. But when, my lord, the archak or some gives prasada, the devotee out of his own free will, my lord, gives, my lord, something to the.
No, from what you are submitting, then all the priests who are doing in Karnataka, they are very, very fortunate to belong to Karnataka.
Well, that is an
5
essential, my lord, practice and custom. My lord, it happens in all temples all over the state. Now, what, my lord, where this sale is coming is, my lord, they are the persons who said, please give 25 rupees. My lord, they were the first persons to say, please give 25 rupees. My lord, I cannot rob Peter to pay Paul. So if I have to pay 25 rupees, my lord, which was then fixed in 84 and subsequently, my lord, enhanced. But that means they did recognize it as an income-bearing, my lord, activity.
So now what you do, you
it
pay.
is there, my lord.
What is
if
that?
They had said, please don't sell the prasada for any amount, my lord, that would have been different.
How much you pay to the temple? You don't pay anything to
no,
the
I have paid, my lord. I have paid.
pay? As of now, what are you paying?
My lord, as of the last year, my lord, I have paid about 23 lakhs, my lord.
What is your income?
Income, I will just check, my lord. They have produced some document. Income, I will just check. And this is something that they have fixed. That I must pay this is something that they have fixed. I have paid, my lord, 23 lakhs. Proof is also given, my lord. Page number 206 is also.
Now let's please come to the judgments and the provisions. 58, you're relying on any other provision?
Can I continue day after, my lord? Thursday, my lord. Let me just answer this question where I am entitled to.
But my difficulty is see how many people are waiting. I have
Lord,
such a
may
long
I just request this, my lord?
list.
Can my lords take it up at 4 o'clock after the usual list, my lord? so that, my lord, the others are not hindered.
No, you continue today. You can answer it next day.
Yes,
I can only on that aspect you can answer later.
Yes,
Then what about the other provisions you're relying on?
Now, my lord, the document which, my lord, my learned friend produced, my lord, please see the document, my lord, 4 crores. My lord,
No, anyhow, Thursday it's coming, no? Let them make a statement before the court by way of an affidavit.
very well, my lord, whatever, my lord.
Whatever it is, then we will see.
Yes.
Yes.
Lord, this document which they have produced, as my learned friend, my lord, pointed out, is in relation to, my lord, Sri Skanda services. It is not in relation to, my lord, what the Paricharak is doing. It is in relation to, my lord, some other business entity.
Who is that? Mr. A?
That's the first petitioner. I'm told he is the one who's having another 3 more temples. One is called Vidrashwata on the way to Madras, then 2 other temples in Bangalore. He is the only one who has been doing
No
it.
difficulty, my lord. I will file an affidavit of, my lord, what they have produced as a response.
It is their document which we have produced.
Yes, my lord.
Both petitions.
Sri Skanda services.
I have the present thing, my lord, from May 1st to 19th of July. They have collected 54,72,295 from 1st of May to 19th of July.
1st of May to 19th of
19th of July, 54,72,295.
Yes. Now, any other provision from the Act?
My lord, act, that is the only provision.
Any judgments?
Judgments, my lord, I got it. I'll prepare a compilation, my lord, and give it to my lords with paragraph numbers. My lords may hear them. On that day, my lord, I'll give it. I have got it.
Yes, Mr.
Yes, lords. First and foremost, lords, my humble submission would be their application with regarding to an amendment seeking hereditary rights is still pending, lords. That is not yet.
Who has,
The petitioner.
I have filed that application.
1 minute.
Which is what I showed, my lord. I ate.
Who has filed?
I have
There are
filed.
2 petitioners.
Yes,
Hema
lords.
filed.
No, my lord, both the petitioners.
Seems to have.
He is also, being a the brother-in-law of some granddaughter of so-and-so, he'll have hereditary rights.
Lord, the amendment is sought to indicate about the place of, my lord.
Hereditary rights is saying about.
That's the IA which is filed.
IA that is
Seeking an
filed.
amendment that they have an hereditary right. That application is still pending adjudication.
That anyhow, I will not consider that application because that's not.
If that is not considered, my lords, then the hereditary, whole argument on the hereditary would go off, my lords.
Basing on the material, which if it presupposes its submission, then I'll say you go before any other authority where it is available to you. So I will not be deciding about their basing on the material. Prima facie can I come? Still, I will not be giving a finding that they are hereditary archakas because that is for a forum which has to do, and anybody aggrieved by that will come here. Yes. So.
Yes,
Then now, what is the procedure under the Act to, if somebody says he is having hereditary rights, who will determine that?
My lords, may kindly permit me to come to page number 9, my lords, of
Sign
my
off
compilation.
Your compilation.
I'll take, my lords, from the first itself at page number 7, which would be the genealogical tree of this Adinaranappa.
Yes.
Yes, my lords. It would be Adinaranappa and his wife, 2 sons, Adishesha and
Not
Shankaranaranappa has 2 sons. One is Adishesha, Adisheshaya and Adinaranappa. We are considered only with the Adinaranappa on the right hand side.
Shankar Narayanappa has got
His wife's name is
Adishesha and
Padmavatamma.
Adinarayanappa.
His wife's name is Padmavatamma. But in the compilation which my learned friend read about, the name seems to be there's some error over there. He has 2 children. There is one Veerabhadra Prasad and one Shankar. Now this Veerabhadra Prasad would go before the authorities and would request for hereditary rights. At page number 8, my lords, an endorsement is issued. The last paragraph is in Kannada, my lords. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಘಾಟಿ ಸುಬ್ರಹ್ಮಣ್ಯ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನದ ಪರಿಚಾರಕರ ಹುದ್ದೆ ವಂಶ ಪಾರಂಪರ್ಯ ಹುದ್ದೆ ಎನ್ನುವ
I think you have to file a translation.
I will do it.
Otherwise, it's
since I had only 2 days, my lords. Since I had only 2 days, I will have it filed by another 2 days. ವಂಶ ಪಾರಂಪರ ಹುದ್ದೆ ಎನ್ನುವ ಬಗ್ಗೆ ದಾಖಲೆಗಳು ಇಲ್ಲವಾದ್ದರಿಂದ ನಿಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿಲ್ಲದಿರುವುದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. They say since there is no documents which indicate you having any kind of hereditary rights, your application is hereby rejected. What he would do is he would go before the authorities, that is the Commissioner Hindu.
One minute. Page number?
Page number 9 minutes.
Page number 6 is the genealogy.
Page number 7 would be the genealogical tree. 8 would be the endorsement issued.
8 is the
endorsement issue, my lords.
dated 3/12/2021.
Yes, ma'am.
Rejecting the case of, what is his name?
His name is Veerabhadra Prasad, S.A. Veerabhadra Prasad. That's the first son.
Case of Veerabhadra Prasad,
Yes, my lords, Veerabhadra Prasad.
son of
Son of Adinarayanappa.
Yes,
Page number 14, the operative portion of the order.
page number 14.
Yes, my lords.
Then what did he do when this, his request was rejected by the commissioner?
Yes, my lords. He comes before this honorable court in a writ petition.
That is at
Page number 15, my lords.
page number?
15.
Yes.
Writ petition 5230. The very same S.A. Veerabhadra Prasad. The operative portion reads at page number 19.
Yes.
Liberty is reserved to the petitioner to
Page
approach the
15.
jurisdictional civil court to adjudicate
WP number 5236.
5230 of 23, my lords.
Dated 5th December.
Yes, ma'am. 5th December 24.
What it says?
The last operative portion. I will not trouble my lords by reading the whole thing because their assertion was that as a paricharak it's an hereditary right, but this honorable court would hold the otherwise. May I read para number 7?
Who
my
is the
lords?
respondent in this?
In this, the state, my lords.
No, respondent number 5.
Respondent number 5 would be his brother, the second son of Adinarayanappa.
Shankar.
Yes, ma'am.
Yes.
Para number 7, my lords.
Yes.
Page number 19.
Hmm.
The petitioner produced a communication dated 20th of August 2016 from the temple, asserting that the position is hereditary. However, this communication contradicts the earlier recommendation dated 30th of May 1993, under which respondent number 5 was appointed on a temporary basis as the son of the previous paricharak. In the absence of the substantial evidence to establish that the position of paricharak is hereditary, the petitioner's claim cannot be sustained. Furthermore, the petitioner is working as a priest in the Venugopal Swami temple and receiving tastic allowances. I find no illegality in the impugned order passed by respondent number 1. Accordingly,
So it is affirmed.
yes, lords. The liberty is given at para number 10, my lords. Liberty is reserved to the petitioner to approach the jurisdictional civil court to adjudicate his claim regarding whether the position of paricharak is hereditary.
Yes.
In the event the petitioner approaches the so-and-so, is directed to adjudicate the matter based strictly on the so-and-so.
Yes.
The second son, he would again approach the authorities, my lords. Page number 21, that is S.A. Shankar,
Page number 21.
21.
Hmm.
Again, his request also is rejected, my lords, by page number 24. He also said hereditary rights.
That my father is a paricharika.
Yes, ma'am. Yes.
He should be taken as paricharika.
Please, my lords.
Ah.
He says that he was assisting his father
Hmm.
and hence he would continue. That also is rejected. This attains finality. He doesn't approach this honorable court or otherwise, my lords.
Page number 21.
Yes, my lords.
Then
Page number 25, at page number 26, my lords, the government order, in the
Page
second
20
unnumbered paragraph, my lords.
page 26.
Please, 26. Page number unnumbered, second paragraph, I'll just read it, my lords. Srimati Hema, that is the second petitioner. Bengaluru, your Kramasankhya so-and-so, ಮನವಿಯಲ್ಲಿ ತಾವು ನಿರುದ್ಯೋಗಿ ವಿದ್ಯಾವಂತೆ ಮಹಿಳೆಯಾಗಿದ್ದು ಘಾಟಿ ಶ್ರೀ ಸುಬ್ರಹ್ಮಣ್ಯ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನದ ಆವರಣದಲ್ಲಿ ಪ್ರಸಾದ ಮಾರಾಟ ಅವಧಿ ಮುಗಿದಿದ್ದು ಸದರಿ ದೇವಸ್ಥಾನದ ಪ್ರಸಾದ ಮಾರಾಟ ಅನುಮತಿ ನಮಗೆ ನೀಡಬೇಕೆಂದು ಇದಕ್ಕಾಗಿ ತಾವು ಸೋನ್ಸೋ ಹಣವನ್ನು ಮುಂಗಡವಾಗಿ ದೇವಾಲಯಕ್ಕೆ ಪಾವತಿಸಿ ಪ್ರಸಾದ ಮಾರಾಟ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಆರಂಭಿಸುತ್ತೇವೆ ಎಂದು ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತಾರೆ. They made a request to say that she is an unemployed youth.
That's it, about the representation.
Yes, my lords. So
What
based
are
on
these
that, this order is passed where they she's given an lease to distribute.
This is on 1/8/2003.
Yes, my lords. 1/8/2000, the 30th of September 2003, my lords.
30th of September.
My lords, this stand she continues till 2024. I'll just go away from this.
No, in this, in this representation, I mean, in this order proceedings, they refer to her representation dated.
This is a representation dated, my lords.
They must be in the.
Yes, my lords. I'll give her the date, my lords. 15th of September 2003.
15th of September 2003. You have a copy of that representation?
I will, right now I do not have it, my lords. Yeah, 2003 representation. I will produce it. Lord, this contention of theirs to say that she's an unemployed youth and she needs employment and it's.
But unfortunately, all your proceedings, all your so-called persons say hereditarily doing, hereditarily doing.
No, we
Why
have
did
not
they do
stated,
it?
indicated anywhere hereditary. We only say that since you have come forward to say that you want to.
Not here.
Please, ma'am.
Your, what is that? Somebody who said that, Agama Pandit.
But
or
Agama
some-
Pandits also say on the other side, Agama Pandita's report says that where the prasada has to be sold and it cannot be sold outside. I'll just read it for a
No,
moment if I
before,
can.
before this person, who was doing this?
But our records indicate that somebody else was doing prior to 1984.
When, from till when they
I'll
who
get
was
the
doing
records,
it?
Manoj.
These are also
I'll produce the
relevant
entire
for your
original
case.
records itself will produce to indicate, Manoj. All the resolutions which my learned friend read was a request made and that request was to be ratified by the authorities, which was never done.
That is what, because it's a 60, what is some 68 temple or what is it called?
Category 8.
This is a category A temple,
A
Manoj,
category
beyond
A
a
temple.
particular.
Category A temple is under the supervision of the commissioner.
Yes, Manoj.
Every proceedings has to be by the commissioner.
Yes, Manoj.
What is a temple committee can do with that? It has to be ratified by the commissioner, any decision to be taken.
They have rejected the two brothers. So the question of now ratifying this person shouldn't arise at all is my submission.
No, for about other proceedings.
I understand, Manoj, I understand.
Yes.
Even if by going by my learned friend's compilation documents at page number 46,
Yes.
they also again say that it is only by for a period of 5 years they kept on asking every 2 years, 3 years, give us an extension.
What I want is,
Yes,
from when you have been extending the lease in favor of the
This person.
petitioner, those documents to be placed.
I'll
on
produce
record.
him. 2003 is my recollection is right. 2003 is first time when we gave her minutes. Nonetheless, subject to correction, I'll produce the entire documents to indicate as the first time when is this petitioner
And also place the documents to show before 2003 who was
who was
doing
doing it. Please, we'll have it done.
Yes.
Next would be minutes. These two petitioners would approach this honorable court at page number 28 by way of writ petition 1589 of 22. Seeking an order of 27th of December 2021 made by the deputy commissioner where a tender was called, minutes.
16th March.
Yes, minutes. This was sought to be quashed.
What is their case? Let us see.
Page number 28, minutes.
Yes.
Minutes may come to page number 29. Writ petition number 1581 of 22. Order dated 16th of March 23. The petitioners are before this court calling in question communication dated 27th of December 2000.
You have the affidavit of this
The affidavit.
I mean, the petition that is filed.
I can produce.
No. It's already in our compilation. We have
Let's see
produced.
that.
It's there. Lords, it's in a spiral bound if your lordship
Page
goes.
number?
The memorandum of writ petition is at running page 41. It starts.
41.
That is why we have produced it. Please turn to the memorandum starts from 46 if your lordship. Facts.
According to the petitioners at page 4, para number 4, page 48, permission was granted to the second petitioner only in the year 2013. Para 4 minutes, page 48.
According to them, it's from 2013.
Yes, ma'am. Here also the premise, my prima facie reading of it would indicate that they want to be given this selling permission only as a permission, not as any kind of an right as such.
Read para 5,
Yes, ma'am.
page
Thus,
49.
aforesaid facts make it clear that the competent authority, namely the Commissioner of Hindu Religious Institutions also, has granted permissions for the petitioner to do business services to the devotees of the temple in respect of items enumerated in the order of permission, and the petitioners have been carrying on the business without any complaint, and the term of such permission is still in operation. When these being the facts, one, Purushottam seems to have given a complaint to the Deputy Commissioner stating that term of permission granted in favor of the petitioners have expired in the year 2018, and still the petitioners are continuing the business and therefore sought for public auction. The second respondent, without application of mine and without even calling for explanation from the petitioners or from the third respondent, and without noticing the customs, usages, ceremonies, and practices appropriated to the third respondent temple, by the order dated 27/12/2012, 21, by number so and so, was pleased to direct the third respondent to conduct
Yes.
the auction in respect to the
Yes.
public.
Please continue.
Please, Lord.
Yes.
By virtue of the order passed by this honorable court dated 16th of March 23, the writ petition comes to be allowed, my lord, and the impugned communication stands quashed.
Therefore, the communication of the commissioner is to be obliterated and the authorities are left to their discretion to lease out the items that were leased out to the petitioner strictly in accordance with law.
Yes.
Yes.
Interestingly, what the petitioners would do is, in the guise of selling prasada, which is Panchamrita, Kajaya, and Kallu Sakre, kindly permit me to come to page number 44 minutes. I am told, my instructions are, sorry, 43 minutes.
Page 40?
3 minutes.
Mm.
There are 20 items which they are selling, which includes Kallu Sakre, Karjura, Panchakajaya, Panchamrita, Palapurna, Taita, Belli, Harike Samagre, Vigraha, Dollar, Keychain, Ungra, Kashidara, Tulsi Dara, Swami or photo, Pustaka, Tirtha the bottle, Stotra the Pustaka, Stalapurana Pustaka, Panchalava Vigraha.
This was, no.
How they would sell it, I have also produced the photographs.
No, even this is also this is also hereditary.
I mean,
right?
I should be, the page number 47, 6 onwards, Milords. What they would do, I'm told, Milords, on instructions I'm stating, Milords, they would keep a deity's
idle
idol at page number 46, it's seen, Milords. And in front of that, they would keep all the other items, and at the time of selling it, they would show it to the deity and then pass it on to the customer. Now, the Agama Shastra Panditas in their own report say that where the prasada has to be sold. It cannot be sold outside the temple premises at all or anywhere else except for one designated place. Here, there are not, by virtue of, I should also admit that my officials have been at quality to say that all these years they have allowed her or the other person to not only sell the prasada,
In fact,
but also
find fault with your officers who have let all this happen.
Yes, my lords, they have. That is the reason in 23 we passed this order. They come before this honorable court at that point of time only to indicate that 5 years was granted to them, out of which 2 years they have lost out because of the fact that there was COVID-19 and the temple was partially. And they would make a submission before this honorable court for an interim order to say that the 2 years time has to lapse. Now that 2 years time also has lapsed more than that 1 year. By virtue of that interim order, they would still continue to sell the prasada and the other things. Lords, first and foremost, Lords, they are not archakas for them to offer naivedya to the deity also is my instruction, Lords. They would say that they are paricharaks. Paricharaks otherwise would say they are only helpers to the temple. Lords, in the guise of being paricharaks, in the guise of not being the persons who are authorized to even offer naivedya to the gods, they would say that this is the prasada which in the non-puja hours or after the puja hours we are selling it at this cost. And the Agama Panditas in their report themselves indicate that the naivedya was never offered. In their inspection, they would come to know that the naivedya was never offered. Without offering the naivedya, they would only indicate that this is the prasada of the deity which has already been offered to the deity, and then would sell the prasada at various costs to the thing. And then what money they would pay would be a very measly sum of 1/10 or much lesser than that to the government as such. Now, when we come across to say that this is the reason why we are saying that you cannot continue because you have already overdone your thing, they file this application to say that they want to invoke their hereditary rights, which was already dead and gone by the two brothers who are already done. But if my learned friend's submission is to be taken, that 3 generations has to be there or 100 things has to be there, 100 years of practice. The first Adinaranappa, if he was doing it, subsequent to the death of Adinaranappa, if his wife has done, there ends it because the 2 children were never given. She is the granddaughter, daughter's daughter.
No, according to them, mother is doing, Shobha.
Mother was doing it after the mother's demise. The sons were never given, so the third generation never came.
The mother is Hema's mother, Shobha. Hema is the petitioner.
Yes, my lords.
Her mother was doing is the.
Correct, my lords. The third generation would be Hema, but the third generation, the men would come over there. Men, when they make a claim, that claim was never allowed. Rather, it was rejected. So it stops over there. Now she making a claim that I am the third generation. If my learned friend submission is there, 3 generations should have lapsed for them to be called as hereditary rights. My lords. Here, the third generation itself is at question because the third generation, the males, were never given the hereditary rights as such. My lords. So, in my humble submission, my lords, they have not made out a case insofar as to continue the prasada distribution and not at this cost.
Say about the act.
My lords, in 2024, the act comes in where 39 would be a repealing section which says the earlier act and earlier practices
New
will
act
continue.
which you're.
Yes, my lords.
For this temple.
Yes, my lords.
That's in 2024.
2024, my lords.
Something has come for this.
2024, my lords. It's called the Sri Ghati Subramanya Kshetra Development Authority Act.
Under the act, now the new committee is appointed.
New committee is appointed. I'm getting instructions whether they have passed a resolution or a notification for the movables and other things to have been.
Without forming the committee, when the committee.
I'll answer that, my lords. I've asked my officers to check and get me the records post 2024. Act has come into force, my lord. That notification I have.
Of course, pursuant to the act, you have to appoint the committee.
Yes,
Then
ma'am.
only committee starts doing the
No,
work.
there's a, Lord's Act itself contemplates all that. What my learned friend says is the vesting has taken place with the government. Government has not handed over to the board. That has nothing to do with this. That's it. My Lord's Act has come into,
Accept that the committee is
Act has
constituted.
come into force. No, my learned friend argued. My learned friend argued. We told him not to argue this point.
No, it's okay. Ultimately, like it, yes.
Yes, my lord.
Yes, Mr. Senior Counsel.
Lords, please take the spiral book which your lordships have, my lords. The convenience compilation.
Yes.
Lords, here what we have done is, my lords, we have given in a chronological order all the documents, my lords. But what I would submit is the genesis of the entire dispute. Currently, my lords, is document number 7. If your lordships have the index in my convenience.
Yes.
7, 8, and 9. Now, 7, my lords, is a. I'm sorry, 7 is a circular, my lords. That they have admitted that circular, my lords, was issued in by the state government in 2010. Lords, saying that prasada will be distributed, handled only by temples all across the state. So this is a procedure from 2010.
Let us see that.
Lords, that your lordships should get at page 19. Though, my lords, unfortunately, our council has not translated. I'll read it to my lords probably.
No, what I request is all the documents whichever are filed in Kannada, I want a.
Translation.
Please take this compilation, both of you, or whatever you filed also. I want,
The
he has filed
translations.
all along with the
Translation. I know.
Yes,
We'll have
page
it right.
number.
My lords, the document number 7, your lordships should
Page
get at
19.
running page 19.
Hmm.
The type page is at 21. It's dated 2/6/2020, 2010. That's what it records is at 22. I'll simply read the last paragraph.
Yes.
ಆದ್ರಿಂದ ಇನ್ನು ಮುಂದೆ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ದೇವಸ್ಥಾನಗಳಲ್ಲಿ ಲಾಡು ಕಲ್ಲು ಸಕ್ಕರೆ ಹಾಗೂ ಇನ್ನಿತರ ಪ್ರಸಾದಗಳನ್ನು ಹರಾಜು ಮೂಲಕ ಯಾರಿಗೂ ವಹಿಸದೆ ಕಡ್ಡಾಯವಾಗಿ ದೇವಸ್ಥಾನದ ವತಿಯಿಂದಲೇ ತಯಾರಿಸಿ ದೇವರಿಗೆ ಸಮರ್ಪಣೆ ಮಾಡಿದ ನಂತರ ಭಕ್ತಾದಿಗಳಿಗೆ ದೇವಸ್ಥಾನದ ವತಿಯಿಂದಲೇ ಮಾರಾಟ ಮಾಡಬೇಕೆಂದು ಸೂಚಿಸಲಾಗಿದೆ. So my lords, what it says is, going forward, there shall be no auction, nothing. Prepare it in the temple thing. First offer to the lords, any prasad. My learned friend was saying prasada becomes prasada when devotee takes. No. Prasada is first you do naivedya to the god. It's offered to the god. Then it becomes, otherwise, my lords, any laddu I can get it in Kanti sweets also. That's not prasada. Prasada is when I offer it to God, there is some custom.
He said
Then it
first
is.
offer it to
Sure.
God. He was not
Lords,
there.
very well.
Yes,
Lords, that is how the custom is. Now, Lords, this was in 2010.
Yes.
Be that as it may. Now, please come to document number 8 is an official memorandum dated 28 to 2018, page 23, my lords.
28 to 2000.
18. There were 3 orders, document number 8, 9 and 10. Document number 8 and 9 is issued to Rangaraju. That's a first petitioner in his writ petition who does not have any hereditary rights. Document number 9 is the same date issued to Hema. Now, my lords, what it does is document number 8. My lords?
What is issued to Hema, page number?
Yes, my lord. That your lordship should get at running page number 30. The typed copy is at 32. For Hema, please see what is issued. Running page, I'll just read it. I'll put the translations, my lords. Vishaya. ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಘಾಟಿ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಾಲಯದಲ್ಲಿ ಕಲ್ಲು ಸಕ್ಕರೆ, ಖರ್ಜೂರ, ಪಂಚಕಜಾಯ ಮತ್ತು ಪಂಚಾಮೃತ ಅಭಿಷೇಕ ಪ್ರಸಾದವನ್ನು ಮಾರಾಟ ಮಾಡೋದು. So these 5 items were given to him.
That means to sell.
To sell.
Prepare and sell.
To sell, yes.
Prepare and sell.
Yes, my lords, because kallu sakre there is no preparation, my lords. That's
Whatever it is like.
yes. Now, my lords, what was given to this Rangaraju, your lordship should get at page 23 because they are mixed up both. The typed copy, my lord, 23.
No, no.
Document number 8.
So what you referred to is page 30.
Yes, that is for Hema. But the typed copy is at 32 minutes.
Yes.
This was given on 13/8/2018 for a period of 5 years. Yeah? They ಹೇಳಿದ್ನಲ್ಲ. Kallu Sakre, that's all. Now for Rangaraju. Rangaraju, 28/2/2018, an order came to be passed. That is document number 8 at page 23. He was given permission to sell ಸುಬ್ರಹ್ಮಣ್ಯ ಸ್ವಾಮಿಯವರ ಬೆಳ್ಳಿಯ ಹರಕೆ ಸಾಮಾನುಗಳು, ವಿಗ್ರಹಗಳು, ಕೀಚೈನ್, ಡಾಲರ್, ಉಂಗುರಗಳು, ಕಾಶಿದಾರ, ತುಳಸಿದಾರ, ಸ್ವಾಮಿಯವರ ಫೋಟೋ, ಪುಸ್ತಕ, ತೀರ್ಥ ಬಾಟ್ಲು, ಸ್ತೋತ್ರದ ಪುಸ್ತಕಗಳು ಮತ್ತು ಪಂಚಲೋಕದ ವಿಗ್ರಹಗಳನ್ನು ಮಾರಾಟ ಮಾಡಲು. So this has nothing to do with custom. All those small things, my lords, which this is on 28/2/2018 for Rangaraju for a period of 5 years.
This is page number 22.
23, my lords. Then at page 27, there was one more order passed on 13/8/2018, one more lease. Page 27, that's also for Rangaraju. Here what is given is ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಘಾಟಿ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪೂರ್ಣಹುತಿ, ಮೈಥಿಕ ಮತ್ತು ತಾಯ್ತಗಳು ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ. ತಾಯ್ತ is, my lords, those small threads and with the thing which they tie and some other thing. So this was also, so there were 3 orders, 3 leases granted in 2018. Now they file a writ petition before this honorable court. Your lordship saw the memorandum of writ petition.
That is Justice now prisoners.
Which, but please see that why I refer to those 3 orders is, if your lordship sees, that is also referred to in the order at running page 85 in my compilation. Justice Nagaprasanna's order.
Here they say about all the earlier.
All the 3 leases. And what is finally done there, my lords? The communication of the deputy commissioner was set aside and they were entitled to continue because their 5-year period was ending in 2023. Now the 5-year period ended in 23. They yet again approached this honorable court. Now let's, in the writ petition bearing Lords, if your lordship kindly take the first writ petition, 25004 of 23. In that, my lords, annexure G at page 49, Justice Krishna Dikshit's order on 26th July 20.
Which compilation?
My lords, unfortunately, I don't see in my compilation also and in the.
No, I saw that somewhere.
It's in the writ petition itself as an annexure.
Which number?
My lords, it's at page 49. Hema files, not Rangaraju.
40.
Running page 49, my lords. If your lordship kindly come to page 50.
No, with all these many documents filed, where is the main writ petition not to
Writ
be?
petition.
Page number?
5, my lords, the annexure starts at 49. Annexure G. It's an order dated 26th July 2023 in WP number 16128 of
Where
23.
is the writ petition issue?
Sikta. Illa, first Thorson. Your lordships have that order, my lords. It's an order. 49. It starts as running page 49, annexure G, my lords. It's the order dated 26th July 23. Now, what I find strange is Honorable Justice Nagaprasanna's order was 16th March 23 when the lordships observed insofar as certain leases period is over, certain leases it continues. They are entitled to. Within, my lords, 3 months they file one more writ petition. Anyway, that is disposed of on 26th July only by Hema. Rangaraju moves out. Now, what is the thing? Your lordship may kindly come to page 50, first para. The short grievance of the petitioner is as to non-consideration of a representation dated 1/7/2023 in terms of recommendation made by respondent number 2, void memorandum dated 13/8/2018. Petitioner seeks extension of the period by 1 year on the ground that during COVID period, she could not make use of the privilege granted. Then, my lords, the government opposes that. Ultimately, this honorable court,
Gives 3 months time.
it only says you consider it, nothing else.
Yes.
Okay. After consideration is the impugned order at annexure H, which is passed at page 52.
Yes.
Now, in first writ petition disposed of by Justice Honorable Justice Nagaprasanna, second writ petition disposed of by Justice Krishna Dikshit. No whisper that this is a hereditary right. You base your entire claim on those 3 leases of 2018, 5 years. Period is over. You yet again come in and say, I lost in COVID, so give me 2 years. You get that also. Now, suddenly in this writ petition, you turn around and say, both of us have hereditary rights. Now, my lords, Rangaraju, who is Hema's husband's brother, claiming hereditary right, my lords. Anyway, we are coming into new aspects of hereditary rights now. Even maybe one day I'll also have to stake a claim for having argued the matter that I have a hereditary right.
What is that IA filed by you for say amendment, seeking amendment of the
Amendment, hereditary rights.
IA number?
25 minutes.
IA 2/25.
IA 1 of
IA 1/25.
1 of 25 for amendment. No, my lords, that's why what I would submit is your lordship may kindly not go into any of this by way of constructive res judicata. Lords, this plea should have been, ought to have been, and could have been raised in the writ petition earlier. Now you don't raise it. You accept it. You tell the authorities, give me this, give me this. Now, after everything is over, even in this writ, my lords, initially there is no plea about hereditary rights. Now a plea is raised. And what about suppression? Now, my lords, Hema is the granddaughter, through daughter, my lords, of Adinarayanappa's. Adinarayanappa's 2 sons have lost their claim. They have accepted. And their claim is for what? Hereditary Archakaship. Not sorry, Paricharak. Now, my lords, Paricharak in any terms is only a person who assists the Archaka. My lords, Archaka will be doing other things. The Paricharaks are normally wiping, cleaning, and giving the vessels. Those are Paricharaks. My lords, 2 brothers have lost their right. They have probably, we do not know whether they have gone to the civil court. They have kept quiet. Our information is there are other sons also of Adinarayanappa. We do not know. Now a daughter, maternal daughter. Lords, of course, there is one judgment of this honorable court. I had told them to enclose it along with the compilation. Unfortunately, it's not done. Justice Sanjay Gowda. My lords, one judgment in May 23, this is taken up in an appeal, but the coordinate bench holds. What are you sitting here for? Here, my lords, the court holds there is no maternal rights, or you can't claim through maternal rights. Please come to my lords, para 9.
Yes.
It starts a reading of this passage. The lordships have that one. Would indicate that admittedly only their father M.N. Subramanya Dikshit had been performing puja in the temple, and before him it was Nanjunda Dikshit, his father-in-law, maternal grandfather of the petitioners, who was performing the puja. It may also be pertinent to note that even in written arguments submitted by petitioners, they contend that their grandfather Nanjunda Dikshit had handed over charge authorizing the petitioner's father Subramanya Dikshit to continue the puja of the temple as hereditary archaka. Reliance is placed on so and so, so and so. Then, my lords, as could be seen, even the grandfather of the petitioner states that his son-in-law was performing the puja along with him, and he should be permitted to continue as archaka. Since the petitioners admit it was their maternal grandfather who was performing the puja, obviously they cannot claim that archakaship was hereditary. In fact, in the impugned order also, a finding has been recorded that the father-in-law of the petitioner's father, Nanjunda Dikshit, but maternal.
Generally, in all these laws, it says succession as per the Hindu Succession Act.
Succession. Now, my lords, here, if you want to still contend you have a hereditary right, please file a civil suit with your family members, establish it. But in a writ petition today, my lords, after having lost, that's why, my lords, Order 2, Rule 2 or Section 9, res judicata, my lords, you should have raised it in the earlier writ petition, it would have been adjudicated. You allowed a writ to be disposed of, giving you a benefit of 2 years. And now you turn around. And, my lords, all the orders passed by what is set out by the learned Advocate General also, Additional Advocate General, we have produced. And the Agama Pandit's report has not been accepted by the commissioner. Notice that is only an opinion. And my learned friend read in his compilation the committee's resolutions, my lords. Those are only resolutions passed by the committee recommending to the commissioner that you can give this right. That does not give any nature of hereditary rights to them. Then, my lords, in their compilation, I just want to point out only one aspect which my learned friend read, but what was crucially missed out was skipped out. I want to point out page 48 in their in his compilation. That's an order dated 9/6/22 of the commissioner.
Yes.
At page 49.
Yes.
Lords, he started with the first para at page 48. That's an ordered communication dated 9/6/22. Then, my lords, he skipped and went into the last note 13 and started reading about the Agama Pandit's thing. But what is missed out at 49? Please come to, my lords, the second unnumbered para from top at 49. Upon reviewing your proposal.
Yes.
The proposal was to grant permission to invite e-tenders, e-auction the issues. Upon reviewing your proposal in the reference, the Agama Pandits of this office have given their opinion stating that since the period of the order issued by this order, wide so-and-so dated 28/2/2018, 13/8/2018, granting permission to sell photos of the deity, harake items, laddu, sugar crystals, dates and other items at Sri Ghati Subramanya Swami Temple, Dodbalapura Taluk, Bangalore Rural District is still in force. It is not appropriate to cancel the order issued by this office at this stage. Since the orders issued to Srimati Hema and Rangaraju who have obtained permission to sell prasada and have been carrying on the sale since the past at SS Ghati, SS Sri Ghati Subramanya Temple, Dodbalapur Taluk are still in force, they may be allowed to continue the sale of the above photos, harake so-and-so, so-and-so, so-and-so.
Yes.
Lords, because that period was not extended, that's all. Lords, that is all what we have to say, my lord. Now, if your lordship go into hereditary rights, first is on their thing. And Rangaraju, any other way, even otherwise, has absolutely no rights. By virtue of an interim order granted in this writ petition, they are continuing. And my lords, my learned friend in their compilation, my learned friend wants to point out one letter by them itself at page 191 in their compilation. This is post the present writ 191. It is from both Hema and Rangaraju, a letter, my lords, to the state government. And in that, please come to 195. Last para. We request you to pass an order extending the permission to sell prasada and other articles at Sri Ghati Subramanya temple for next 5 years to carry out sales as before, and we are bound to pay the money. My lord, this kind of a sale is not hereditary, nor a custom, nor a right, my lords. There are different things which are customs or hereditary rights. And nowhere in Karnataka, my learned friend said, nowhere in Karnataka, prasada is allowed to be sold by, my lords, I am talking about the Mujrai temples, notified temples, by a third party. Even in Kukke Subramanya, because in their representations, they refer to Kukke Subramanya temple, the main Kukke Subramanya temple in Karnataka. Even there, for the first occasion, outside the temple premises, auction was held to sell only, my lords, these kind of taita, silver articles, gold articles, threads and other things, not prasada at all. After that, they were extended for a period, but nowhere near the temple premises. They were all outside. Now they are even outside. And in Kukke Subramanya or any temple, it is only the temple which will prepare the prasada, even the laddu. It is given through a counter by receipts. No third party is allowed. Now, if my learned friend says, I have the right to prepare, you have the right to prepare your laddu, whatever, kajaya, everything. Please sell it in your row house. You call it as prasada. If some devotee takes it, good for them. But if you're doing it inside the temple, you are misleading the devotees. And we do not want to do that.
Yes, your writ petition. Come to that. Where is that? Next one. Yes.
My submission would be that insofar as religious rights are concerned, Your Lordship had asked a question whether religious rights can also involve commercial rights. In my humble submission, Lord, it does involve. Lord, a rights of a pujari or a mahant or a shabait, the courts have recognized it consists of an office also, combined with property. Therefore, my Lord, so that's how civil courts get jurisdiction.
Now, for there are under the inams are granted to the purohits or whoever are doing the service in terms of their service. Some are a small extent of 4 acres. That is a different aspect.
That is, of course, by way of inam, my Lord, which is granted.
Not only
Where by virtue of their office itself, my Lord, either they get remuneration or they are entitled to certain benefits.
That is, there are several Supreme Court judgments which have interfered with that.
Therefore, in fact, Shurur, but which dealt with this, also may not recognizes this itself. We may just may not pass on.
So let's not go into that, because as of now, I am convinced that it is not hereditary right.
I can only point out, to your Lordship,
So
that
please
insofar
come
as
no, in your writ petition, what you have questioned?
I have questioned the subsequent resolution, which has now been passed by this authority. It was read out by my learned friend. On the question that this, I would humbly submit, it was pointed out to your Lordships that earlier order had only said not within the temple, the first prakara.
Now, what is the consequences of if the earlier writ petition is dismissed? What are the consequences of that on this writ petition?
Well, now if your Lordship were to say that I do not have any right at all, then perhaps nothing may survive in this.
In this writ petition.
In this writ petition.
Yes.
Because ultimately, if your Lordship were to say that I have no right in the earlier thing itself to sell any articles anywhere in the temple, then perhaps nothing may.
It's only on the point that they have to sell
In so
it
far,
out.
of course, I have.
No private person shall sell it.
Yes, I have pointed out that this proceeds on a basis that I am a private person. I have no connection at all with the temple, and therefore that may not be correct. And I have not been heard. And second, on the question of jurisdiction itself, because your Lordship sees the act. under which they have to be vested with the authority, which vesting has not taken place is my assertion. Not just to summarize the points, not insofar as this petition is concerned. One is not insofar as the authority of this board is concerned. It does not flow unless and until there has been a vesting not under the act. That vesting has not taken place as per our,
How it will happen, vesting?
by the government. Government has to pass an order. Your Lordship sees the act. My Lord.
Saying that all the properties
Yes,
vest
yes,
with the government.
yes. That's how, my Lord, it contemplates.
No, by way of that act, it vests with the government.
It vests with the government, not with the authority.
No, once the authority is constituted,
Yes, my Lord.
it will flow to the.
No, there are different functions of the authority, because your Lordship sees authority is for planning. In fact, the whole, other than the temple itself and the properties, the whole area for planning of it and how to develop facilities. Kindly have a look at the act. Therefore, my Lord, there are other purposes. This act is not only for this purpose. In fact, my Lord, this is not the main purpose. If I may humbly submit, the act is for a different purpose altogether. It is more for a planning, as a planning authority for the entire area.
And apart from that, they'll take care of the entire administration also.
Insofar as, my Lord, that is where, my Lord, 19 would come in. And, my Lord, read with 39, where it says, my Lord, the 1997 act will continue to apply. There, my Lord, I would humbly submit, my Lord, my submission is this. Insofar as the Agama Pandit's, my Lord, two reports are there. Your Lordship sees the first report, my Lord, which was pointed out to your Lordships. There, my Lord, a reference is made to section 58. My learned friend pointed out, my Lord, that only the Agama portions Pandit's note was read out, but not the Deputy Commissioner's order, and he read out the reports of the Deputy Commissioner's order. Deputy Commissioner's order is based on the Agama Pandit's note. Agama Pandit's note clearly says it is as per the customs which are prevalent in the temple. Section 58, my Lord, has been pointed out. And your Lordship sees the next report of the Agama Pandit, my Lord, which was in the compilation your Lordship takes. In fact, unfortunately, I was not given a copy, perhaps not, but I have borrowed my learned friend's compilation. What was read? Kindly have a look at the second inspection report.
Because those documents are your own documents.
Of no difficulty, my Lord. I am in about myself personally, my Lord, not about the party. Kindly have a look. For the sake of when we have a convenience compilation, it's convenient to refer for both parties to refer to the. Please, my Lord. My Lord, kindly have a look at page 91, my Lord, in the convenience compilation.
Yes.
My Lord, this is the inspection report. This is referred to, my Lord, in the order which was challenged, that is, my Lord, at page 71. 71, the earlier order, my Lord, which is challenged in the earlier writ petition. And then at page 75 is the reference to the opinion of the Agama Bhattidas.
Yes.
Kindly see, my Lord, now the report, which is at page 91.
Yes.
The whole discussion, kindly have a look at, my Lord, para, page 99.
Yes. Yes.
In Agama Shastra, preparing the prasadas in the temple or inside the temple, inside the courtyard, in some mandapa room, offering it as naivedya to the deity.
He has read that.
Yes, my Lord. This was read out to point out to Lordship, my Lord. Then kindly see the concluding portion. After this, page 99, there is no reference to the fact what I have been doing is wrong. All that I point out is, please give the proper place. Now, this has been misinterpreted by not referring to the concluding portion to say, therefore, they should be evicted. Now the question would be as to whether the interpretation of this order, whether it evicts means evict from the temple itself or evict from first plus, that's he has dealt with it.
Plaintiff who comes to the court has to prove his case basing on his own merits.
Please.
It is like you are relying on their, the
No,
defendant's.
I'm only pointing out, my Lord, that insofar as the two reports.
If you have to succeed in the writ petition, you only have to show that the so-called hereditary rights you are saying, whether that exists or not. That's the only thing. Remaining other things like.
My submission, of course,
mentioned.
That my learned friend has dealt with it, I will not repeat it. My submission, my Lord, is the resolution of 1984, which deals with my grandfather's application at that point of time, and the subsequent Agama Pandit report, my Lord, which relies on section 58. coupled with this report also, which does not say, my lord, it is opposed to the customs. That prima facie shows, my lord, that I have been the one who has been doing it. As your lordship said, let them point out to us who has been doing this earlier.
You filed 2 red petitions earlier and you will never say about your.
Yeah, my submission there, my lord. Yes, my lord. My submission there would be.
Petitions to them.
My lord, may I just clarify on that aspect, my lord. But insofar as regulation of my right is concerned, I have no difficulty, my lord, in terms of the lordship, my lord, a reference was made that I'm earning so much money. Of course, amounts are being paid to the government also. At what rate I should sell, where I should sell, what is the quantity, all of this can be regulated. My right cannot be abolished. Now, insofar as the lease, my lord, my submission is that's a recognition of that right and putting some conditions. That, my lord, it gets over. But I cannot be prohibited unless, my lord, as your lordship says, in the case of TTD, my lord, there is a statute which does, then, my lord, the larger questions now arise. In fact, now Shirur, everything is being reconsidered now, my lord, in the light of the constitution bench as to whether, what is the scope of that?
No, the budget of TTD temple is equal to a budget of a state.
Of course, my lord.
If that is given to a private party, what will happen?
My lord, and I would also humbly submit, my lord.
All those things won't
No,
work
no,
out.
therefore, my lord, my submission is, of course, my lord, in terms of regulating it, if the statute were to take away right, my lord, then I would naturally question it. By an executive action, my lord, all that I would point out is, my allegation is this action of the board in this case, my lord, I will not be saying on the other earlier case because, my lord, he is, insofar as this action of the board is concerned, is without jurisdiction, in violation of principles of natural justice and not contrary to section 58 of the Act, which is preserved by the 1997 statute and by the 2024 Act also, because it says in terms of religious practices, has been broadly interpreted in Shirur Mutt itself to say prasada is also a religious practice and therefore not sale of. I will not detain, my lord, just further your lordship.
So I'll have this, now all arguments are concluded from the government, whatever the document that you, both of you, both from the temple and the government, whatever documents, you please take your.
Let's we'll provide with the
Along
translations.
with the translation, and you only like any day tomorrow, I'll just give you 5-10 minutes time to only convince on that.
Or a day after I'm not there.
We would also insist on cost because, my lords, we are going on the res judicata. If this is going on, my lords, it will never end. No, there should be an end to litigation.
Thursday, only, no other arguments.
Yes,
Only on the question I asked,
Yes, my lord.
citation and the question I asked.
Yes.
I'll give only I'll take it up at 4:30. I'll conclude it at 4:45. Yes.
Great.
Yeah, heard the councils. Then counsel for the, heard the counsels for the petitioner, and also then the senior counsel and the additional, the additional advocate general for the state. At the request of learned counsel for the petitioner, this matter on Thursday at 4:30. Both the temple as well as the government shall file the translated copies of all the documents which are in Kannada. Give them anyhow, there you can't give. This you can give. Yeah. Take it. Interim order earlier granted is extended.
Grateful.
Yes.
Shri Venkatesh, 230 mood matter.
I'm filing the plain copy. It was asked, objection, everything has been complied with. This is a matter, my lord, sir. Hello.
Take that.
In this, my lords, page 41, my lords, page 41 is the affidavit which I had filed along with the application that I have been denied representation by a counsel by the court.
Where is that page?
Page 41 minutes, in page 41, running page 41 minutes. The paragraph 9 minutes, the highlighted portion.
Yes.
SP holder present and files an affidavit that their advocate is not giving NOC, advocate for the plaintiff absent, already time given.
Where are you reading? 41 is not what you are referring. It is some paragraph, some affidavit.
The 41 minutes is the affidavit in support of the application minutes. Affidavit in support of the application.
Yes.
That application is the statement. In paragraph 9 of that affidavit,
it starts with it is submitted that we learned that.
It's respect submitted that we learned that paragraph. I have highlighted the portion in italics in paragraph 9 of the petition, where is that very specifically highlighted The SPA holder is present, and this is the order of the observation of the court. The SPA holder is present and filed an affidavit that their advocate is not giving NOC. After the plaintiff's advocate for the plaintiff absent, already time was given. In spite of several adjournments, advocate for plaintiff not cross-examined DW1. Hence, the cross-examination of DW1 is taken as nil for defendant's further evidence. The next date of hearing, my lords, in the same paragraph, again in italics, which I put across, advocate for the defendant absent, defendant present, defendant filed IA seeking permission to engage another advocate. This was actually plaintiff, erroneous correction, and for arguments in column. So they closed the evidence also and posted it for arguments. Then again in paragraph 10, my lords, the plaintiff's present, defendant's present, advocate for the plaintiff's absent, advocate for the defendant present. This matters of 2017. Hence, plaintiff side argument is taken as heard and for defendant arguments and column 27. Lords, I am not being represented by a lawyer. My lawyer is not coming to court. I have issued notice to him. He is not willing to give NOC to me. I have also produced the judgment of this honorable court, my lords, which clearly states the nature of engagement. That it is not that the advocate has to lean on the brief. The choice that a plaintiff has regarding his advocate is concerned, well, that is a choice which is with the person. If any advocate has an issue with the clients relating to the payment of fee or other aspect is concerned, there is separate proceedings. He cannot hold the brief to the detriment of the litigation. Here is a case where, my lords, the plaintiff for last 3 months is not being represented and proceedings are going on at every stage. And the court records that we have been presenting the fact to the court that we are not being represented by a lawyer. Please give us permission to leave to engage services for an advocate. That is not being given. And that is the observation on the order, my lords. If your lordships were to come to in page 29, my lords, this is the order, impugned order.
Where is the proceeding sheet?
The impugned order, my lords.
Proceeding sheet.
Order sheet, my lords, is at 30.
30?
Annex F, my lords. Annex F, in page 44, my lords. In page 44.
Suit is of the year 2017.
Type copy.
What is happening from 2017? You placed before the court only on from 29/1/2026.
This is the relevant portion. I put only relevant portion of the order sheet. We have not been engaged. We have not been allowed to engage lawyers service, and I'm conducting a
Where I
suit for
can understand
declaration.
all this? From what? From these proceedings, how I can understand what is your submission and that is what is happening?
Well, this is a suit for declaration and possession, which I have filed.
You are saying that you are repeatedly asking the court and the court is not considering your request.
That's my lord's Annex A, the order passed by the court where I had filed an application. Recall the order so that I can proceed with the case.
Please.
That in page 25, my lords, out of the learned trial court.
Let's read the order. Read from the reasoning part.
I would come to paragraph 11, my lords.
From the reasoning part, paragraph number 7.
Oh, yes, my lords. The plaintiff filed a suit for declaration that the sale date dated 21/6/2017 executed by the defendant in favor of his vendor is null and void. Further, the plaintiff claiming declaration of title in respect of suit scheduled property. Even the plaintiff is claiming possession of the suit scheduled property. After appearance, the defendant filed written statement and accordingly issues were framed. After the plaintiff's SPA holder was examined as PW1 and cross-examined by the defendant advocate. Meanwhile, the plaintiffs 2, 9, and 10 are dead. The LRs of the plaintiff number 2 were brought on record. Defendant also examined DW1. The advocate for the plaintiff has cross-examined DW1 in part. When the case was posted for further cross-examination of DW1, at that juncture, SPA holder of the plaintiff and 66, 8, and 9 filed a memo by seeking permission to engage another advocate. Now, the application, who is the SPA holder of the plaintiff, 6, 8, and 9, filed the application to recall the order dated 4/9/2025. This is on the day when the plaintiff's evidence was closed. On perusal of the order dated 4/9/2025, the advocate for the plaintiff has closed their side of evidence. Now, SPA holder of the plaintiff 6, 8, and 9 claiming that he has to lead further evidence, but remaining plaintiffs have not claimed reopening of the case. Even though the SPA holder has given the evidence on behalf of all the plaintiffs, but now application is filed only on behalf of the plaintiffs number 6, 8, and 9.
Counsel for the petitioner submitted an application is filed to reopen the case as the advocate has not represented and the evidence is closed. Without considering all that, the court has dismissed the application filed with the SPA holder by order impugned. It is submitted that the petitioner, as the earlier advocate is not representing, and as a petitioner, and the court has not, and you could not engage the advocate, you could not proceed with the matter, and the court has failed to consider the application that is filed with the petitioner. Considering the same, there shall be stay of all for the proceeding pursuant to the order dated, and summons memo shall be filed by 31st, or else a stay granted by this court stands.
Interim order means
Granted. Yes, next.
hand submission.
230 mentioned matter. Still list number 2, serial number 1. Chief Eshgiri Rao.
Kavita, this is the earlier matter, the temple matter. Yes.
Hand submission.
No, it is not possible. It will later, it will be uploaded by tomorrow.
Because it matters posted for judgment tomorrow, madam.
Yes. Yes, next. What is urgency in this matter?
Your Lordship may have it
No,
tomorrow.
no. Why it is mentioned? What is urgency?
This pertains to a matter which is remanded from the High Court with certain directions to conclude the evidence. There was a small amendment filed by the plaintiff, that has been rejected as a post-trial amendment, number one. And number two, because it's a remand, I may not be able to, this is the crux of the issue. The trial court would possibly.
When is the matter coming up?
The next date is 22.
22nd.
22nd.
Of
A final
this
hearing.
month. If you lodge-
Final hearing was, evidence is completed, matter has to be heard finally before the honorable trial court. 94 is
This
the.
order passed.
Plus, this order is passed on 2nd June 2026.
20.
What the petition is doing from 2nd June to,
Because we filed the petition immediately the next day, if your Lordship will see.
Came up before this, came up before my lords a couple of
Couple of
occasions.
times it has come up. It's there before the trial court tomorrow. And even if your Lordship could have it tomorrow, it's all right.
Yes.
I understand that.
list it in the first.
First. Can it be in the first list? Lordship?
First list.
I'm so great.
This 58 and 59 in the first list. All the admission matters in the first list and come from orders. Orders matters, give the dates. Interlocutory also give the dates. B group also. Let B group be in the list tomorrow.
List number 2, serial number 10. There is a final argument on posted for 4/8 for final argument.
4/8 is long.
Kindly have it next week, my lord, at least next month.
Interim order may be kindly extended.
Hello, my lordship.
My lord, item number 73, my lord.
This 230 matters.
My lord.
This matter tomorrow. In
First
the
list.
Other 2-3 matters are there. Other 3 matters.
First
That's
list.
why accordingly, you will just spread it in the entire week or on the next week. But make sure that only one day, one matter. is
Electricity matters do not.
And remaining matters as per.
Electricity matters.
Serial number 77,
my lord.
Hello, may I kindly-
Item number 73, my lord.
If your Lordship could at least have it, if not tomorrow, day after, because.
That's in which list?
72 items.
Which list?
First list.
First list matters will come.
Then it's.
Except interlocutory and orders
Because
matters.
I don't know why it has got posted in orders. It was there in the preliminary hearing on the other day.
No, you have filed an application. That's why it is in orders for amendment.
That amendment, not that
Application has not yet filed.
That
Amendment is not yet filed.
the amendment is there with us. We wanted to give it in the open court. I don't know why it has gone for orders. Your ladyship had heard us.
One matter, the complaint officer.
No, that matter, in the, let it be in the first list.
But serial number 93. But serial number 93. Written in the list.
230 में ले आओ पटकन डेट
वो पहले भी उठ गई थी मेंशन करते थक गए एक आदमी
Didn't hear.
सीरियल नंबर 71 सर हाँ पूछ लेंगे कोर्ट मास्टर से पूछ
ये पे क्या हुआ हाँ मिस्टर कोर्ट मास्टर मैं बाहर कर देगा ये तो इलेक्स प्लस
कोर्ट
कोर्ट
मास्टर
ऑफिसर मैडम
मिस्टर कोर्ट मास्टर नो इट्स ओके
हमारे हिसाब से रहेगा लिस्ट में ये
उसने कह दिया ना सारे लिस्ट के कल लिस्ट 1 विल बी हर्ट लिस्ट टुमारो
बोल रही थी ना
speaker was on what no mic was on this is mic here he's not but she's not in the mood to hear mic and camera both are on
चली गई ना
ये रहा ना mic कैसे कर देंगे तो ऑन होगा
कोर्ट मास्टर को पूछिए ना
मिस्टर कोर्ट मास्टर क्या पूछना
73 what happened 73 it will come tomorrow it will be in the list tomorrow
हेलो कोर्ट मास्टर सर आवाज ही नहीं आ रही
कितने का सुनेगा वो
कोर्ट मास्टर सर नहीं सुन रहा नहीं सुन रहा चला गया उठ के होगा ही नहीं सुनेगा कैसे
हम कर देना आएगा लिस्ट में रहेगा वो
होगा वैसे जब उन्होंने बोल दिया तो होगा ये ऐसा क्या कर दिया इसने हेलो कैंसिल प्लीज कंफर्म confirm
कोर्ट ऑफिसर मैडम
ಹಲೋ ದಿಲ್ಲಿ ಹೆಂಗೂ ಕೋರ್ಟಲ್ 19 ಅಲ್ಲಿ ಇದೀರಲ್ಲ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಡೇಟ್ ಕೊಟ್ರ ಎಂತ ಡೇಟ್ ಕೊಟ್ರು ಒಂಚೂರು ನೋಡಿ ಹೇಳ್ರಿ ಅವ್ರು ಎಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ yes what I'm trying to say is I didn't get to know what happened in serial number
Court officer, madam.
ಏನ್ ಗೊತ್ತಾ, ವೃಶ್ಚಿಕ ರಾಶಿಯವರಿಗೆ ಆಗಸ್ಟ್ ತಿಂಗಳಲ್ಲಿ ಏನು ಫಲ ಸಿಗ್ತಾ ಇದೆ, ಈ ತಿಂಗಳ ಪೂರ್ತಿಯಾಗಿ ನಿಮಗಿರ್ತಕ್ಕಂಥ ಲಾಭಗಳೇನು?
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಯಾವಾಗ ಬರುತ್ತೆ ಮೇಡಮ್?
Madam, instructions ಇದೆ ಅದ್ರ ಪ್ರಕಾರ we will assign the dates. You go through the case status at 6:30 or 7 o'clock. By that time we will finalize the dates.
ಮೇಡಮ್ ಎಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ಗನಾ?
ಹೌದು, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
ಓಕೆ ಮೇಡಮ್.
First list, madam, 230 matter, madam, 94.
230 matter ಗೆ ಡೇಟ್ ಅಸೈನ್ ಆಗುತ್ತೆ. That also you have to go through the case status, sir. ಅದು instructions ಇದೆ.
Interim order, please kindly be extended, madam.
Interim order till today existence ಅಲ್ಲಿ ಇದ್ರೆ interim order extend ಆಗುತ್ತೆ.
Thank you, madam.